Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Welcome to the stream. I forgot I have the headsets on, and I can't hear anything. So, good morning, Lois. Good morning, Paula. Hello, Toxic. Hi, Denise. Enjoy lurking today. Everyone. Hello, everyone in the chat. Hi, Toxic. Hi, honey. How are you? Um, Today, sorry that I'm slightly late, but I had to take a little bit of a nap before we started the day. I am in the comfy clothes because I'm in the comfy mood today. Um, I am tired, guys. It has been a long week already, and it's only Wednesday, but a happy Wednesday nonetheless. It's halfway through the week. I have one more day to go, and then I am off for the weekend, which is good because I want to slip in and just relax. But there's several things we need to talk about. A lot of things that we need to talk about today because, first of all, well, some of them are related to this case and some are not. So the one thing that is actually oh nice, that is awesome. I can't wait for a 3-day weekend, and I cannot wait because actually today I did something of a big girl thing. Let me take the headphones out so I can like hear myself clear. So today at work, oh, I you guys are being hit with the snowstorm. I hope they really can't affect this jury because they are sequestered, so it's kind of easy to bring them to the courtroom. So hopefully, though, everyone is safe, that you all have what you need, and that you are warm, safe inside, and to ride out this snowstorm that you all are going through. But talking about the big girl decision that me and Nightwa did, I have reduced my hours at work at the day job. Oh, hi, howdy, hello. Oh, I am very comfy, Gigi, and this is a comfy place. So yeah, I am TCA, Katya, true crime addict. Whatever you want to call it. Thank you very much for coming. If you are subscribed, that's awesome. Don't forget to hit the like button as well. It does help a lot, and you can find us easier next time as well. Uh, so Oh, what? 20 to 25 centimeters. That is crazy toxic. Oh, I would be buried in it. I would definitely not going anywhere. Oh my days. Oh, you're in Florida. Wow, that is awesome. I should not be this cold. I should not be complaining because I am in the UK and we don't get as cold as you guys do over there in US. So I should not complain about the cold, but here I am again today complaining about the cold, and me in my big comfy hoodie and just gonna watch trials with friends. Um, so yeah, so it's absolutely, yeah. Oh, freezing. Oh my days. Please, Paula, please, everybody, keep safe. It's crazy out there. I was like, to be fair, I know why I would love if we would snow that much here in the UK, like Toxic was saying, 2025, because definitely I would stay at home. I would not get out. And yeah, we would not work around the amount of freezing. Hello, Susan. Hello. Good morning, darling. How are you? Good morning, Susan. So it's wow, that is crazy. I am so kind of in a way glad that UK doesn't have that crazy of a weather, but I would love to be able to just stay at home and get paid for it too, because obviously my day job, I can't not do it from home. Sadly, I wish I can bake bread and pastries in my house, but not in the quantity that I do at work. So that would be crazy. I am so sorry, everybody. Give me 2 seconds. Nightbot is calling me. I need to take it just to make sure he's all right. Give me 1 second, y'all. Sorry about that, everyone. So Nightbot was just wanting to find out if, because again, guess where he is? Guess I will give you a chance. Good morning, Maria. Hi, buenos dias to you, hun. And I'll give you guys a guess of where Nightbot is. It's a place that I love. I didn't know how to say it. Well then, Paula, you won. Yeah, he's at Costco. We have a Costco problem. We like because he passes through on his way to work. So, yeah, he is at Costco. You all know me so much, so well that yeah, it's just picking up because like he went to work today. I've been to work. I'm working. It's gonna be a crazy day. So we are gonna need some food for tonight, so it's just grabbing a lasagna from Costco. Um, Obviously from all the places because it's the best place. So yeah, you do know me. To be fair, it's not that hard because I talk about Costco. Anything, any chance that I have, I'm talking about Costco. So it is not a Costco sponsorship, by the way. I'm just in love with it. I would, yeah, recommend Costco to anybody because even though people don't might need a bulk stuff, I would still recommend. Um, so so yeah, so it just was that I was, what was I talking about before I actually went? Oh, thank you for that, Toxic, about the Steven Stearns. I am gonna have to like catch up later when I'm not on stream, maybe before I sleep. But three things I wanted to talk before trial starts. I know, isn't it? It definitely. So I was watching a video, just like a fun video to entertain myself before I started the stream. And I was watching, right, most disturbing fandom problems, or like most disturbing internet fandoms. So it was talking about a guy, Richard Ramirez. I don't know if you guys know him, but he was just talking that he was an unaliver. I need to do some digging because now I'm interested in that story. Was an unaliver. I don't know. I don't remember really like the crime that he committed, but apparently it was a very bad one. And he was cute. Um, oh, Night Stalker. So so he like had like a crazy fandom and everything, and you went on trial and everything, and one of the juries, she literally was telling him that he was not guilty, saying that he was not guilty and everything. And she fell in love with him and end up marrying him, apparently. I don't know if it is ever true. I haven't had done any research. I was just watching a video about it. So Oh wow! So it's I didn't know you unlearned for to come talk about that. I'm joking, Denise. So yeah, so I was just talking about like hearing, and I got so intrigued, and I want to do some more research. Um, oh, definitely there was a lot of tea spilling in that trial, Maria. It was very very good. I was gonna say another word, but I don't think I can say that in here, but it made a boom explosion. So it was a very yeah, oh, lasagna from Costco. I cannot wait for tonight for the food. That's another subject we talk about a lot in this channel, is about food. Trials, food, Costco, and G. Ooh. Oh, that's so sweet, Denise. Oh, you need to talk to Cutie Pie, aka Nightbud, about that because he needs some recommendations for things. No, I'm joking. So another thing that I was watching before we get to do the like recap of the trial from the part that I had a chance to hear, I was listening to the cold. Is it Cold Gray? I'm always confusing those two. You know the dad and the son that got arrested in Georgia, about the pew pewing incident that happened last year, and I think I was watching the hearing, right, and he looked. Colin is the dad. Okay, Colin is the dad. So the hearing was for Colin or for. Hang on, I'm trying to get it back on my screen. Okay. Yeah, Colin. So the hearing was for that. Thank you very much, Toxic. So Colin, the dad, had a hearing yesterday, and he was on the stand. My days, he looks he looks completely different. It's not like even the same person. I'm sorry to say, and I don't want to be body shaming anybody or anything, but he has put some weight. So yes, check that out. There's the Colin and Gold Gray case on the Discord. The link was above as well, so check the Discord out. But oh my days, I was watching it and he has gotten so much weight. Again, I'm not body shaming anyone, but he's comfy in prison, in jail, because it's like. And I've heard that like jail food or prison food is not that good. So I don't know if it is like he has now proper meals or yeah, he has put on some weight because I'm not body shaming anybody or anything, but it's just I'm just mentioning that he looked a completely different person. He doesn't look the same. Colin Gray, sorry, I keep calling him the wrong name. It doesn't look the same Colin Gray that when he was on a thumbnail and was that went to jail. Sorry if you're hearing that noise. I don't know what's going on outside. Oh, there's a massive lorry truck just outside my house, and is making a right ruckus to everybody. Sorry, my phone is having an issue here. Let me. Yeah, it is. So yeah, so it's just absolutely madness that how people can change a lot, and it's not like been a high time because I think he had a hearing in December at some point, so it was just crazy. But now is the moment that you all been waiting for. Talking about the trial of yesterday. I mean, the I was listening to the first ME, the one before the explosion one, the last with I think was the last witness of the day or the before last, and she was very she was very good. She said what she had to say, and she did not say a word more or a word less. She went there, she did the job like she was required to, and got off and went home and carried on with her own life. Not a problem. Now the other lady that you guys saw the interview thing with Zio yesterday on lunch break, the medical examiner, and oh, that she was spicy. I mean, the defense, like the sadly the cross was very like normal and very standard for what it is. Like they asked questions, she wrote answers to her knowledge about findings and everything. But now the cross examination from the defense, that was something else. First of all, I don't understand half of the questions that he was asking because it was not relevant to the Emmy, and why would she even know about that? But I don't get it. That is fine. But then the last 10 minutes of the testimony was just like a backwards and forwards. And he was trying to make her admit that there was a small possibility that Evelyn was already unalived when she went to the bin. Uh, yeah, to the bin. So then, yeah, so that did not make sense at all. um what he was trying to say, but he was trying to create a bit of reasonable doubt. But and then by when she was threatened by the judge that if she wouldn't if she wouldn't reply yes or no to the question, she was gonna be held in contempt court. Which then she said yes, but she could have been alive somewhere else, and I love that. I like because I only watched that part this morning. I was a little bit late to the game, but that was a massive bombshell. I think that was the best part of the whole day. I think it was literally the best part of the whole day. Was even though we had to wait for the whole day to hear that, it was worth it. Definitely worth it. It was amazing. And in terms of his like theory, like Toxic is saying, I don't agree at all. It's like because the way that like a 15-month-old it's capable of um like either poke someone or understand the concept that if someone is on top of her, like she needs to try to find a way out. So I just don't understand that. Yeah, exactly, and that still shows premeditation though, as well. That still shows that Megan had the opportunity, right? Even though like someone rolled on her and everything, but she was still breathing when sadly she got put in the bin. So Megan could have called for help, could have called 911. And it's like, what are you going to say? Megan is going to say, oh, I panic and I did not know what to do. Well, when you panic and you don't know what to do, you call for help. You call someone. You could have called your dad. You could have called, well, probably not mom, because mom is something else. Uh, Mom probably, we could have called your grandma. You could have called your best friends that you know that they were there, and they could have probably helped you or give you directions to help you. So I don't think no one, and I agree with you, Toxic, I don't think she did with anybody else. I think Megan was by herself, and then she created this whole story about Hunter, about Ethan, about mom, about whoever was, and then just yeah. Oh yeah. I was like that part, GG, it was absolutely gut wrenching. I'm so glad that we did not um get to see that. And like even on certain things, certain exhibits that they were showing, I have decided to like not show on stream, and I have a really cute overlay that I can show. I'm showing the overlay now. So that's just the overlay that I put for when sadly there's a bit too much strong things happening on stream. um but I completely agree as well with you, Toxic. I am eagerly waiting for the defense case, because the defense case is going to be actually showing us the excuse that Megan is giving. And actually, I am thinking, guys, that um, we might get to listen from the defense very soon. You know, I think very, very soon we might, because I'm not thinking of anybody else that the state can bring. They've already had the lead detective, they had the key witnesses, they had all the detectives that were involved in the case. They had both of medical examiners. They had a bunch of experts to about cell phone data and messages and pictures and everything. They had the friends, they had the family. So I I don't think so. I was like the evidence is too strong. But then again, after Colin Griffith case, I'm not saying anything. I'll wait until I hear both parts to actually give my full verdict about it. It's not like I want her to be guilty, but we need justice for Evelyn. So definitely justice for her. And I I want that this unaliving is not for just nothing. And I am glad it was, because actually in Tennessee there's now a Evelyn's law that parents are required to report a missing kid in 24 hours, and if they don't, they do face legal challenges. So sadly something had to come out of it, but it is good to see that things are changing, and they lawmakers are actually looking into that. So I don't know, what do you guys think? Do you think that the state is gonna rest today, or do you think that they still have some more up on their sleeve? And it's like, I don't know, but I think, and I am thinking that Megan's grandma, right, that will be Angela's mom, she's gonna be a defense witness. I don't know why, but because she was with Megan during the interview, and I think she was manipulated to a point that she might be called as a Megan's witness type thing. I don't know. I'm just thinking. Oh yeah, like the evidence, it's solid rock. I'm sorry to say, but I think in my opinion is solid rock against Megan. So like the something changing towards that fact, I don't know. um Hang on, sorry, just doing something because my phone is doing something weird. um so it's just interesting seeing. I want to see what defense the defense puts on. So not so I don't forget, guys, on Friday again, I might be a little bit late, but I'll keep you posted in a way. But I am not 100% sure if I am or not, because it depends on how long the guys take doing the installation on at my house, because I am changing the internet, hopefully for a better one, because this one is already making my head boil. I barely have anything connected to the internet, right, when I'm on stream. So not my phone or my tablet is connected to the internet, just my laptop, so I can get the maximum bandwidth. But it's still struggling. My internet is still struggling, and it's still lagging, and apologize for that. So I cannot wait for Friday um for that to actually kick in. And yeah, and the thing is, I have the ethernet as well connected, so I don't understand why it can be so lagging. Is I know it's the quality of it, so I can't wait for uh oh yeah, and that's the one we get toxic as well, the Kirkland brand. The one that's already made, that you just pop in the oven and you cook it, and that's it. That's the one we doing. So yeah, I was did I told you that I decided to drop a day out of my day job, the bakery job. So from the 10th, because I have to give them some notice. So from the 10th of March, I am only going to be working 3 days at the bakery now. And then I'm going to carry on doing this, because I want to focus maybe a little bit more on this. Um, oh, um, I'm just a day. It's just a day. I'm working right now 4 days in the bakery, and I am dropping a day. So I'm gonna be working 3 days, because I've been exhausted, and I'm dropping a shift. I've been absolutely exhausted. I've been doing about 70 hours of work a week. So because between with YouTube and everything, and I want to focus a bit more on that. So me and Nightbot, we've been talking, and since he's back up at work and his schedule is completely chock block, so I need to I have the possibility of dropping a day. And even if he wasn't, what I earn with 3 days, it's more than enough to cover bills and everything, so I can focus a little bit on this. And Gigi, we're talking about lasagna because Nightbot, my other half, he helps out in the channel as well. You're gonna get to meet him and see him on stream as well. So he is at Costco right now to grab some dinner for tonight, because with between me working, being doing YouTube, and him being a bit tired from his own work, we're not gonna be in the mood to cook. We know that, so he's just grabbing something to bring home now that he's finished work, and he should be here in about like an hour or so. We should be in chat, and then yeah, because he also is a mod and he helps out like the channel quite a bit. um so you're gonna get to know him, and he's nightbot for us. I've said his real name on here, but he doesn't want me to. So but yeah, so Fate is still not up, because again, I think they're only gonna come back close to 9 a.m., because that's what they've been doing. But we only have about 5 minutes. Yeah, I know. It's definitely Costco equals at $200. Like, absolutely agree. Every single time that we go there, we don't spend less than like 100 to 150. It's just, I don't know why Costco has this thing that they put things in strategic places, and then it just falls into your cart somehow, and then you go to the checkout and you have to pay for it. So, and it's not you that put things in the cart, they just fall into the cart, isn't it? So and I we are obsessed with Costco. So I think if we could live closer to Costco, we would. We literally have a small room that is just Costco stuff, which is, I don't know if it is a good thing or not. So like maybe one day we need to tidy it up and put, because the little room is like a cupboard. It doesn't has a light bulb, so every time that we go there we have to use our phone torches, or we have like a beanie that has a torch, we have to use that. If we one day fix it, we'll do like a mini a mini Costco tour of our cupboard that we call the Costco cupboard. Because it's like we prefer buying things in bulk than having to go to the supermarket every day or every week. Even though I do work in one, I still don't want to finish work and having to do shopping. I just want to come home because I had enough. And so yeah, I don't want to be shopping after work. I just want to come home. But yeah, so that's why we are Costco upset. Yeah, maniacs. Also, did anyone catch how many objections yesterday by any chance? Um, oh yeah, it's definitely cost effective for a lot of things, especially water. At least here over in the UK, right? We get the 40 pack of Costco bottles of the water, and it costs us 3.49 for it's all right. It's okay. Yeah, oh yeah, especially for large families, that is absolutely. But even though it's just me and Nightbot, we are considered large families because we eat a lot and we have a food problem. So we are a large family too. That's all right, Lois. It's absolutely no problem. It's fine. It doesn't need to be 100% accurate. We're just doing more for the entertainment of it than actually like keeping an actual record of things. It's fine. um yeah, so it's okay. We will stay with the count that we have. um oh wow. Oh yeah, exactly. Yeah. That like it, and it's still very worth it. Like for example, we buy like a pack of mess, like 500 grams over here in the oh, nice. Yeah, I don't blame you. We DoorDash do a lot, too much, and we go to Costco. We just are lazy to cook. Like it's not lazy. It's just the fact that it's quicker and easier to DoorDash and to buy already made and actually spend the time cooking. I love a very hot cooked meal. Don't get me wrong. I love it and I would love to have more time to do it. But it's just it's just the fact there's no time, you know? Ooh. Yeah, it's like I can understand. It's like I've heard a lot about Sam's. I think Sam's Clubs is like the same thing as, I don't want to say the same thing. They have different things than Costco. They have the app that you can use throughout the shop to scan. Yes, I am not in the US, but I still know that Sam's Clubs, you have the app that you can scan and go, and Costco, at least here in the UK, you don't have it. I am obsessed with, I watch a lot of American things. But literally, my whole YouTube recommendations is mostly American. I have one or two UK stuff, but that's mainly like UK courts and stuff like that. Um, but yeah, and we go also to Costco for gas because it's way cheaper than going to a normal pump. Like for example, normally we either take a car or the van to Costco to fill it up each time we go, because it's a lot cheaper than yeah, then that's, sorry, just notifications keep distract me. They pop up on my screen, and then I'm like, I want to know if people need me or not. Or not. It's like uh, it's just a convenience thing. It's easier to get delivered than actually sometimes cook it, and sometimes, I'm sorry to say, it's cheaper as well, because you don't have the cost of like the electric and everything of cooking and the hob and gas or anything to do it. It's cheaper sometimes to order it in and not having to cook. But it's also now more of like a time thing, because time is sometimes non-existent and very reduced, so yeah, go for some for chicken. Make sure that you bring for everybody. We do have a rule that you are even having a coffee or having something, you're gonna have to have for everybody. So, ooh, so one feed is up, but the other one is not. So I'm gonna put this one up, and then because and then swap, because sometimes the audio from the other one, it's better. So, oh, that's why my internet is so slow, because I have 500,000 tabs open. No wonder. But where are they? Oh my days, can I? Mm, I need to. No wonder my computer is slow and the internet is struggling. I have 500,000 tabs open. Dude, I need to figure out where they're gone. Okay, hang on. I need to do a control of a mass right now. Oh, I saw a judge. Oh, a judge. Oh, I saw a hat. Um, what's I? Oh, like, the mom. The mom is on probation. We know that from because she's tried to um smuggle drugs into prison, so into jail. So she's on probation for that. Um, I don't think Megan is gonna testify. I don't think that everyone. Give me just a second. 1 second now. Uh, I'm so sorry. Um, I just got the news that a dear friend from the law tube community has passed away, and give me a second. Sorry. For those who know who we here and know Sharon McDonald from the RA community, I have some bad news. She sadly passed away yesterday. Um, I've noticed that she was absent and she hasn't been present on posting the Facebook and the shout outs for the birthday shout outs and the stuff. Um, and yeah, a friend just texted me. Our friend Denise just texted me because we always hear the Yump Hell from the channel, and the news was there. And good morning, Pink Bursts. I'm so sorry. Um, uh, this is a horrible news. She's a very dear friend, if like if in a law tube community, and it's just gut wrenching. Um, to hear this news and to yeah, so it's a hard day yet again. Please hug everyone that you love. Make sure that they know they are loved. And yeah, she was absolutely gorgeous person. She felt like from day one that I was in that community, she felt me part of it. That oh, sorry, it just makes things in perspective. The little things, the little discussions and everything, that's the little fights that you have with those you love just makes everything insignificant. And just appreciate them each and every day and hug them if you can. Send them a message, a video message, a text. Life is cruel. I don't have words. Life is absolutely cruel and gut wrenching, unfair. Uh, I, I don't know what to say. For once, I'm speechless, and not for the best of reasons that I am. But it's just we literally last Friday just lost a dear friend as well in the community, and yesterday another one has just been. It is absolutely heartbreaking. Um, Oh yeah, more tears. That is for sure, Lois. That is absolutely sure. And it just makes things real. And it's just like it's our dear friends and not seeing that person there every day. It's just hard, and it's life. It's absolutely um mean and absolutely unfair. And I just wish that there was something we could do, something we could say. Um, but sadly, there isn't. Sadly, we just life. It's like this. I'm sorry if I'm not my usual self, but out of respect and everything, I can't be a beat. And she is a dear person that I'm will miss. So, um, yeah. Oh, I am so sorry, Gigi. That is absolutely so sad. Yeah, same, Susan. I was like, I was even thinking to myself because normally I get the notification on Facebook, for the birthday shout out that they do, that RA does, and I haven't seen her doing it for a few days, and I was like, oh, maybe she's taking a few days off. I was actually gonna reach out one of the mods just to check in, and now I just got a notification and that RA went live, and I went to because it's Wednesday hump day, y'all, and I was just like, he was just talking about it, and then our friend Denise, texted me as well, and it's just horrible. And uh, please, hug those you love, those who you were close to. Send a message, send a video chat, a video recording of yourself, maybe just talking to them, because these moments are precious and don't ever take for granted. I know sometimes I even Nightbot take sometimes gets to my last nerve, but then I get to think it's like I don't want to imagine my life without him. And life is cruel and life, I'm sorry, sucks so much. Losing a loved one, losing a colleague, losing a friend, it's never easy because I don't think life was intended to those purposes of us dying. But sadly, something that it does happen, and something that we have to deal with in and day out. And some people have even lines of work they have to deal with death every day. I know I did. I work in a care home, and I had to deal with dying, death a lot, and it was sadly a natural thing. And um, you know, it is. Paula, please take care, darling. I'm thinking of you. Um, sorry, I'm just trying to be respectful and mindful. I am excited for the day in court to actually see justice for this little baby as well. But I also sad that we lost a dear friend. Um, that she was so very welcoming. She always had a nice thing to say in chat to about everyone, about anything, and it's just absolutely awful. And oh, it is heartbreaking. It is so very sad when we lose a loved one. And I need to check on people. I need to make sure that they are okay and that they are being taken care of. And as soon as the courtroom starts, I'm gonna be paying attention to chat. We can still chat about what's going on or whatever you guys want to talk, but I do need to send a couple messages to check in on people just to make sure that they are taking care of themselves right now. So it's been an absolutely gut wrenching of a week telling you about that. Um, I'm hoping that this week gets better, gets a little bit brighter, and just my days. It's just horrible. It's just awful, and yeah, there are no words. I'm just hoping that they come back in soon because I do need the court to start, please. It should have already been starting about 10 minutes ago. And yeah, I think out of respect, maybe we can just stay a little bit silent for a moment until court starts. At least maybe that's what we can do to respect a little bit and maybe remember Sharon uh, uh McDonald a little bit. Even though we only met her online, I only met her online. Uh, on the community, on the LawTube community. Um, yeah, maybe just a bit of a moment for her. I'm sorry, I don't know what else to say. I'm just lost for words. And it is very rare for me to be lost for words. Um, it's not usual for me to be with no words and not knowing what to say. Um, definitely, it is not. I always having something. I always have something to say. Always have a comment and everything. Oh yeah, she was absolutely lovely. She was very very welcoming, and whoever got the chance to cross paths with her, wherever she was, absolutely a joy and a grateful thing. And we try to be supportive as much as we can, because we are covering very heavy and very hard subjects, and we never intended to make any fun or making a joke out of it, but we like to make things a little bit lighter, a little bit easier to bear, because the subjects that we cover day in and day out here are not easy, and they are hard to take it, especially if we got into a similar situations. um we try to make that just a little bit better to endure and to take it, and to process. um so we try to laugh about my accents, my all my days times, how many times I say on my days in the stream, how many times I miss a count and everything. So same, absolutely same, Gigi. And but it's a the good humor, but respectful, and because you have to be respectful in at the same time. And I never want to you the guys to think that I take this lightly. I don't. I take very respectful for the victim, for the families, and everything that is happening. But I also want to make it easier to understand and easier to take it in, because we cover very hard subjects. This case, it is one of them, is one of those cases that are very hard, very, very sensitive for so many people, including myself. I talk about it very openly because I it does bring me pain, but I also like to talk about it. I have lost my son, so I do. It's completely different circumstances, so the pain is completely different, but it's something that I can relate in a way about the loss. Um, so it's just something that I'm very open about, and I like to cover this cases just to shed a light on this whole situation. And um yeah, so it's just a bit more significant. I still need to try to close all the 5 million tabs that I have open, um be, because apparently I have 500 million tabs, and that's, I think, what's making the the internet being a little bit laggy. um okay, I think I found it. There we go. Okay, I think I found what I was looking for to absolutely close it, and hopefully that will make the the internet a bit better. I need to save this. Um, we're still seeing the judge there. I'm just saving a video. Bear with me. Hopefully, this will make the stability of the internet a little bit better. Um, I do need to do something else. Um, Sorry, just replying to messages, people just checking in, and yeah, making sure that everything is okay and people are taking care of their mental health. It's something that I've been saying all throughout this trial as well. Is if you need a bit of a break away from this case, it's absolutely fine. Take care of your mental health. Take care of your health. Um, your physical, mental, emotional health, because it's a very hard case again, and it can take a toll on people. And just be sure to keep an eye out for yourself as well. You keep an eye out for other people's and for yourself too. um so yeah, I don't know, court is delayed for almost about 20 minutes. Maybe they are um they maybe just are sorting it out. A jury might be late, or something has happened that we're not. Is there no sound? Is it? No. Okay, I need to put the headphones on so I can make sure. Good morning, Pickles. Welcome in. Good morning. I hope you're all right and you have recovered from yesterday's shenanigans in court that has happened. Um, I am a bit monotone today because sadly we lost a friend yesterday. So and we got the news today. Um, so yeah, so we are trying to boost the mood again but still being respectful, and also yeah, we just it's just gonna be one of those days again. But good morning, welcome in, it's good to see you. um Today's Wednesday, so yeah. Oh, it's okay. I was just, Lois, you're gonna make me cry, leave if even more than I am already dearly. Thank you. And Pink Burst, finally, we got hit with a membership. Thank you, Lois. I am gonna cry. I'm already a bit sensitive today, as it is, and you're gonna make yeah, you got it. I am okay. We lost a dear friend, and it is a very heavy loss because it was an amazing, outstanding friend in the true crime community. Um, and I am a little bit sad. I am waiting um for the court to start so I can go off and cry a little bit out of camera because I don't want to cry again on camera. Um, Thank you. Appreciate, we all appreciate that, Pickles. So I'm trying not to cry right now. Even though Lois is trying, because I appreciate Lois the support always, and the amazing support that you have given to the channel and everyone, just by the fact being here every day with me. And um thank you, with everyone, like pressing the like button, subscribing to the channel, even sharing it. It means a world to me, and I could not be still doing this without you, and will never be able to do this without every single one of you. So I want to appreciate that, and I never want to take that for granted, definitely. um so it's just, it's just life isn't fair, life isn't just, life it's hard. um it is absolutely crazy. And I like something that I've been saying a lot this morning is just make sure you check in on your loved ones, on your close friends, on your family, on your neighbors, whoever you have close to you. Just check on in. Send a message, send a quick call, a video recording. I do that with my mom because it's a way that I have a little keepsake for for the future. Um I we send video recordings on WhatsApp, video messages, and I tend to always keep them just as a keepsake for the future, because you never know. Ooh, Judge is back on his rope, and he's looking serious, looking to see if, um, yeah, something is happening. And again, like I said, as soon as the court starts and I make sure that the video is on, I just need a couple minutes to cry and to check in on other people as well, to make sure that they are okay, and just that. But we are excited for another day in court, even though I sound a bit monotone right now. um, the we I am expecting, actually, to be fair, that the state rests today after the craziness of yesterday, of the medical examiner. I am expecting the state to rest because I don't know who else they could have. Oh, is it this? Yeah, it looks like the judge is coming back to stay. So yeah, so I don't know who else the state has to come. And here comes Megan, to good morning, Willow. No, you haven't missed anything much more, honey. We're just still waiting for the court to start. I think they were waiting for you to come in and to arrive and take your seat. um Yeah, I think they were definitely waiting on you. So no, they haven't started, Maria. No, we're still waiting, and yeah, we're still waiting. So yeah, I know it is very nice of them, isn't it? So very good. Very nice of them for wait for you, Willow. They knew that they needed you, so you know, Maria, we
Oh
always
no, you
have
told me
to check
3 weeks
in
ago.
on everyone
Just went
because
ahead and typed it in.
if we don't, who's gonna do it?
I've changed it on the original. So yesterday, the state indicated they may have another witness or at least exhibits. And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes,
So I thought we'd take that up before I brought the jury in and had to send it back out.
yes, Judge. The state intends to introduce a certified copy of the order from the Circuit Court in Bristol, Virginia, which ordered Hunter Wood involuntarily committed to the mental hospital over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a letter dated January 10th, 2025, which is from the Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the Circuit Court of Bristol, Virginia.
We have no objection, Judge.
Okay. So what I intend to do, and then after that, do you think you'll have any proof?
No, Your Honor.
So what I'll do is I'll bring the jury in, admit that, and the next number of exhibit, then you can rest in front of the jury. And then I'll have to send them back out so we can take up some matters out of the presence. All right, we can bring jury in if we're ready.
Everyone stand, please. You may be seated. Thank you.
All right, General, call your name. Oh, wait, before we do that. Ladies and gentlemen, yesterday when we left, I gave you certain admonitions. Do any of the jurors have anything to report with regard to those admonitions? If you do, raise your hand. Let the record reflect none of the jurors raising their hand. All right, General.
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. We would offer that as the next exhibit in this case. 261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit 261. All right, call your next.
Judge, the state would rest.
All right, ladies and gentlemen, I know you've only been out here for 2.5 minutes, but I'm going to send you with the officer.
Everyone stand, please. You may be seated. Thank you.
Mr. Scott, you have a motion?
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts. Just briefly, I'll go through them. As it relates to the first three homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various, although she stated that she believed it was a fixie issue, later under cross-examination admitted it could have been a SIDS death. She admitted that it could have been a heart issue, or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count one in premeditation, there is no evidence whatsoever in this case of premeditation. So those are the three murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect its health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion. False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those. But I will leave those for now, but I do move for a judgment of acquittal without further argument. And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
I'm a brief, Judge. Of course, the court reviews this motion in the viewing the evidence in the light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket, and then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation is at least shown through the physical evidence in this case. As far as the remaining counts showing the cause of death, both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
All right. Of course, as Mr. Scott and the general has stated, in viewing the evidence in light of the Rule 29 motion for judgment of acquittal, the court's required to view the evidence in the light most positive to the state. And looking at these charges and the proof through that lens, with regard to count one, the premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, you couple that with the voluminous amount of evidence where the defendant was giving different stories as to where the child was, as to how the child was doing. When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that day, there was story after story about where the child was. The defendant appeared to have moved on to other things. And I think when you take all that evidence, and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But course of the opinion, the state, when looking at that proof, and a lot most favorable to the state, that they have put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think that taken in a lot most favorable to the state, the fact that that child was wrapped and placed in the garbage can, I think the jury can look at that. And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy, dirty toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. I think that taking a lot most favorable to the state, that those two counts would survive the Rule 29 motion. And I'm going to deny the motion with regard to those two counts as well. With regard to the tampering with evidence and the false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in a light most favorable to the state, I think those are issues the jury can determine and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right, in that case, we have to go through the Lowen versus State questioning, and I'm gonna hand this down and let you do that.
Judge, for the purposes of the record, would you like her to come to the,
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Scott.
Megan, I want to ask you some questions about my representation of you and explain to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes,
Okay. And part of that, I've talked to you about, you have the right to testify, is that right?
yes,
And if the jury can't hold it against you if you don't testify, you understand that?
yes,
Do you understand you have a right not to testify?
yes,
And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
yes,
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
yes, I have.
Do you want to testify?
No,
I think I covered it, Judge. Approach.
Yeah. All right. Will you have other proof?
No.
No. I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I gotta send the jury out so we can finalize the charge and give the parties time, because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them nod off if they're reading with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we'll bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I will finalize it and send it out. That's the
Yes, sir.
process going forward. And during this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for closing argument. Okay? So we need to bring the jury. And I need to give the curative instruction.
Yes, sir. I was going to ask about that. I forgot.
I did too.
So while the jury
Everyone
gets
stand, please.
in and Bear yells at my ear, so the defense is not going to put in a case. Is that what I understand? Is that what you guys understood? Because we went to the quality of Megan testifying or not testifying, which she decided not to, and we are talking about closing. Here we go. I'll turn on the heat.
Okay, ladies and gentlemen, one thing I omitted to do a moment ago. Yesterday, during Dr. Malushnik Did I say that right?
Yes, sir.
At the very end of her testimony, she answered the question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? Yes, sir. I'm going to instruct you that that last phrase, you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Everybody puts that murder in some other way out of their mind and not consider. If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Been at rest.
All right. Ladies and gentlemen, where we are now is the proof is closed, but it is not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow along, and you'll have that for your reference while you deliver. Okay. This will also, and what'll happen is it'll probably take 45 minutes to an hour. I'll get all the notebooks made. We'll give the lawyers time to organize their thoughts for closing. When we come back, I will hand out the notebooks and I will read you the charge, which will be painful, and I apologize for that, but it's just, that's the way it is. And then we'll go straight into argument. Okay? So I apologize for the length of the break, but just bear with me. It's necessary. Okay? You'll go with the officer.
Everyone stand, please. You may be seated, thank you.
All right, we'll be in recess. We'll probably take 45 minutes.
Court stands in recess.
So, wow, we are not going to be privy to be involved in this quality of the jury's instructions. So, that is going to be fun. I mean, yeah, oh, sorry, Paula. I was gonna text you, but I am absolutely swamped over here on checking in everyone. Hi, good morning, K1. So I can give you a rundown. State arrested, defense rested. Megan decided not to testify. Defense decided not to put any case forward, and then the judge had to say to the jury that to disregard the bombshell from yesterday. We had JOA motions that got denied. I am sorry, but you missed quite a bit. As a lot happened. Hello, Paula. I am so sorry. I was gonna text you, but swamping with messages and checking in on people, and Nightbot got home, and so it's just a lot of moving parts going on at the moment. So yeah, welcome in everybody. Thank you so much for coming today. I mean, I don't know what to do because we can do one of the two things. And I am so sorry, I am not turning on the camera at the moment because I am still look like an ugly crier, and it's still a bit heavy, the whole thing. What we could do is, while we are waiting, uh so what we could do while we're waiting is listening to some parole hearings, and then I have the feed yet again on my phone, and then I can keep checking in to see if any movement and when they go, but it might be a while, so we can catch up on some parole hearings, or I can see if No, she's not live yet because one of my favorite judges is not live yet. I absolutely love her. But I don't want to do like court hopping because I just want to like to stay on one fit. But yeah, she's still not live. Um okay. All right, Paula. This might be some like hit and miss information that might be a little bit hard about the JOA, but you can always skip that part anyway because I have already spoiled it to you. So sorry about that. Um so I'm trying to see. Oh, there's the other judge. I need to find the the thing. Hang on, where is the other judge? Because I really like. Here you go, found it. See, bookmarks is amazing. Hey, toxic. So, just to reiterate the comment there from Willow, state rested, defense rested, motions for acquitted, denial for all charges, and then the judge had to withdraw the statement that the medical examiner did yesterday. Um, so it was absolutely chaos of a morning, and yeah, I'll see you very soon. Yeah, thank you very much, Maria, for that. I really appreciate that. The care that you're showing. Thank you very much, and thank you for being part of our community. So right now, toxic, we are just they are doing the rest of the jury instructions and everything, and then when we it's been a chaos of a morning. I don't know even where to start, where to look, or what to do, or what to say. So it's just toxic, absolutely fine, girl. I'm not even with the camera on at the moment. I don't think I can muster the courage to do so because I am still, yeah. Good morning, buenos dias. Good morning. Welcome in, darling. It's good to see you today. Um, we are just trying to figure out what we're gonna do because court is in recess at the moment because they are working on jury instructions. So my idea is we can do the pardon hearings from no revocation hearings from yesterday that was there, and then when one of my favorite, I have two favorite judges that comes back, either Judge Fleischer or Judge Boyd comes on, we'll put one of them on if that one is finished and if they're not back yet. I do have another feed of the I'm showing to the camera like I have the camera on. I have the feed of the court on my phone in case that they come back on. Will come back. So we'll check that out. We'll watch some parole hearings and then we'll go from there. And then we'll be in chat to talk to everybody. And then I just need to catch up on a couple bits behind the scenes, guys. I hope you understand. Thank you. I will remove the counter too, so it's not there in front of anything.
Time is 9 o'clock, and we're here at headquarters in Baton Rouge. And my colleagues here are Pete Freeman and Danny Barra. The staff at headquarters is to my left, and would y'all introduce yourselves?
Carla Williams.
Okay, thank you very much. Today, our first remote location is going to be in Jefferson, and we've got a fellow named Danny Odo. Darren Odo, if I'm saying that right. Is that right, Mr. Odo?
Yes, sir.
Okay. And we're in Jefferson, and we'll get with you in just a minute, Danny. But would the staff there recognize themselves, please?
Yes, sir. This is Deputy Landry with the Jefferson Parish Sheriff's Office.
Okay. All right. Okay, Mr. Odo, you're here for a revocation hearing. And do you have a piece of paper in front of you that talks about the revocation here? You got your signature and things and all that?
Yes, sir, I do.
So you understand what's going on today, and you understand you're not eligible for a lawyer, but you could hire a lawyer if you wanted one.
Yes,
Is that
sir.
right? Okay, you understand all that.
Yes, sir.
Do you have a seat there? Do you have a chair?
No, we don't have a chair.
Okay, you can stand up. Just seems strange. You standing up there. Okay, Mr. Odo, Danny Barra to my left has been assigned your case, and he's gonna go over some rule violations you're accused of and wants to hear your response. Then we'll ask some questions and see what you got to say. But that's basically how we're gonna run this hearing today. So, Mr. Barra, would you go ahead and get us started?
All right, we're gonna start out with going through the violations that they already went through at the preliminary hearing, and just a review of that, which was number 2. You failed to submit to monthly reports and monthly scheduled office appointments with your parole officer. You failed to report to your office on his February 27, 24 visit. Back then, you pled guilty. How do you plead today?
I pled guilty, sir.
All right. Number 3, you failed to report to the new address to your probation officer. Therefore, your home visits could not be made. Your whereabouts were unknown. You also failed to get written permission from your parole officer prior to leaving Louisiana and absconded on or about February 7th, 2024. How do you plead to that?
I plead guilty, sir.
Number 4, on September 26, 2024, you were arrested for domestic violence misdemeanor under MS number 024-014261 by the Pearl River County Sheriff's Office. How do you plead that one?
I plead guilty, sir, but with a statement.
Okay. Then go ahead and give us your statement.
The way that they actually wording it is not actually correct exactly how it happened. I got my wife. I don't know if she's supposed to be coming with me in front of the board to explain the situation and for her half of it. But they saying that I popped my wife in the head, sir. And I've been with my wife my whole life. We grew up as children. I've never put my hands on her. Matter of fact, December 5th, she just had brain surgery. So it wasn't even like that. It was over money, situation of money, because I was working for a guy that wasn't paying me my money. She thought I was using the money for drugs, and nationality, the guy was not paying me my money. And she can actually vouch for that now, because now that I'm in jail, she's contacted him and he's telling her, well, he owes me more money than I owe him. So.
Well, that's a little contrary to what the police report says. Like you said, the police report said that you're arrested for hitting Tanya Jean Luke in the back of the head, and that you took her wallet and tried to leave, and she tried to stop you, and you grabbed her by the arm, leaving marks visible to police, and that you also had marks visible on your neck where she had hit you. It kind of looked like a little bit more than a oral.
Yes, sir, but they saying that I hit her in the back of the head, but I did not hit her in the head. You know what I'm saying? At the time, sir, she actually, I know for a fact that she was in the process of getting brain surgery from, she had a tumor in her brain. She just had brain surgery on December 5th.
So she hit you, but you didn't hit her.
We wasn't actually beating each other the way they actually wording it. You know, it's like I beat her. It wasn't even like that. You know, it wasn't. And she's supposed to come to the board and testify that it didn't happen like that.
Where is she? We don't have her on Zoom or anything like that trying to get in.
You know, she's supposed to log in since 7 o'clock this morning. She was supposed to be here with me.
Okay. Well, we'll just have to agree to disagree with the police report on this one. Number 9, home visits were not permitted since you had absconded supervision on February the 7th. How do you plead to that
I
one?
plead guilty, sir.
And you failed to pay supervision fees and were in arrears of $745. You also failed to pay the processing fee, and your last payment was in January of 2024.
Yes, sir. I plead guilty.
And you failed to attend AA and NA meetings 3 times a week or obtain a mental health evaluation.
Actually, that one, sir, I actually plead not guilty to. When I came home from prison, I went to JPSHA. I was seeing a psychiatrist there. Also, when I left prison and with the parole board sending me to the Steve Hall program, I was actually left there and taking the Vivitrol shot at Jefferson Parish, JPSHA, taking the Vivitrol shot, plus seeing my psychiatrist. And the rules of me taking the Vivitrol shot, I had to go to AA meetings, and I was going there. So I can prove that I was doing that.
But you didn't. But you didn't give them any paperwork, or you didn't give them anything.
I don't have any paperwork to prove that, but y'all could get it from Jefferson Parish, JPSHA. I don't have no way to do it. I have no one here. My wife lives in Mississippi, and I have no family here in Louisiana.
Did you actually attend AA and NA 3 times a week?
I was going through it, yes, sir. I had to do that to take the Vivitrol shot. I have to go to meetings to be able to, for Jefferson Parish, the human resources, for them to actually pay for it. I had to go to meetings, so I was forced to take it to be able to take the shot. Yes, sir.
All right. Why did you quit reporting to the probation officer in February of 2024?
What happened, sir? I was living, when I came home, me and my wife was together. We were living together. My mother-in-law got sick. She had to leave to go take care of her mother-in-law. My mother-in-law lived in Mississippi, so I wound up moving with my mother. My mother didn't want me there anymore, so basically I was living on the streets. So I didn't have nowhere to go. I couldn't go to Mississippi at the time because me and my mother-in-law didn't get along. And my wife was there taking care of her mom because she was in hospice in the process of dying. And I was living on the streets, sir.
The probation officer can help you with that. You didn't bother telling them anything about it.
I was scared, didn't know. I was on the street. I didn't know what to do.
Does anybody have any questions?
No. No question. Is,
I have no question.
okay, is the panel prepared to vote?
Yeah.
Okay, yes, sir, Mr. Morrow.
Well, Mr. Odu, based on the violations that you pled guilty to and the contradiction in the police report, I find that there's plenty cause to revoke your supervision. You're a 4th felony offender who ought to know, that reporting is important. And you didn't report to the probation officer. You made your whereabouts unknown. So for those reasons, I have no choice but to vote to revoke.
Mr. Freeman?
I find that he violated condition number 2, 3, and 9, and number 4, as Mr. Barra stated, there's a lot of contradiction there. So my vote also is to revoke.
And my vote is concurs with my partners there. So looks like your parole is revoked as of today, and we wish you good luck in the future. And that concludes all our business in full regard. Jefferson. And we're signing off from there.
All right, thank you.
ready to go. Okay, the Committee on Parole now is going to go to, let's see, we're going to Beauregard Parish, I believe. And, is Beauregard Parish there? Okay, Mr. Leonard Scott.
Sure.
Okay, Mr. Leonard Scott is, do you have any staff in the room with you?
Yes, sir.
Okay, would you introduce yourself, please?
I'm Deputy Scott.
Okay, you're Deputy Scott, and we're here with Leonard.
No relation.
Yeah, no relation.
Okay, all right, time is 9:19, by the way, when we'll start this here. Mr. Scott, we've already introduced my cohorts next to me. We're gonna be hearing your case. Can you hear me okay?
Yeah.
Okay.
Yeah.
We're gonna be hearing your case, now, and there's certain rules that you signed a piece of paper, said you would abide by when you got paroled out.
I didn't
And,
find it. I don't remember that.
Okay, do you have something in front of you right now with your name on it?
No.
Okay, we're gonna put something up. Do you recognize that form there?
Yeah.
What is that? Yes in the affirmative? You do recognize that?
Yes, sir.
And that's what we're gonna be talking about today, is the fact that you can get an attorney, but you're not gonna be appointed an attorney.
Okay.
You can pay for it yourself and have an attorney, and you wish not to have it. You're not gonna pay for an attorney.
I'm disabled.
Okay, this case is my case, and so I'm gonna go over certain rules, and you tell me if you are guilty, not guilty, or guilty with a state, or not guilty with a statement. Okay.
Okay.
All right. The first rule: upon release, I'll report no later than 48 hours to probation and parole, Office of Public Safety. Okay, did you, as soon as you got out of jail in Ohio, did you report to the Louisiana State Probation and Parole?
No, sir.
So, excuse me?
No, sir, I did not.
Okay, did you know you were supposed to?
No, I did not.
Okay, so you're saying you're not guilty with a statement?
Yes, sir.
Okay, tell me what your statement is. Why didn't you report? If you had signed something saying,
I didn't know. I mean, I just spent 15 more years incarcerated. I had 37 total years incarcerated. I had no idea that I was supposed to report back. I had no means to report back.
okay,
Just discharged from the Ohio system with nothing, with a bag with a couple of items that I had, and that was the only thing I owned. I ended up in a halfway house in Toledo, Ohio.
do you have a place to live in Ohio?
No,
No?
no, sir. I was on the streets after that.
Okay, so you pled not guilty to that. Okay. Rule number two, I will submit a monthly report on the 5th of every month until I complete my supervision. Are you guilty or not guilty of that?
Because I didn't know I had to.
Okay. All right. And number three, I will live at the address of the certificate and on this certificate. And I'm assuming, how do you plead on that?
Not guilty. There's not even an address on the certificate. There's
Okay.
no address. I don't have an address.
Okay. So you
Okay. It depends when I get to bring that.
They just brought him up? Yeah. That's all right, it's fine though. He's in the enhanced phase.
Yesterday about the water cooler in the street. So it's trained. Oh, no. Yeah. Okay. Yeah. I get awful with it. Do they do something with their activities?
Yes.
Yes. You sure y'all don't have them already?
It's just like coffee and it's like. Maybe 10 meters.
Okay, I would say that's all you usually provide is for the property.
Okay.
But I can wait more, but it's not regular.
Okay, no,
So I'm covering up your information.
no, that's fine.
Thank you.
Thank you. No, thank you. Yeah. Cause I would want to look it up. Send it to him. So now it's sent to the. So that email. Castillo Gonzalez. Okay. I can send you that email. And then also. Just want to find one that should not be here, email. No, it's. But I. Wow. Actually, Alex, Michelle,
Yeah, I just need to, yeah, I think it might be. Yeah, I'll do more than one. Absolutely.
Okay. Okay, we want.
We've done a lot, right? That's why, yeah. She's in her middle. Yeah. Definitely not resort. Okay. She's actually, she lives.
Oh, really? That's awesome. Oh, really?
Yeah. I really was like, I'm definitely going. I was like, I really don't want to be involved, but. I guess.
Okay, right.
But yeah, so she is in different, maybe like just kind of for the house. She, I think it's weird thing because like back in the. Now it's the running like you're something sort of this new things she was. So. Then she goes.
I was gonna come and talk a little bit. Oh no, we're not talking a case right now, Pickles, unless you are behind. But we're just gonna start watching the judge, Fleischer out of Texas. He was getting way too big on YouTube, and he gave up YouTube because he didn't like all the attention and everything. So he gave up. But they still have the feed up on the courts thing that
You're
we've
Christopher
been using.
McCormick.
Yes, sir.
Mr.
Here we go.
McCormick, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Yes, sir. I mean,
I think you.
Mackenzie, if you want, go, and then we'll wait to do anything until you come back. And I can just have Alex hang out. Yeah, yeah, go. Just let's wait, Ramona. So that she can go talk to Jerry real quick.
Okay, no problem.
So,
Mr. Montalvo, just have a seat.
council, come on up. Hey, how are you?
Doing good, Judge. How are you?
Happy Wednesday.
Same.
You got,
So Judge, I have Tina Perez on the docket. I think this case may be due for trial setting at this point, so I just wanted to run that by you, Judge.
see.
Thanks, 43, Judge.
Yeah, it's 200 days, 100%. I mean, we need to figure out what, you guys don't want to accept any offers, don't want to do PTI?
So Judge, in this particular case, there had been a dash cam issue and some videos that we were waiting on from the plaintiff witness. I don't know that it would get PTI approved just based on the blood alcohol level.
What is it?
It's like 0.3 something. Judge.
Yeah.
So that was kind of the initial feedback from the prosecutors the past 2 sessions. That's where I'm at with that, Judge.
Yeah, it's time. So, just get a trial date for Ramona.
Yes, sir.
Yeah, whatever you want.
Yes, sir.
Okay,
Thank you.
sure. Each Cunningham. Hey, absolutely.
I'm here on Mr. Montalvo. I ended up putting it on the docket today. I know you,
Okay.
I know you want your PC and.
I have one problem. He's an intern, so we can't do anything until I get another prosecutor here. She's out talking to the jury now.
I can tell you the problem.
You said Montalvo, right? Oh, do you have the phone number?
Yes, the cost number is gonna be 255
Okay,
0592.
So if you have any brief motion.
That's the meter one.
Okay.
And.
did you want to waive PC? Okay,
He's here. Do you want me to bring him up? Are you satisfied with bond conditions?
well, no, I'm gonna put bond conditions on him. I just don't know.
Need a prosecutor.
Yeah, let me just, give me 2 minutes if you don't mind. No. You used to be one, right?
No, I've been special prosecutor whenever I've.
Huh.
I went straight in trials.
Yeah, me too.
Thank you.
Yeah.
Good to see you.
Yeah, you too. Just give me 2 minutes and then, sorry.
I'm glad I got you when you're without a jury. So.
You ended up dismissing it, so.
See someone with a real suit come in. I'm just checking.
I'll also message Will and see if he can come too, because
And then where's,
Also-
where's,
yeah, I'll message them. I don't know where either of them are.
No. Yeah. Don't. You don't have these here today? I know we all have these. I know I saw her. They were a Popa officer that has that case. They were, I don't think they're even although they get the attachment, she said, he said they put him on a home confinement.
I was present. I don't know if you want to speak with her. H. Brown.
one day, Alex, one day.
One day.
Are you a 2L or
3-0.
3L?
One more semester.
Okay.
Odessa, yeah.
Where you from?
Odessa.
Really?
Mm-hmm.
So you're just here because for the law school, right?
Law school. Mhm.
Are you gonna go back?
Probably not. Probably stay around here.
Might as well, right?
Mhm. Yeah.
Are you staying?
More opportunities. Yeah.
Do you use felonies?
Oh, yeah. Back in higher, I don't do appointments, no, like that. Yeah, I stopped filming the moment like 10 years ago. I got old to do appointments, yeah, so 60 years ago. You know, it's easy. I've never really been able to do what I'm doing now, like, they don't.
I mean, like the rules say, as long as I'm covered by a remote mean, it should be fine, but I think it's just not, that's what that, yeah. Yeah, yeah, you brought that up, yeah. I mean, supervisor had to come here and like, be with this person, so that's how we could.
Yeah.
That includes the third.
Yeah. Yeah.
I mean, I don't know, probably other things, probably vomiting.
Another day, got some research, no sign. Yeah, I'll be back. Yes, ma'am.
Need somebody to see. And she should be back, and just talk to the jury real quick, so she should be back like 2 minutes. Okay, I'll finish the drum. Yeah. Yeah, she wanna give it back. Yeah, how they feel. Yeah, I think it's like they just, yeah, that's right, yeah, she's pretty right. But that's just. This school required everybody to be here, they're boundary third. Yeah. They know they still got started with coffee. Even that. Yeah. Bringing those. Between them. Oh,
Morning. Amy, you're licensed, right?
No.
You're an intern too.
I have an intern.
All right.
Oh. You're just so good.
Am I an intern too? Yes. Come on up, Mr. Lee.
Yeah, I wish that counted.
Well, we were in trial and they just ended up dismissing it. And so the one prosecutor that we have, she's talking to the jury now. I don't know where our chief is and I don't know where our number 2 is. So that's what we're just kind of waiting now because we can't do anything until that. So I'm sure that they're coming soon. I don't.
Okay, I'm gonna get it.
Dude, you didn't understand ridiculous. There's a whole promise.
You posted this.
Okay, sorry about this, guys. I'm gonna jump to another judge. While because I don't know how long judge is gonna be. I can keep an eye on him and then come back to him if he's like changes or it gets starting interesting. Oh no, it might actually be ready. Never mind.
Mr. Montalvo, come up. Ramona, did you get the cost number on this?
I did.
Okay.
Wait, did you get the card?
Yes. Thank you. It's Casimiro?
Yes.
Yes.
Yeah. Good morning, sir.
Good morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 6, 2025, the officer was dispatched to an intersection in North Houston of Rossland Road and Little York Road regarding a major crash. The officer made contact with the defendant and observed watery eyes, slurred speech, and improper balance. The officer further observed a strong odor of marijuana. The defendant stated he was driving from his grandmother's house, turned north, and lost control of the vehicle. The defendant stated he had not been drinking, but had smoked marijuana and had marijuana in the vehicle. The officer observed a burnt marijuana cigarette on the crease of the defendant's right ear, and standard filter sobriety tests were performed. HGN 0 out of 6, walk and turn and one leg stand were unable to be completed. The defendant was read the DIC and consented to blood.
All right. Mr. Montalvo, I'm going to find that there's probable cause to go forward with your case. Have you any prior DWIs?
No prior DWIs and his eligible license.
All right. You have a lawyer. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court. But I am ordering you not to consume alcohol or illegal drugs. I'm going to test you. If I find that you continue to use, I will revoke your bond, put you in jail. Do you understand? Just stay in touch with the lawyer. He'll tell you when you have to come back. Don't pick up any new cases and just behave while you're out there. Do you understand?
Yes, sir.
All right, I'm gonna have you sign a reset with Ramona. We'll have you get with Felicia for your bond conditions, and after that, you guys are free to go.
Thank you, Judge.
Okay? Okay, Josh, you ready? So is this true? You got into college? Wow, I'm so proud of you. That's so great. What are you gonna be doing? That's awesome. Have you started yet, or when do you start?
Not when I start. I'm doing them online.
Okay, that's okay. Look, you got to start somewhere. Start small, and then you just build up, and then at some point it'll just get bigger, better, and then just keep at it. It's going to be hard. It's not easy, but if it was easy, everybody would be doing it, right? That's why the more difficult something is, in the long run, the better pay you get. Just keep up. If you ever have any issues, if you need help, just come back to us. We'll help you with whatever you need. Really, just stay with it, stick the course, and just keep it up. Okay? You're doing great. And remember, patience is key because you're going to get upset. Just don't take it out on anyone. That's it. All right? Great job. Okay. Thanks, Josh. All right, Claire, you ready?
Yeah, I'm approaching on Oriole Dixon.
Okay.
She's doing her GED class and that. The issue that we're running into, Judge, is she is having to basically learn all of high school. She's going to every class, she's
Okay.
doing all the homework.
Great.
But, they're at the point where she can take the test of the modules, but she hasn't learned everything yet. She did drop out when she was in ninth grade, so she's having to learn everything.
I get it. So what do you want to do? What do you have an offer in this case?
This is the offer, GED. Well, there's a GED PTI, but there's also another PTI for class and maybe some community service.
So you want to do that one and then just let her stick the course on her own?
I think that would be better.
Okay.
Yeah, the only offer I see is the PTI with the GED.
Oh, there's not another one added?
I only see the one anger management, anti-theft, and the GED. So
Oh, well, then I guess before it was not even an anger management.
You want to talk to the chief? She's not here now, but perhaps.
Yeah, I just have trial right now. No, we took yesterday and.
Oh, you're in trial now.
Now.
Do you want to set it off a week?
I can come back, or yeah, that'd be great. If we can wait.
Whatever you want. It's up to you.
Yeah, if we could do that, and try to figure it out, I'd appreciate that. Cool.
Go for it.
Thank you, Judge.
You got it. Oh, we have more, right? I forgot. Dude.
Page 13. Got a Mosey?
Coming up, sir. Is it Badamosi?
Yes, sir.
Mr. Badamosi, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
yeah, I apologize. Does the first name, last name start with a G?
Correct.
Okay, I just wanted.
E.D.
Okay, correct. So on October 16th, 2024, at approximately 2:05 p.m., the officer was flagged down at an intersection of Huffmeister Road and Hempstead Road in reference to an FSGI. Upon arrival, the officer spoke with the complainant, who stated he was parked at a Valero gas station and that he observed the defendant display irate behaviors. The witness observed irate behaviors towards the complainant, who expressed fear for her safety. A witness stated the complainant was attempting to exchange information, and the defendant did not attempt to exchange info and left the scene. The witness tried to follow the defendant approximately 3 miles from the scene when he saw an officer and flagged him down. The officer made contact with the defendant, and the defendant was reluctant to provide identifying information, but then identified himself by name and date of birth. The defendant admitted to being involved in an accident and that the complainant's vehicle had minor damage. The defendant made a false statement that the accident occurred at Huffmeister and Hempstead, and the defendant stated he asked the complainant if she was okay. The defendant was released at the scene, and the officers then met with the complainant at the gas station, who stated she was driving southbound on Huffmeister when she was struck by the defendant's vehicle. The complainant pulled into the gas station, and the defendant began striking her window and became irate. The complainant requested the defendant's insurance information, and the defendant refused and left the scene. The complainant stated the defendant did not ask if she was okay, and the estimated damage was $970.48.
Okay. Have you run his license?
I'll run it right now, Your Honor.
Please. Mr. Badamosi, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. If you do not have a Texas driver license and liability insurance in your name, then you're not allowed to drive, and that is also a condition of your bond. Do you understand?
Yes, sir.
It's eligible, Your Honor.
Okay. File those conditions, please. Do you have the ability to hire a lawyer, Mr. Badamosi, or did you want to apply for an appointed lawyer?
If we could actually do this now, I
Don't. Just, I have a bunch of, well, not a bunch of days. I have DAs here. Whatever you say, they're going to use it against you. It's best that you just don't say anything now. You need a lawyer in this case. Don't, it's, you could end up with a conviction. You're looking at up to 6 months in jail and or a $2,000 fine. You need a lawyer to represent you in this case. So you can either hire one or you can apply for a court-appointed lawyer one, but you have to qualify for an appointed lawyer. If you'd like, I can give you an application and we'll see whether you qualify or not.
Yes.
What would you like to do? Okay, I need to know everything about you. I need to know how much money you have coming in. I need to know whether you have a spouse that has money coming in, what kind of car you drive, what house, money in your bank account. I need to know everything about you, and then I'll see whether you qualify. Deputy Miranda is going to give you an application. I'll have you sign a receipt with the.
I go ahead and pay for an attorney. I don't have to do all this. I just go ahead and hire the attorney and stuff.
Right. If you wanted to go hire a lawyer, what we would do is I'd have you sign a receipt with Ramona, would get you out of here, and then when you come back, just have a lawyer.
I'll take the, I'll get my.
You're going to go hire them. Okay, so just bear with me. So I need you to sign our bond conditions. I'll have you sign a receipt with Ramona. Let me just have you take a seat in the jury box. I'm going to get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Okay?
Your Honor, just to confirm, it was no contact with the complainant.
Yeah, no weapons, no contact with the complaining witness. No driving without a.
No, tech and insurance. Yes, Judge.
Judge, the next one is Anthony Smith.
Anthony Smith, come up.
Page 29, Judge.
Got it. Mr. Smith, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, a University of Houston student found the defendant sleeping inside a campus building on the 4th floor and believed the defendant was not a resident. The student alerted the on-call desk attendant, who called campus police. Campus police made contact with the defendant, and after running him through TCIC, gyms, and locals, found an active issued campus-wide criminal trespass warning from May 16th, 2024. The officer had previously found the defendant inside a different building on the campus, and these buildings are only accessible to students and staff. The defendant is neither staff nor student. The defendant was then detained.
Right. Mr. Smith, I'm going to find that there's probable cause to go forward with the case. Going back to University of Houston. Do you understand? Don't, if you need a lawyer, I can give you a lawyer today. You can tell the lawyer, but I don't want you going back unless you're an active enrolled student there. You're not to go back to any part of U of H. Do you understand? If I find that you violate these conditions, I'm going to put you in jail. No more PR bonds for you. I'm also ordering you not to be in possession of weapons as well. Understand? I'm not asking for much. Just don't go back there. If you need a place to sleep, if you need a place to go, we can find that for you. Just don't go back there. All right. I'm not, stop, don't.
Sorry about that, guys. But apparently there is the feed is up. I don't know if they are gonna come back soon or not. So things are moving. So I was thinking, and I was just actually just reading, writing on the chat, but I'm gonna talk about it. That's what I was thinking. Maybe even. You know what I was thinking? William McLeod. I was thinking about mom's boyfriend being the baby daddy because his DNA probably is already in the system anyway. So I was thinking that would be the William McLeod, the baby daddy, but don't know. I was actually thinking, what do you guys think? There is a new trial that started literally 2 days ago. The rose petal unaliving trial. Um, I don't know anything about that case. It's from South Carolina. They are on a half an hour delay, but doesn't matter because we can be on catching up. What do you guys think of watching that trial after this one? Because there's a high possibility that this case finishes today. That be a possibility that we literally close the chapter on Megan Boswell. What we could do is like we did with this one on Verdict Watch. We could on Verdict Watch on the deliberation. We could start the new one and then go back, do the verdict, and then come back to this one. But the one thing that like absolutely we need to know the baby daddy, because I was like, how can I move on to another trial without the baby daddy's name and information? I was like, literally the defense made the whole thing make the whole thing of talking to the news station and to everyone and then saying so it's like the news station saying, oh, you're gonna find out in court who the baby daddy is, and all the information is gonna come out in court. Comes his time, the defense rests. I was like, are you serious? You gave us a cliffhanger and you not come through with your cliffhanger. That is just absolutely ridiculous. Sorry, you upset me with that because I've been waiting. So probably that's what we're gonna do. We're gonna do the Zachary. I think his name Zachary Hughes. Or Hughes. I don't know his name. I need to do some research on him. But what we might do is doing some catch up on him while on Verdict Watch, and I need to just do like the thumbnail and all the sort of stuff. But that's probably the next trial that we are going to be covering. I know it's been back to back to back trial, but hey, it's a trial season. We need to take advantage of this. And I like doing court, watching court cases and everything. It's not my favorite thing though. I prefer watching trials. But we'll do that. If nothing new, the new trial comes up, I mean, in my search, I mean, if you have any suggestions of small little trials or anything that is ongoing, please let me know. Please reach out. I would love to hear that because you guys are also a part of the channel. And if you mention a case that you would like for us to follow, there is pretty much almost nothing that I won't cover. Judge is on the bench. We are going ahead. So yeah. So let me know, but probably we're gonna cover that one. But I don't know. I know Chase, I don't know if you guys remember. Sound is coming back. Now that I'm like talking, sound is coming back. How rude. Because I was thinking, the last trial we had out of Tennessee, the jury had to choose the penalty phase too. So I need to find that out because I don't want to start with the openings of the new case if this one still has the penalty phase, and that's what's going to take us to the to the 4 weeks that they were saying. There is sound from court. I hope you guys are can hear it, but I'm still talking because there's still nothing. No one is talking, so I'm not being rude. Lol. No, I am because they're talking. Is it? I don't know. I stopped talking. They stopped talking. I
I'm gonna ask
stopped.
this one last time. Have y'all reviewed the final charge or the charge in its final form?
I have, Judge. I have, Judge.
And on behalf of the state, General, do you accept the charge as written?
Yes, Judge.
Mr. Scott, on behalf of the defendant, do you accept the charge as written?
Yes, sir.
All right. What I'm going to do, it's 81 pages long. I'm going to bring them in, give them the charge. I'll probably, of course, I have to read all the judgment forms. Oh, if you look at it on page 49, I'm going to read down to, I'm going to stop where it says when you retire to the jury room. I'm going to wait and give them that part after y'all argue. I would ask if the state's ready, but I think General Harper just left.
He's coming right back. He left his copy of the jury instructions on his desk. He's just grabbing them. The state is otherwise ready.
And I won't say it, I'm sure I won't think to say it, but the presentment is required to go back with the jury charge. And it's in the back of the book.
Your Honor, count 18, was that redacted out? Just making sure.
Yep.
Yeah.
Thought we did.
Yep. All right. Is the state ready to proceed? Defense ready to proceed?
Yes, Judge.
Then let's bring the jury in.
So 81 pages.
Stand, please.
81 pages of jury instructions. That is going to be wild. But before we do go very quickly, don't forget, everyone, to play the verdict game where you get to guess the verdict, guilty or not guilty or hung, and the approximate time of the deliberations. There are prizes for grabs for the winner. Or the link will be again in chat. Make sure you play if you want to.
All right. In the criminal court for Sullivan County, Tennessee, at Blumble, State of Tennessee versus Megan Boswell, defendant, case number S72869, date February 3rd through 12, 2025. Count 1, first degree premeditated murder. Count 2, first degree murder in the perpetration of a felony. Count 3, first degree murder in the perpetration of a felony. Count 4, aggravated child abuse. Count 5, aggravated child neglect. Count 6, tampering with evidence. Count 7 through 17, false report. Count 19, abuse of a corpse. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Jury instructions. Members of the jury. Count 1 of the presentment charges the defendant, Megan Boswell, with the offense of premeditated first-degree murder. This offense embraces the lesser included offenses of facilitation of premeditated first-degree murder, attempt to commit premeditated first-degree murder, facilitation of attempt to commit premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, child neglect, attempt to commit child abuse, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 2 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offenses of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, attempt to commit child abuse, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 3 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offense of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child neglect, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 4 of the presentment charges the defendant Megan Boswell with the offense of aggravated child abuse. This offense embraces the lesser included offenses of facilitation of aggravated child abuse, attempt to commit aggravated child abuse, facilitation of attempt to commit aggravated child abuse, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child abuse, attempt to commit child abuse, assault, and attempt to commit assault. Count 5 of the presentment charges the defendant Megan Boswell with the offense of aggravated child neglect. This offense embraces the lesser included offense of facilitation of aggravated child neglect, attempt to commit aggravated child neglect, facilitation of attempt to commit aggravated child neglect, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child neglect, attempt to commit child neglect, assault, attempt to commit assault. Count 6 of the presentment charges the defendant Megan Boswell with the offense of tampering with evidence. This offense embraces the lesser included offense of facilitation of tampering with evidence, attempt to commit tampering with evidence, and facilitation of attempt to commit tampering with evidence. Count 7 through 17 of the presentment charges the defendant with Megan Boswell with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant Megan Boswell with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant Megan Boswell with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue. except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty to this offense. Count 2, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. The killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the aggravated child neglect, the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And three, excuse me. Three, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. One, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And two, that the act of neglect resulted in serious bodily injury to the child. And three, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally have previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony and was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown are established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix a fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has previously been defined, for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of these instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix the fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix the fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For purposes of this count, intentionally, knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than $5,000. And you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5, misdemeanor or reckless endangerment. Any person who commits the offense of misdemeanor or reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor or reckless endangerment, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of misdemeanor or reckless endangerment as charged in the presentment, then your verdict must be not guilty as to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. That should say neglect. All right, let me reread that. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew an investigation was in progress, and 2, that the defendant concealed a thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, knew, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of tampering with evidence as charged in the presentment, then your verdict must be not guilty as to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officer is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the statement was made by the defendant. 2, that statement was made in response to a legitimate inquiry by a law enforcement officer. And 3, that the statement would concern a material fact about an incident within the officer's concern. And 4, that the defendant knew such statement was false. And 5, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur. For purposes of this count, new and law enforcement officer are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false report, then you may fix the fine in any amount not greater than $5,000, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of false report as charged in the presentment, then your verdict must be not guilty as to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of abuse of a corpse, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of a corpse as charged in the presentment, then your verdict must be not guilty as to this offense. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly failed to report the death of Evelyn Boswell to the county medical examiner, local police, district attorney, or sheriff. And 2, that the death was from violence, trauma, or any suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under circumstances as the defendant believed them to be at the time. And his actions constitute a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4. Attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5. Attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count 6. Attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. Attempt to commit false report, maximum fine $5,000. Count 19. Attempt to commit abuse of corpse, maximum fine $2,500. Count 20. Attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1. Facilitation of first-degree murder, maximum fine $50,000. Facilitation of attempt to commit first-degree murder, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6, facilitation of tampering with evidence, maximum fine $5,000. Facilitation of attempt to commit tampering with evidence, maximum fine $3,000. Count 19, facilitation of abuse of a corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense are circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or new means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. The person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Recklessly or reckless means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as to the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Child neglect. 19. Attempt to commit child abuse. 20. Attempt to commit child neglect. 21. Assault. 22. Attempt to commit assault. 23. Misdemeanor reckless endangerment. Count 2. 1. first-degree murder in the perpetration of a felony. 2, facilitation of first-degree murder in the perpetration of a felony. 3, attempt to commit first-degree murder in the perpetration of a felony. 4, facilitation of attempt to commit first-degree murder in the perpetration of a felony. 5, second-degree murder. 6, facilitation of second-degree murder. 7, attempt to commit second-degree murder. 8, facilitation of attempt to commit second-degree murder. 9, voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child abuse. 18, attempt to commit child abuse. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 3. 1, first-degree murder in the perpetration of a felony. 2, facilitation of first-degree murder in the perpetration of a felony. 3, attempt to commit first-degree murder in the perpetration of a felony. 4, facilitation of attempt to commit first-degree murder in the perpetration of a felony. 5, second-degree murder. 6, facilitation of second-degree murder. 7, attempt to commit second-degree murder. 8, facilitation of attempt to commit second-degree murder. 9, voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child neglect. 18, attempt to commit child neglect. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 4. 1, aggravated child abuse. 2, facilitation of aggravated child abuse. 3, attempt to commit aggravated child abuse. 4, facilitation of attempt to commit aggravated child abuse. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child abuse. 15, attempt to commit child abuse. Count 5. 1, aggravated child neglect. 2, facilitation of aggravated child neglect. 3, attempt to commit aggravated child neglect. 4, facilitation of attempt to commit aggravated child neglect. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child neglect. 15, attempt to commit child neglect. Count 6. 1, tampering with evidence. 2, facilitation of tampering with evidence. 3, attempt to commit tampering with evidence. 4, facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. 1, false report. 2, attempt to commit false report. Count 19. 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20. 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second?
I think the judge needs a break after this, man. The reading all these charges and everything. It is, yeah, that was definitely a second. Wow, yowza. Something might be wrong with this jury instructions because the judge is amending something. So it's just weird. Uh, you did not miss anything. Yes, and she is guilty. I think there's something wrong with the jury instructions, so the judge is trying to revise that and everything. But Louis, I did find it, at least not in the U.S., but probably in the world, the most person that has the most convictions, that was convicted of 2,653 counts of fraud in Thailand, and he was sentenced to 13,275 years in prison. So that's a long sentence. I don't think. Why did they not just give a life in prison? Because giving years is just, well, yeah, it's the same thing. Um, so, yeah, that
All right.
person is gonna be in prison.
Now, ladies and gentlemen, remember, when you go back there and you select a foreperson, this is the official jury charge. Okay? And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment at a separate sentencing hearing. You'll be provided with forms for all possible verdicts in this case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. Now, in your books, you don't have, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of first-degree murder, or checkbox 2, guilty of facilitation of first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 4, guilty of guilty of facilitation of attempt to commit first-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder. Fine amount $ blank, not more than $25,000. Verdict form, count 1 continued. Checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $ blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $ blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $ blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount $ blank, not more than $5,000. Or checkbox 14, guilty of facilitation of reckless homicide. Fine amount $ blank, not more than $3,000. Excuse me. Or verdict form count 1 continued. Checkbox 15, guilty of criminally negligent homicide. Fine amount $ blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount $ blank, not more than $2,500. Or checkbox 17, guilty of child abuse. Fine amount $ blank, not more than $2,500. Or checkbox 18, guilty of child neglect. Fine amount $ blank, not more than $2,500. Or checkbox 19, guilty of attempt to commit child abuse. Fine amount $ blank, not more than $500. Or checkbox 20, guilty of attempt to commit child neglect. Fine amount $ blank, not more than $500. Or checkbox 21, guilty of assault. Fine amount $ blank, not more than $2,500. Or checkbox 22, guilty of attempt to commit assault. Fine amount $ blank, not more than $500. Or verdict form count 1 continued. Checkbox 23, guilty of misdemeanor reckless endangerment. Fine amount $ blank, not more than $2,500. Or checkbox 24, not guilty. 4-person signature line date blank. Verdict form count 2. With jury, find the defendant Megan Boswell marked appropriate 1. Checkbox 1, guilty of first-degree murder in the perpetration of a felony. Or checkbox 2, guilty of facilitation of first-degree murder in the perpetration of a felony. Fine amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder in the perpetration of a felony. Fine amount $, blank, not more than $50,000. Or checkbox 4, guilty of facilitation of attempt to commit first-degree murder in the perpetration of a felony. Fine amount $, blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount $, blank, not more than $50,000. Or verdict form count 2 continued. Checkbox 6, guilty of facilitation of second-degree murder. Fine amount $, blank, not more than $25,000. Or checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $, blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $, blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $, blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $, blank, not more than $5,000. Checkbox 11 or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount dollar sign blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount dollar sign blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount dollar sign blank, not more than $5,000. Or verdict form count 2 continued. Checkbox 14, guilty of facilitation of reckless homicide. Fine amount dollar sign blank, not more than $3,000. Or checkbox 15, guilty of criminally negligent homicide. Fine amount dollar sign blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount dollar sign blank, not more than $2,500. Or checkbox 17, guilty of child abuse. Fine amount dollar sign blank, not more than $2,500. Or checkbox 18, guilty of attempt to commit child abuse. Fine amount dollar sign blank, not more than $500. Or checkbox 19, guilty of assault. Fine amount dollar sign blank, not more than $2,500. Or checkbox 20, guilty of attempt to commit assault. Fine amount dollar sign blank, not more than $500. Or verdict form count 2 continued. Checkbox 21, guilty of misdemeanor reckless endangerment. Fine amount dollar sign blank, not more than $2,500. Or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 3. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of first-degree murder and perpetration of a felony. Or checkbox 2, guilty of facilitation of first-degree murder and perpetration of a felony. Fine amount dollar sign blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder and perpetration of a felony. Fine amount dollar sign blank, not more than $50,000. Or checkbox 4, guilty of facilitation of attempt to commit first-degree murder in the perpetration of a felony. Fine amount dollar sign blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount dollar sign blank, not more than $50,000. Or verdict form count 3 continued. Checkbox 6, guilty of facilitation of second-degree murder. Fine amount dollar sign blank, not more than $25,000. Or checkbox 7, guilty of attempt to commit second-degree murder. Fine amount dollar sign blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount dollar sign blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount dollar sign blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount dollar sign blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount dollar sign blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount dollar sign blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount dollar sign blank, not more than $5,000. Or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide. Fine amount dollar sign blank, not more than $3,000. Or checkbox 15, guilty of criminally negligent homicide. Fine amount dollar sign blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount dollar sign blank, not more than $2,500. Or checkbox 17, guilty of child neglect. Fine amount dollar sign blank, not more than $2,500. Or checkbox 18, guilty of attempt to commit child neglect. Fine amount dollar sign blank, not more than $500. Or checkbox 19, guilty of assault. Fine amount dollar sign blank, not more than $2,500. Or checkbox 20, guilty of attempt to commit assault. Fine amount dollar sign blank, not more than $500. Or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment. Fine amount dollar sign blank, not more than $2,500. Or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 4, we, the jury, find the defendant, Megan Boswell, mark appropriate 1. Checkbox 1, guilty of aggravated child abuse. Fine amount dollar sign blank, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated child abuse. Fine amount dollar sign blank, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child abuse. Fine amount dollar sign blank, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child abuse. Fine amount dollar sign blank, not more than $10,000. Or checkbox 5, guilty of aggravated assault, not more than, fine amount dollar sign blank, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault. Fine amount dollar sign blank, not more than $5,000. Or verdict form count 4 continued. Checkbox 7, guilty of attempt to commit aggravated assault. Fine amount dollar sign blank, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit aggravated assault. Fine amount dollar sign blank, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault. Fine amount dollar sign blank, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault. Fine amount $ blank, not more than 3,000, or checkbox 11, guilty of assault. Fine amount $ blank, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault. Fine amount $ blank, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment. Fine amount $ blank, not more than $2,500. Or checkbox 14, guilty of child abuse. Fine amount $ blank, not more than $2,500. Or verdict form count 4 continued. Checkbox 15, guilty of attempt to commit child abuse. Fine amount $ blank, not more than 500. Or checkbox 16, not guilty. 4-person signature line date blank. Verdict form count 5. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of aggravated child neglect. Fine amount $ blank, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated neglect. Fine amount $ blank, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child neglect. Fine amount $ blank, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect. Fine amount $ blank, not more than $10,000. Or checkbox 5, guilty of aggravated assault. Fine amount $ blank, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault. Fine amount $ blank, not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault. Fine amount $ blank, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault. Fine amount $ blank, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault. Fine in amount $ blank, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault. Fine amount $ blank, not more than $3,000. Or checkbox number 11, guilty of assault. Fine in amount $ blank, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault. Fine amount $ blank, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment. Fine amount $ blank, not more than $2,500. Or checkbox 14, guilty of child neglect. Fine amount $ blank, not more than $2,500. Or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect. Fine amount $ blank, not more than $500. Or checkbox 16, not guilty. 4-person signature line date blank. Verdict form count 6. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of tampering with evidence. Fine amount $ blank, not more than $10,000. Or checkbox 2, guilty of facilitation of tampering with evidence. Checkbox amount $ blank, not more than $5,000. Or checkbox 3, guilty of attempt to commit tampering with evidence. Fine amount $ blank, not more than $5,000. Or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence. Fine amount $ blank, not more than $3,000. Or checkbox 5, not guilty. 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of false report. Fine amount $ blank, not more than $5,000. Or checkbox 2, guilty of attempt to commit false report. Fine amount $ blank, not more than $3,000. Or checkbox 3, not guilty. 4-person signature line date blank. Verdict form count 19. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of abuse of corpse. Fine amount $ blank, not more than $3,000. Or checkbox 2, guilty of facilitation of abuse of a corpse. Fine amount $ blank, not more than $2,500. Or checkbox 3, guilty of attempt to abuse a corpse. Fine amount $ blank, not more than $2,500. Or checkbox 4, guilty of facilitation of attempt to commit abuse of a corpse. Fine amount $ blank, not more than $500. Or checkbox 5, not guilty. 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant, Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances. Fine amount $ blank, not more than $3,000. Or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. Fine amount $ blank, not more than $2,500. Or checkbox 3, not guilty. 4-person signature line date blank. Back on page 48. You'll be provided with, well, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. I'm going to stop right there. Is there lunch here? Your lunch is here. I'm going to let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm going to have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge.
Everyone stand, please.
Yay, we made it through, guys. Whoop whoop. So, yeah, I think we are most sleepy. So, I have done a song with AI thingy. I think Suno, yeah. And I want to play it. But how do I share it? I think I'm gonna have to share the screen of this tab. So I'm gonna hopefully the sound is not like deafening. I really liked it. So I'm gonna share the tab. It's fine. I think. I don't know. So I hope the sound is not gonna be deafening.
Roll through the feed, headlines popping off. Her lies tangled tighter than a granny's knitted cloth. Daughter gone missing, truth begin to skew. Media frenzy like shades of deja vu. Heartstrings played out, the court got a name. Spotlight shine, harsh detectives in the frame. She's scrolling through alibis, truth now a ghost. Hiding behind tears, face going coast to coast. Check the box, tick a lie. Snake in the grass, wonder why. Whispers louder, the silence she barred. Secrets unravel, the lies get caught. Courtrooms, roof waves, emotions on blast. Lawyers duke it out, facts shadowed in the past. Smoke screen thick, truth stay elusive. Innocence claimed, evidence conclusive. Megan's whispers like a Halloween mask. Every answer given, non-committal task. Reality and fiction, lines getting blurred. Justice owes alike, truth be heard. Check the box, tick the lie. Snake in the grass, wonder why. Whispers louder, the silence she barred. Secrets unravel, the lies get caught. Megan's whispers like a Halloween mask. Every answer given, non-committal task. Reality and fiction, lines getting blurred. Justice holds a mic, truth be heard. Check the box, tick the lie. Snake in the grass, wonder why. Whispers louder, the silence she barred. Secrets unravel, the lies get caught. The lies get caught. Yeah! the lies get caught. Hey.
All right. So, what do you guys thought of our song? And now I've lost the screen. But anyway, I will just go back to this one. I really like that. The case one. Thank you so much for the idea. Amazing idea. Love it. Because I was like, I'm trying to be like natural, and you guys like give ideas and everything, and we do those, and not like imposing just my stuff. I loved your guys' impulses, like and asking for stuff, and I don't mind at all because that was very very awesome. And I've lost the window, of course. Oh, there, the lol. So I think like I'm gonna keep the song, and I might put the to see if I can do like a playlist on on playlist on Linktree or something, and then for each trial we can make some like a song or something like that, and then like go with the flow. If you guys wanted to, we can do it. If you not, just like easy peasy lemon squeezy, you know what I mean. So finally we made it through, everybody. We made it through all those jury instructions. It was long, but we made it through. So after lunch we're gonna have some closings and then deliberations. I did not hear, but did you guys hear anything about the length of the closings? Because um normally judges have limits on trial on closings like an hour, 2 hours, 45 minutes, but I don't think I have heard anything. No. Okay. Because then this is worrying me because I want to start our new trial, right? I am done with Megan. I know she's guilty. I'm sorry. She's gonna go away forever. But apparently, if yeah, as like I want to find Megan guilty, lock her up, and throw away the key and move on. Uh, but we might have the sentencing phase after this. So I think if they find her guilty on the first and the living, they go back and the jury determines the sentence, which is either life with parole or life without with it's either life without the possibility of parole or life with the possibility of parole. That's what she's facing because the unaliving penalty was removed from her case. So that's gonna be it, and then obviously we're gonna listen to victim impact statements and all of that, and then like arguing about that. I don't think it's gonna take more than a day for that. So probably if we have a verdict day, they will do the sentencing phase tomorrow because I'm not seeing that taking much longer. And then hopefully by Friday we'll be done with this case. That would be great. That would be such good news because then Friday we could pick up our new trial, which would we would be a couple days behind, but that's okay. We can make extra overtime for that, and we can speed it up through. Uh, or we can stay permanently behind and just go with the flow or see whatever is out there at that time. But I'm really interested in that rose petal one now anyway. But yeah, I agree, case one, because like that is a lot of pressure on the jury to like find the penalty for the for the person. I mean, ugh, I mean, to be fair, they still have the whole motel and everything, and uh, they should not leave to the jury. Should be the judge at a later time because that ruins our plans, judge, and that is just not fair. So, are they gonna be back at 1 p.m. or was it 1 p.m. right that they are gonna be back? I did not notice because I was too into listening to the song that we have, the new song that I created with the help of Case One, and did not pay attention. But I think it is a 1 o'clock. But my food is actually quite ready, and is be it's been ready for a bit. So what I'm gonna do is I'm gonna play some chord from Judge Stephanie Boyd out of Houston, and then I will be back in the bed after I eat my food. And you guys can also like eat and go do your stuff. We'll be back shortly, just before 1 o'clock anyway, for the case. But just to if you want to listen to something while we are on break, I'm just gonna leave something on here for us and for y'all to do to listen. Apparently she's in the middle of a trial. Hang on 1 second. She is in the middle of a trial. I don't want to go in the middle of a trial because then I love Judge Boyd as well, but apparently she's in the middle of a trial. Let me see where Fleich is. I really like Judge Stephanie Boyd, um, but yeah, we're gonna probably be with Judge Fleisev instead. I am so sorry. Oh, I pressed the stop sharing button instead of the share this tab. Oh my days. Nope, this one. We're gonna stay with Fleich for the moment, and then I will be right back because I don't want to put the thing is I don't want to put just Stephanie Boyd, the Judge Stephanie Boyd, because she's in the middle of a trial and it would make no sense, absolutely no sense of starting a trial from the middle and then not having to drop it and go to another court. So that's why I'm choosing to leave you with Judge Fleischer, which I hope he comes back soon. He starts talking. So I'm gonna have my food while it's still warm. I'll see you guys very, very shortly. And yeah.
Just so that they can have the money. Yeah. Because I have to do transfer. There you go. You're very welcome.
No more.
Right on it?
Okay, who's next, Ramon?
Okay, 13 at the top of 13, bonding. Bonding.
Oh.
Yes, that 5,001. Or hold on a second, hold on. It may be more on that one because we've had a number of issues with this gentleman. 5,001.
You know what? I'm not. So, for some of the like, they have different murders on a case, but they also have like, they have some other but their bond is like, they have a bond that's set out and they post it, which is. And post their bond for 1 month. They wouldn't be transferred to the account, right? They could just be released and they would just have to go through whatever. It's an American bond. Where they're required, right? But they wouldn't, even if they switched to our bond.
Good morning, Judge. We are here on Charles Black.
Okay.
Judge, he is wanted, I forgot what one it was. He's wanted, Georgia. He's wanted out of Georgia, Judge. He's asking for a bond. He is stating that currently he is having cancer treatments at Memorial Hermann, and that he would like an opportunity to go handle these cases within the 2 weeks, as well as continue his cancer treatments.
What's he want it for? And what, are you opposed or unopposed?
We're opposed based on reasons. Do you want to bring him out?
Yeah, do you mind bringing him up? Sure. Who's next, Ramona?
Judge, did Michael Pam approach you on time?
Uh,
He left.
Who left?
Mr. Pam.
Is Mr. Ghani here?
Yes.
How's your trip here in Kansas?
Well, Ghani?
Okay.
Team.
Is he planning to like drive us? Is he planning to drive us?
I mean, if he's not here, I'm revoking it at 5,001.
Because his drive.
Who's next?
Let's see, yeah.
Oh, Godfrey, did you get that one?
Yeah.
Okay. What about Jacobo?
No, Judge, there's a whole.
What do you mean there's a hold? What is he here?
Yeah.
Okay, so 5,002 on both cases then. Can you take Kelly Benavides off, please? I'm still showing her attached on Jacobo. Jacobo, page 15.
Mama lives there.
All right.
5,002, you said?
Black, Charles Black.
Please. Good morning, Mr. Black.
Morning.
So your lawyer is asking me to set you a bond. I don't know. You know, I've never met you before. I have to get to know you in a very, very short time. I need to know several things before we set you a bond. You know, you are an inherent flight risk because you're wanted out of another state for some charge I have no idea for. So we're going to get to know you to see whether we should set you a bond or not. I don't know at this point. So Amy, tell us about Mr. Black.
Your Honor, he's wanted out of Rockdale County, Georgia for possessing, displaying false ID with government logo or seal for criminal act, and also a theft by taking of a motor vehicle. State's opposed to a bond at this time. We also see that he has a bond forfeiture in Harris County, and then he also has an open warrant in Kansas for a failure to appear. Furthermore,
Did you know that?
No, she just told me when we were waiting on him to come out.
Furthermore, we have concerns about how he would even get back, considering his driver license was denied renewal in 2021 due to a failure to appear and driver.
Oh, but I mean, there are other ways, right? But the more concerning fact is that he's got an open warrant in a different state as well. What is that for? And how long has that been open?
We're only seeing for failure to appear. I saw earlier it was from 2017. So he's been
It
out.
was in 2017.
Correct.
I've never even been there.
I'm just telling you what they're saying. They're saying that you have also an open warrant from Kansas from 2017. I can't possibly give you a bond when you're wanted at two different states, one for 6 years ago, man. You know, have Kansas not put a hold on him?
Not that I know of at this time. I can reach out to our central records to find out.
That would be good. You know, I would like to know whether they're going to put a hold on him, you know. Has he waived yet? Do you know?
He has.
Okay, when did he waive?
That's correct.
Do you know what he's wanted out of Kansas for?
Not at this time. Dave was the one who told me.
So let's do this, because the cases that you're wanted out of Georgia, they're not the most egregious. You know, it's a suspended license and then a theft case. It's not the most egregious. My more concerning issue is that you're wanted out of a different state as well. So let's do this. What we can do, let's roll this to tomorrow. Can you, Amy, in the interim, if you can figure out, number one, is Kansas going to put a hold on him? Number two, what's he wanted for? If it's some kind of rinky-dink speeding, then I'm not worried about it. But if it's something serious, then I have issues, especially being that it's 6 years old. So let's do this. You know, it's a no at this point, pending what's going on in Kansas. So let's see what happens there. And then, you know, we can bring him back tomorrow and figure out. And I just need more information to be able to make an informed decision at this point. Okay? Do you have any questions?
Pretty much. I know somebody has been using my identity for the past couple of years because I was in Georgia, but.
And it's probably a good idea for you to do something about it and not just, you know.
I reported my identity stolen and I put out a theft report for it.
I don't know what to tell you, but before I set you a bond in, you got to understand, I can't just take your word for it, right? Right. I have a lot of people that try to sell me the sun, moon, stars, tell me it's little bunnies jumping in the woods, to what their cases are all about. When really. So let's figure out more information. We can bring you back tomorrow and see. Okay?
Thank you.
Okay, thanks, Shabbat.
And I also have waivers for Elijah Clark and Alana Gonzalez, who had originally sent her a bond. I believe it was like last week. Mother decided that they did not want to put it up.
Really? Oh, man, that sucks.
So we have her waiver.
Okay. I'll just sign it. We'll be good. Thanks. Gonzalez on the dock today.
Yes.
Set the bond at.
$1,500.
Didn't want to make it.
I think, no. So when they were going to the bonding companies, they kept saying that even if they did it, that she would still want it. They were giving her a hard time. So I suggested that they go put the full amount up at 49 cents a cento. She told me that they were gonna do that. And then she called me, whatever day I sent the email the day before yesterday, indicated that they weren't able to do that, or they didn't want to do that, or whatever the case may be. So she's really just been
I
sitting there.
mean, it's a lot of money, and
Because I explained it very clearly the first time I called Judge. It's unfortunate that she had to sit for a week. She could have been gone to Louisiana by now, I
Right.
believe.
Yeah.
They assured me that they would before I signed the document that day.
okay, guys, thanks.
Yeah.
Thanks.
I got this other one.
Donnie? Donnie?
I'm gonna get on there, because there's, I don't know what it is. I should have.
Hey,
So just the other one, just sort of bringing it out. So there could be some of this out there. Side. And. But I have some. We don't. I was. You play. Chinese.
who's next?
What are you doing with Donnie?
Who?
Mike McDonnie, page 14, well.
Did the person if they're here?
They can, but I guess they.
But if they're not here, they're not outside. And it's 11:30. Yeah, 5001.
On page 20.
And this is going to be like.
5002.
No, just one.
Okay, I'm gonna ask them please, this has conditions, I don't know if they're like speaking with me for the. So you might, you wanna ask.
Oh, yes.
You can get a question, that's fine.
Okay.
All the same. Oh, I'm kidding.
Yeah, I know, paychecks goes in.
Oh. Yeah, why don't you give me those?
They were all together. And it just monitoring. Morning, Judge. Can we approach?
Yeah, of course. Come on up.
I'll bring up my client, Judge.
What are we doing?
So on his harassment case that's getting dismissed today,
Okay,
there was that subsequently filed, criminal initiative case, that's gonna be set. Waiting for discovery on that one. We're asking, the part of the conditions of the harassment case for the monitoring. You have stated previously that if he got a job, that he would consider taking the monitoring off. He hasn't come employed. Also, he's done a whole plethora of things to get the dismissal. He's took the anger management class. He took the 16-week, I'm sorry.
BIP?
Not the BIP, the other, forget the name of the class, the long 16-week class.
thinking for a change?
Thinking for a change, yes. And then it's also completed, like I said, the anger management class.
So Deanna, is he the complaining witness in the mischief? It's the same as the complaining witness in the harassment, right?
Well, technically, no, Judge. He went to go find a complaining witness, the girl, but destroyed the grandpa's car.
Allegedly.
Oh, okay, allegedly.
And destroyed is a big term, Judge. So I don't.
Mischieved the grandpa's car.
What is your position to them to taking
I
off?
just want to look at the surveillance because it looks like it was a June case that was filed in December. And it wasn't, the person that put in the PTI offer before didn't include this one, which I probably would have included just to get both of them dismissed.
So when was the offer made prior to the new case or before this?
Yes, Judge, it was prior to the new.
That's
case.
why.
Yes, so. but it
Most
wasn't-
people remove a PTI offer when you pick up a new case,
Yes.
right? You don't get the benefit of the bargain when you continue to act like
Yeah.
a knucklehead.
And we approached, and the problem was, and you were a little upset that day, was that was preceding the harassment incident by 2 months,
Oh.
3 months.
So the open state,
I see. So that's weird. But
I agree.
nevertheless, if it's not filed, then they're not going to know about it
Right.
to include it into the PTI offer. I see. So now that's why.
So I
Okay.
just want to make sure that something was taken care of because the restitution I have from when we spoke, when Alex spoke to
Mhm.
him was December 18 was $4,000,
Oh, that's high.
which is why I want to be able to reach back out to him and be like,
And
if there's maybe a.
before I want to remove the device, I want to know that there have been no issues as well. So
And the last time we were here, I spoke to you, Judge, and also Attorney Harmer, that the issues are coming from, there are issues, but they're all coming from the CW. I've provided video evidence and text message proof that she has been constantly trying to contact him and harass him, even through all this stuff.
still, or is that, has it
That-
stopped?
I haven't, since December, it was still since December. I don't know what's happened between, January and today, but during December, from September to December, there were multiple attempts to text him, multiple attempts of calling him from different numbers.
So let's do this. Would you mind reaching out to the complaining witnesses, both?
Yes, Judge.
Her
And the grandfather.
and the grandfather, see if there have been any issues.
Mm.
If there are, ask for proof. Don't just take their word for it. Say, yes, if she's like, yes, he's been contacting me, ad nauseum, this and this, okay, show me. Take a screenshot of whatever you're saying that has happened, because there's documentary evidence and everything today now, right? Whenever you get a call, you can pull the call log. So, and that if they say, well, I don't have it, then we take it with a grain of salt.
Yes, sir.
I'm willing to, I want to make sure that there've been no issues. If there have been no issues, then I'll take it off.
Okay.
So what we can do, if you want to, now it's 11:45, if you want to roll it to tomorrow, and I can waive his appearance so he doesn't have to come back,
Yes, we can do that.
right? And then assuming they still have no issues, I'll waive the signature so he doesn't have to come back and we can remove it.
Okay.
But I want to make sure that no issues have been occurring before I take it off. And then if so, then we're good. And then are you in the same instance, get the restitution amount,
Yes, Judge. Mhm.
get proof,
Mhm.
right? Because if they're saying it's $4,000 and you're talking just in this, Wasn't it just a rear view mirror if I'm not?
It was the mirror, yeah.
4,000, what is he driving? A Lamborghini Urus?
Yes,
Really?
Judge. We'll reach back out and see if we can get that proof for restitution.
Right. And I'm happy to do whatever day you want to do. If you want to do tomorrow, if you want to do 3 days, a week, whatever you want to do, and then we can waive his appearance, so you didn't have to.
That'd be great. I'm down here tomorrow, so.
Okay, let's hope they're able to do both by tomorrow. I don't know.
Okay.
We'll see. You got, Mirella is 5,002.
Well, should CW reaching out? Just forward me whatever you said.
Email? So it's gotta be stuff in here.
Oh, perfect. Yeah, it's not attached on anything. I can just double check. There's nothing there. Let me just send it to you.
First was.
Oh, well, he's gone.
Yeah. Morgan, the previous.
Oh, well, also long.
Also,
Okay.
she's in DVD now, yeah.
Well, they're different logos.
Yeah.
Thank you, Judge.
Absolutely. Take care.
Just
mark.
On Jacobo, you got both at 5,002? Okay, let me just do bail orders on those real quick and then because I didn't do it, I forgot.
They reach out to the witness.
Sign it out.
Oh, wait, yeah. The wheel witness, Edinburgh was allegedly being assaulted.
Right. Yeah, hi, Michael. How are you, man?
I'm here, Mr. Quell Gani, Your Honor, GHANS. State still needs to rip the CW. We're set for plea.
Yeah, I mean, we're supposed to get this done today. It's 200 days old. Is he here?
He's here, Your Honor.
So Judge, there is two offers. There's a 30-day and the DWS that can defer, not defer, probation. Council's asking for a DWI first reduction. My chief said no. So the only thing missing is the wheel witness, and there's allegedly a person getting assaulted.
Yeah.
Which is why the person called for the DWI. So it was an assault that ended up being a DWI, and they haven't contacted that person either. So I was told by my chief to make sure to do that first. If we want.
But I'll set it for a week. It's 200 days old. But let's set it for a week. We'll have you come back in a week. We got to take care of it that day. All right? Okay.
That's your case.
Okay.
Or to, like, restricted one. My blood girl's name.
Judge,
On GHANS.
Jacobo,
Yeah.
he's on page 26 as well.
Yes.
So.
Right. Under Ramirez.
Yeah.
Yeah. So both at 5,002.
This girl's getting this one in his car. Okay. Yeah, there's some stuff. Got me realize he's drunk. Then it's a new investigation. We haven't talked to the person about. Or the person being assaulted, which I don't think we know their information, but we haven't had to deal with. And he wants a reduction of credit, that's a no. So I'm trying to see. We have any problems. With the case of. Keep them. Oh, we're gonna make it a second.
Can I just take pictures?
Are they dark reports? I've been on the recital. I mean, it could be.
He was surrounded.
He's a big guy. How old is he?
Yeah.
He's so tall.
Yeah, he's got an older brother.
How old is this tall? And it's not as tall?
Sure, I'm assuming they gave a little speech.
Oh, it's
It
so.
was like the kids.
I'm glad you got to go.
Yeah.
I'm gonna leave y'all.
That's sweet.
Yeah, today. I'm gonna go take my sister out to lunch. Just got here from Miami. Sorry, I think they're around.
Yeah.
Yeah, we're close. We're close.
Okay, just excuse me if you guys get it. You know, be fine.
William, nice you to show up, huh? Get in an 11 out at 1. In a 10 out of 1.
I've barely fit you all in my schedule, so.
I get it. Thank you for blessing us.
See his little Isaac Newton.
My 10-year-old did like a play, he was.
Nice, great. Yeah, I wouldn't miss it either. Never miss it. All right, who's next? Let's get out of here.
Judge, did you get Spark?
No, Sparks? Okay. 2501.
I don't think, I don't know, support, I don't know, I don't think the person being
Judge,
assaulted's name was on there.
For
I think she was in my.
attorney
Okay.
Whitney Moore, yesterday she approached on Rockville Williams about the no driving, removing the no driving, but we were waiting for her to provide proof of the insurance. I was wondering, she said she was gonna send it to the court, so I was wondering if you
I
all
haven't gotten
received
any.
anything over it, because I haven't heard that.
Nope.
Nothing so far, okay. I'll keep it on hold for now.
Okay, who's next? What?
What are we gonna do with Tom?
What's it now? Come up, Mr. Thomas. It's 5001.
Hey, Thomas.
Needs to be tested in 45 to 50 days again.
Oh, sorry.
You will get tested again in 45 to 50 days. If you test positive again, you know what's going to happen, right? Okay. I'll have you sign a reset and we'll get you out of here. No more, Mr. Thomas.
Yeah. Yeah, officer, they go this way, but it's more like it's on the same time. Okay. Yeah, I was like.
I think that's it. You have, it's you going, do you have anyone else in back? Everyone's gone? Nice, okay. What is your name? Last name? Apellido? Sure. Yeah. We'll have them, as you're going, we'll have them come up and sign a reset. We haven't talked to,
Judge, I will see you tomorrow.
Yeah,
I'm
have fun.
taking my sister to lunch. She just landed from Miami, so.
Nice.
I'm gonna go get her.
Have fun.
Thank you.
Take the day off. Who's the other guy?
Another one's,
I don't, okay, I guess we'll wait to see if the lawyers show up. If not, we'll, yeah, it's convenient.
I just sent an email to Michael Slatter to the office, so I don't know.
The other one is Reyes.
Yeah.
He's usually pretty good about showing up. Both of them are. I guess if you want to wait, maybe like half an hour.
Did they give you anything useful?
It was interesting to hear your perspective because they were came out of it being like, this is not gonna be a fair fight at all.
Really?
But that's like the point of these things with the guy, if you wanna under promise and then they'll get delivered.
Sure.
After that. So I could have thought one person will do it. They did not know the job something after the way that he. No, they did not know it.
I
So,
once had a jury told me that they didn't like the way I told them to pay about the city.
oh, really?
Except they didn't like it.
Yeah.
It's like, I had to focus on that. I was thinking, yeah, good, really, actually.
Yeah.
Do everything else, focus on this.
Yeah.
That's weird, they might,
Well, not after, his rebuttal on the puzzle.
well, he did the thing about mom losing her, or probable doubt for reasonable doubt. And that what the bubble's on, reasonable doubt.
Yeah, so he didn't come up with the trigger. He was trying to show that fairness and evidence is the lower things are gonna be on the.
Right, it's like a comment.
Yeah, no.
Usually get that thing.
When he was talking, he had specifically talked about the puzzle and stuff. We can't tell if the drugs are breathing, you can't tell if they're good. Yeah, they really ate that up.
He's pretty folksy. He's
Yeah.
got,
But it's still everything I'm doing, he's gonna tell it was my first trial, and then everything, I seem very online, it's been very vibe.
Sounds good. Yeah, that's the hard part.
Mhm.
We call them stuff. Bigger than two names you have.
Mhm.
Women across the.
Mhm. I want to.
Sure.
Here.
I think he's the night. You can like everybody.
Yeah.
I mean, it's not at the end of the day, but that's more practice of the fundamental part. Yeah.
Judge, how did you come to do felony docket? Like, was Court 5 always did that and when you took?
You mean the fugitive docket?
Yeah.
Yeah, when we were elected in 18, we basically divvied up who does what. Some people have sober court, some people have veterans court. We chose to do the fugitive docket as opposed to.
Okay, so you kind of like just, it could move to another court in
Sure.
the future. It's not like assigned to just.
Yeah,
Court
it
5
used to
court.
before I was elected, it used to be with Judge, what was his name? In Court 10, Ross. Ross handled it for like 20-something years. And then I took it. Ross went off the bench, retired, and then it went to Spute. Spute took it for a while. And then Spute lost the election in 18,
So Allen
or
County
16 or whatever it was, and then I took it. Huh?
Allen County automatically comes with fugitive as well.
Correct, right. We also get all the out-of-county cases, fugitive cases, out of states, so anything outside we get. So, and it doesn't add too much to the docket,
Who has
It's-
a veterans court?
Hmm?
Who has veterans court?
It was Judge Hughes, who now has left, and then I wanted to say Judge Baldwin. I think it may be Judge Baldwin, but I'm not too sure.
I was always curious, like, how that came to be, like, how it's.
Yeah, usually it's someone who has veteran experience, who's been in one of the arms of the service. They usually, are the ones who would take it.
Bring your computer. Okay.
Ramon, is there anything else?
No.
Okay, I think we're done. We'll wait just to see if those two lawyers come. Guys, we're done.
Perfect time, thank you.
Yeah. Are you going back to your kid or what?
All right, everybody. Hello, hello, hello. I'm back. Back home. Right on when they turn on the feed. They're already on the sidebar. Man, um that was a very good timing for me. Oh. Sorry, I had my phone still on with the feed. Lol. I made back right on time for the feed. I think they were waiting on me. What do you think? I think they were definitely. Are you still on the phone? Oh, okay, that's fine. No worries, Paula. We'll wait until closings are done and everything is done, so then I can open the package. I can't wait to open it. It's so excited. I have it here. I can turn on the camera for 2 seconds and show. Um, See, it's here. It's in my hand. The parcel is here. So, yeah, the parcel is here. I'm so excited. Obviously, for the parcel like opening, I'm gonna turn on the camera, but I'm trying like hiding all the personal information. Don't.
All right.
Yeah. Here we go, guys.
Is the state ready to proceed to closing?
Yes, sir.
Defense ready?
Yes, sir.
If the jury's ready, let's bring them in. Now, I am going to say, hey, Kyle, hold on.
Okay.
Sorry. Let me put this down here so y'all can hear me. Can everybody hear me? If there's any outbursts at any time during the state's closing, the defendant's closing, the state's rebuttal, I'll clear the whole courtroom. All right? Now we can. You've got exhibits 135 and 93 separated, right? 93 also? Yes. Okay.
I need exhibit number 183. It's a video.
It's bad when it's one of the security officers. Huh?
My blood sugar alone. Get rid of all high. Everyone stand, please.
I am so excited. We are going to hit the closings. We're gonna hit the closings. Yeah, but we are gonna get there. Don't worry. We're gonna do this. We can do this, Toxic. We are closing to this trial. Finally, we can do this.
You may be seated. Thank you.
All right, General, you may.
I'm going to leave this up if that's okay, Your Honor. Thank you. So we've finally reached the point in trial for closing arguments. And what this essentially means is it's an opportunity for the state of Tennessee to go through, talk about the evidence a little bit, reflect on some of the witnesses, because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6, it covers the burden of proof. And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay? My handwriting's not the best, though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. It might be on that same page. Probably should have written it. Here it is, page 5. In your instructions, in the second paragraph, it states, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. He kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, but the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, John.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also commit mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you. Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case. Mr. Scott brought up the theory of an accident, or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence, tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the chicken shack, to December 8th. Evelyn Boswell's 12-month well visit. Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows. And Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse, I can't remember what it was, as to why she couldn't bring her. So they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by. Because I know that's a question we have all had. 2.5 months goes by. 2.5 months. But now we know. We know why. Because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But, time continues to pass, and you've heard witnesses, in particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think that something doesn't feel right. It just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day, and Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood, and Megan Boswell's there, but there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory box. Now, why would you call something a memory box if you are alleging that your child is still alive? This is all Megan Boswell had of Evelyn in that house that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger, not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house. I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back, I'm trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy. And so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. Mr. Scott wants you to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell, because she would not go to school. She went to foster care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with Omami, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell, the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell. And I'll submit to you that Hunter Wood, the person that they would like to blame somehow, is also a victim of Megan Boswell. She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different. Then she goes to her mom. She blames her mom, her own mother. She's willing to blame all the time knowing. I mean, we know, let's find the picture. We know where Evelyn was. You see Evelyn? That's where Evelyn was. There she is. Evelyn Boswell sat there in that trash can for 2.5 months. And her mom discarded her, not just Evelyn, but everything that was associated with Evelyn. Everything. Because she didn't need it anymore. Everything. She didn't need that stroller anymore, so she left it behind. She didn't need the clothing. Do you remember all the pictures that came in and all of that stuff that was in that shed? Because she didn't need it anymore, because she knew where Evelyn was. The defense wants you to believe that Hunter Wood is the one that backed Megan's car up to that shed in the middle of the day. In the middle of the day, Hunter's just going to go over there. He has a truck. The testimony was that Hunter had a big truck. Now, why in the world, if he had a truck? I mean, this clearly took more than one trip. I guarantee you. Look at all this stuff. They want you to believe that Hunter Wood backed Megan Boswell's car up to that shed that day. Tommy came home. It was in the middle of the day. Where's the diagram? Do you remember the diagram of the scene? Look at this diagram. They somehow want you to believe that Hunter Wood pulls up this driveway and comes to this shed right here, right in front of Omani's house. Tommy's house up on the hill in the middle of the day. Is that reasonable? What is reasonable? How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed, because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Omami's house. And so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. It's Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind, the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And it's not a very nice statement to begin with, but it's definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand and you heard Megan Boswell admit that she knew Evelyn was dead. She's telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, what's your point? What's your point? And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment? And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with, because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with them. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. Think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life, as if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she sat here when she's picking out furniture for their new house? But she's sad today. She has the gall to sit here and cry today and pretend she can't look at the pictures of what she did to her child. What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can. She's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing, still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things? You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA. Let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you can look at them when you get back there and then dispose of them in the same trash can that the baby's in? That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell, that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture of DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory, or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please? Thank you. Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Of course, he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it under the rim? Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag? Megan Boswell's fingerprints. And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag. And it was forcefully pushed down. Compressed, I think is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag. Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on that foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash. Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if a child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malushnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide. that Evelyn Boswell died from some sort of asphyxiation. So suffocation, I guess, is the easiest way to say it. So if it was not for, say, the position of her body upside down in the trash can, that could have killed her. Well, say it wasn't that. Then maybe it was the blanket that was pulled up over. Remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can. Could have also been the trash bag that she was placed inside of, where she was unable to breathe. Could have been the foil that was wrapped around her head. Could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve to where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body down into the trash can. Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil on her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count one, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser included offenses, and we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these. Again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form. The state has to prove several elements for each charge, and those are also in your packet. Count one is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil, or premeditation in the time that she put her in that trash bag, or premeditation in the time that she pushed the next trash bag on top of her body. Ladies and gentlemen, I submit to you, there is nothing about this case that is not premeditated. Count two and count three are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. We submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can, that's neglect. Leaving her in the trash can, that's abuse, and it resulted in her death, which is felony murder. And we have to prove that the child is under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. And if you remember, the defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her. You heard from the witnessing, there were people that she could have given Evelyn to that would have given her a beautiful life. But instead, she violently murdered her daughter. She told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you the state has proven every count and every element of every count beyond a reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you, General. Mr. Scott, you may close.
Good afternoon. I appreciate y'all's time. Appreciate you being here. Although I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case. And Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. Jury instructions will tell you that this case is not about your emotion. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute. But the state seems to be putting forth a theory that you should convict her of first-degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also technically would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page for page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well checks. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect. We heard from Audrey Gibbs. She'd been with Megan almost every day up until she moved to Knoxville in 2019. She describes Megan as a good mom. There were a few things. There was once where she had thought her diaper needed to be changed. Once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville at the end of December sometime, and by that point she acts disassociated. She's not normal. She's saying "I love you" over and over again to her. So, again, maybe she's not grieving right. Bailey Hawkins stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things. They might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did it. There's a video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about a home life? Watch the video with Agent Fraley. Her mom was let in there in stripes, a jail uniform. What kind of home life was that? Then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name is, I can't remember his name honestly, but it's the mother of his ex-boyfriend. She described Megan as a good mother. Evelyn was always clean. And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out of anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso till I see his car in the parking lot, pull in. That's not what happened. I think he kind of wanted you to think that, but that's not what happened. Let's talk about Randy Wood. Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunter Wood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massagill wants you to think I have some grand conspiracy theory. I don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swallowed her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible. Why did Hunter not give his DNA? Ask yourself that. If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they had? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he said, yeah, he talks about some off-the-wall stuff. Now, ask yourself, who's more likely to wrap that child in tinfoil? The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic? And I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. And the young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Smith and Dr. Malusnik. Now, Dr. Smith asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And the diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what they want, what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malusnik, I didn't ask about something that didn't exist. Dr. Smith knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive or dead. She couldn't say that. She brought up that the child had a heart valve that leaked. She admitted under cross-examination that that could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massagill brought up that I brought up tongue tie. I brought up tongue tie. I brought up GERD. I brought up an infection she had because all of those things can lead to the onset of SIDS. That's the research, and Dr. Smith agreed with that. Now, I want to tell you something about Dr. Smith and Dr. Malusnik. I think Dr. Smith she was the medical examiner in Johnson City when this happened. Dr. Malusnik is not her boss. She's not, it's not like she's somehow over her. Dr. Smith was the chief medical examiner at Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malusnik for another opinion. Dr. Malusnik only reviewed her report, and she finds that it's a good report. But then she wants to go further and find with some type of certainty that that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, Doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened. She was being content that she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left. And suggest to you the more accuracy of that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear she could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. Malusnik come in with a preconceived notion That's what happened. Now, the state has to prove to you cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Schmidt leaves open a heart, it leaves open SIDS, laryngeal convulsion, it leaves open all of those things. We don't know what happened. It also left open a rollover, which is what Megan told Agent Fraser. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble. And that's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No, it's not. Should she have called and reported? She absolutely should have. I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point. That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how they grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up. She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought two medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about it. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, Why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness. Now, let's talk about the tinfoil. How could her one fingerprint be on a piece of tinfoil? You all see this roll? Maybe like this. Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way. What's another possible way? We've heard that the tinfoil had food and debris on it. So there's food and debris in the trash can. But like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it. One fingerprint. One fingerprint. It doesn't prove she put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen. Your DNA is all over the house. Your finger, I said DNA, actually fingerprint. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think that's what you should consider. I mean, probably Evelyn's handprint on the trash can. At some point, I think in opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's the child's. Now, Ms. Massengill made a statement. I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint experts say they can. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement of Agent Fraley. February the 25th. She's talked to law enforcement over and over. And she talks about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's. It could be at Tommy's. Why would you say, if you're trying to lie to them, perpetuate this lie like Ms. Massengill tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's telling them where the baby is. She thinks, I think it could have been left one of these 2 places because I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case to you. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven the cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some rolling over in the bed being an accident, or some kind of health-related issue. They haven't proved that. let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Massengill talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look through your notes, TBI cut those gloves up for testing. I could be wrong, but I think that's the case. Now, what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter. And it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at those texts, they're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child, but I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to have proof that you didn't do something, if you start a conversation, start texting it, say, oh no, I didn't do that. Look at my text. I texted her, she's told me this. It's a convenient thing for him. But he didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document admitted this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your questions. I hope my argument has helped you somehow with this case. But what I would say to you, if you have questions about any of the elements of this crime, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt on this homicide count. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons, and I'm used to it. I think I've been up here for about a half an hour, but I thank you. I pray you'll come to the right decision. Thank you.
Thank you, Mr. Scott. General, you may close on behalf of the state.
Thank you, Judge. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends, every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, you could, that was the point, which she decided, hey, I'm going to be truthful here. No, no, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. So they're the ones who suggested it. And then very conveniently, the next day, she comes in, and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected it. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this just pattern of just totally bizarre behavior that involves wrapping her child in a blanket, tightly pressing her head in aluminum foil and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence isn't it? That all this occurs at the same time that she starts working at the chicken shack. And then she meets Hunter Wood. You know, that Hunter Wood, the one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. There's other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. When did Ethan Perry step up? I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common sense in asking yourselves why. Why would Megan Boswell then start on December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December 7th. Remember, she starts Chicken Shack the 2nd, 7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have it. Evelyn's sick. She's got the flu. I can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend Bailey Hawkins told you, I mean, yeah, she wasn't a perfect mom, but she did well. She did well. They all did. I mean, she's posting pictures on Facebook, Instagram. Everybody. Her own pediatrician, Dr. Pugh, came in here. Yeah. She's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, that's an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her. She won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Why? Apply your common sense. She won't do it because she can't face the truth about what she's done. She can't face that truth. She can't look at that picture. And I'm not going to put it back up there for you. She can't face what she's done to that child. Discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting that out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one. And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand and said, oh yeah, I remember when I saw Hunter and Evelyn and Megan together? I remember when I saw that. None. Nobody said that. How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No. Again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember? But that's what she wants you to believe. When her breaking point, when she's finally telling the truth. Apply your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed? Or maybe it's the playhouse over on Tommy's property. No. Again, we know Evelyn is probably gone 5 days after she first met Hunter from working at the chicken shack. But Megan Boswell wants you to believe that he's been able to go onto her and stick a body in a trash can in a playhouse that was built for Megan Boswell. Mr. Scott asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here, and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier, and in doing that, she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension that we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it. Maybe that's why. And again, in this particular case, you heard from Agent Gray, what does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her, that she analyzed, not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. As I remember, I asked her if I gave everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter Wood. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things that medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just 2 doctors about Evelyn's condition, about what kind of a child she was. You heard from 3 doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No, her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern, not Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who died in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet they want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently, the first one. No, it's not a possibility. You decide this case on the evidence that you've heard, the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners said this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. All the evidence in this case points to one person alone as being the person who caused that asphyxiation. And that is Megan Boswell. This wasn't an accident, ladies and gentlemen. It wasn't an accident at all. You've got lots of evidence of premeditation sitting over there in that box. This isn't a little piece of tinfoil. This isn't foil like you stick around a baked potato and stick in the oven. You saw it. You saw the photographs, and the foil's in there. Pull it out. It's a big old piece of foil. Mr. Scott wants to suggest maybe it's sitting down in the trash can, somebody pulled it out. Nobody's using that much foil. Use your common sense. And remember the testimony from Dr. Malusnik yesterday about how that foil was applied. That blanket, so tight when they're taking it off, the impressions left on that child's face. The foil, how painstakingly slow they had to pull it off because it was tightly compressed around the child's head. I submit to you, that's premeditation, ladies and gentlemen. That's intent. That's not an accident. Part of this case, ladies and gentlemen, that as Mr. Scott said, is really, sad. It really is. It's a tragedy. You think about all those people that you heard testify, how easily all of this could have been avoided. All those people, Bailey Hawkins, Audrey Gibbs, Casey Saltz, Gail Kite, Paul Miller, Erica Stacy. Any one of those people would have taken that child. All this could have been avoided. But Megan Boswell only cares about one person, and that's Megan Boswell. She started a facade back first week of December after she killed her child. She created this world, this web, you've heard it called. And that's a pretty good description of it. It's a web. It traps and ensnares everybody that she comes into contact with. She started this facade back then, and it's continued and continued and continued. And she brought it into here to this courtroom in front of you. And she's trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It's an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could be Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium, Super Bowl party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there, Detective Faraz, the James Lewis interview. She acted all surprised. What are y'all going to do? You going to find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions, for her decision to get rid of Evelyn, to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell is guilty. First-degree murder, false report, tampering with evidence, and failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, John. Thank you, City Attorneys. Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. Just leave them in the seat. That'd be fine. And your notes as well. We'll just take care of them. The rest, what do you mean? Yeah, I'm going to finish the charge. All right. Now, back on page 49. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. Take with you the presentment, the exhibits, the verdict forms, the court's written instructions, and you may retire and consider your verdict as soon as the officer comes back to get you.
Everyone stand, please.
3:05 p.m.
Take the ones that you have. Just
Right.
the three.
Leave the others.
Don't worry about the ones that belong.
Whenever you see it, thank you. All right, we'll be in recess, waiting verdict of the jury.
All right. We are officially on verdict watch, guys. Clock is back up and is ticking, and we are on verdict watch. So now, has come the time that you all been waiting for. I'm gonna try to see if I can do this. Oh, but if I put myself big on the screen, you guys cannot see the clock. Hang on. Let's go back to this one and let's edit. So, and I'll put myself rather big. Okay, I think that should be big enough for you all to see. Okay, right. I think I am all right. I think camera ready. Nightbot is just bringing me the box. Tun tun tun. The other way around.
I'm gonna go on camera.
I am, and the mic is on.
Yeah, no mic is on.
So I'm gonna turn off the camera just to be aware. Hello. So I've got the box here. I hope everyone can see. Can I have the knife? Try not to stabby
I've
myself.
got to kneel down to be on the same level as you.
Yeah, Nightbot is nearly
You
down.
need to go full screen. You need to go full screen. Somebody will say
No, I don't want to go full screen, but okay, I'm full screen. Yes, the package time. It's the parcel time. So opening up. I'm gonna try not to stab myself.
or me.
Or Nightbot. You might be witnesses in another living. You don't know.
They can all go to pub.
Yeah, in the UK, because that is interesting. Trying to see if the camera will see. Okay, we've got a bunch of this thing
Lovely
to
packaging.
protect. So that is very well protected. More wrapping things. Ooh, I can see things. The verdict clock is still going. It will be back on the screen soon. Still more things. Ooh. Hey, no! No. Nightbot is already saying what it is, but I'm trying. Oh, I know what it
I
is.
have a little bit of a guess.
That's what I wanted from there. Can you put?
Is it Taylor Swift addict?
I am a Taylor Swift addict. Sorry, this thing keeps making. I think I'm gonna put on the Nightbot's head. Nightbot is in jail now. It is so exciting, but there's something else. Hang on. Ooh, there's two things. Ooh, it's like a box that keeps on giving. So let's get rid of this box. And let's open.
I want to know what it is.
Is this what I'm thinking it is? Paula? Hang on, I need to take my headphones off because the headphones are. There's like stuff in. What? Hang on.
I think this is going to be your background.
I'll get demonetized so fast.
Yeah.
Another packaging. What is this?
Oh dear. Well, let me hang it out behind you.
It is awesome. I love it. Oh, sorry. It's
I'll only show it for a second because then.
Yeah. That is awesome. And then there's a card. Thank you, Paula. I will read it in privately. So I'm not gonna read it on stream. But thank you very much, Paula. Like I really appreciate it. Sorry, I am a big fan of Taylor Swift. I have her merch, wearing a merch behind this. So the book it's about the Eras Tour, Taylor Swift's The Eras Tour. So yeah, that says, oh, it's not a card. Ooh, I'm gonna open it. So it's a book about the tour that she did for the past 2 years. So and it's was available only in America. So I kind of. Oh, I will keep that. So, Paula, let me have a look. Oh, I'm gonna cry on stream, so I'm gonna definitely read off stream because it's gonna make me cry again. But Paul, I really appreciate it. Thank you, thank you, thank you. Yeah, cue the tears. I'm gonna cry. What else is new? Me crying on stream. And sorry, my hair is all over the place. Oh, Paul, are you gonna make me cry on stream again? What else is new? I am overheating because the Nightbot did a hot chocolate, and I am overheating. But Pickles, just go a few minutes again. But basically, is hang on, I'm grabbing the book. I cannot wait to read this. It's the Taylor Swift Eras book. I am a Taylor Swift fan, so Paula very gracefully got it for me. Obviously, we talked about it, and then it had a big, massive. What do you call this?
It's like a memorial thing.
It's like a blanket almost type thing about the era store as well, and then something that Paula included on it. I am a Swiftie. Yes, I am very proud to be a Swiftie. I like it. I literally the concert that I went on Friday night was a fake Taylor Swift concert, so it's like a tribute. So and yeah, so thank you very much, Paula. You are amazing. Thank you very much. Sending you a big massive virtual hug right now. And yeah, thank you, and I'm gonna cry, so after the stream, obviously. So I'm gonna go back to be a tiny person on the screen because we've got a lot to cover. Where is it? There we go. Well, I need to be smaller than this because now we are going to be looking at what Willow did for us. So she did a PDF type thing, a presentation, sorry, about the timeline of the case. Very interesting and very good. I was already had a look into through it. So I am gonna stop the screen sharing. I still have the feed up, so as soon as they come, it will be there, and I'm gonna share that again. Paula, thank you very much. I really definitely worth the wait. 100%. I like absolutely worth the wait. Yeah, I wouldn't have waited longer if I had to, which it would be absolutely fine. But it's very thoughtful. Very thank you, and a million thank yous, million thousands of thank yous. I really appreciate it. So on the screen now, there is the presentation that Willow did very graceful for us. Willow Moss True Crime, our amazing friend. That's basically a timeline of the case that we are on deliberations for. So we have, the accused Megan, and then we have our victim, little Evelyn, such a cutie pie, and let's go through it. So on the 21st of March 2001, Megan is born. And then she had a childhood and everything. Then in 2014 to 2017, Megan dates Ethan Perry while in high school. And then in July 2018, a year after they did Ethan, she goes on a trip while pregnant with Evelyn. So right there, I think that like it tells me that Ethan straight away it's not that. But anyway. Then 2018 in 2019, Megan is in foster care, was placed with Kai Guide for 4 months. And then she was, I think, 7 months pregnant at that time, because I remember that she's saying that during the trial. Oh, hang on, I'm gonna just turn off my camera for now, but thank you very much. And then on the 28th of the 11th 2018, Evelyn Boswell is born to Megan Boswell and a still unknown father. So she was born around Thanksgiving time, because 28th of 11 of 2018 yeah, the Thanksgiving in 2019 was on the 28th of 11. So Evelyn was born around Thanksgiving time. So Megan got pregnant around Valentine's Day, because baby's born in November, right? Am I doing the maths correctly about that? Um, I hope I am. Then 2018 of the 5th, 2019, that we have the picture of little Evan, such a cutie baby girl. Then in 2019, she dated Caleb for 2 to 3 months. And then in 2019 again, she had another picture with Megan and Evelyn. Um, and then he has the Bruce. I don't know if you guys can see. I can zoom in a bit more, but here is the big bruise on Evelyn's head, which it's kind of normal for babies to have bruises. It's not like I would be like worried about it, but yeah, a bruise on the head is can be a red flag. I'm not gonna lie, um, but yeah. Sorry, I thought I was gonna needed to write, so that was at 3. Deliberation started at 3:08 EST. So I was just writing that for tomorrow. Then Megan on the 1st of the 11th 2019 begins texting a lot. Ethan, I can't say that word, over 12 times a day with updates and images of Evelyn. And then again, see, 28th of the 11th 2019 was Thanksgiving. It was last in-person sighting of Evelyn by her grandfather, Tommy Boswell. Then on the 30th of November, Megan sends the Ethan the last weekend picture. She will try to claim to be a new image. Oh, so it wasn't there. Sure. Okay, all right, that's a good detail, Willow. Then in December the 2nd, she started the Hunters working at the Hunters Tea Chicken Shack. So and Megan is an employee. Then on the 3rd of the 12th of December, Megan ceases to excessively message Ethan Perry with images and updates of little Evelyn. No new images of Evelyn were taken or found on any of Megan's devices. No new images were posted or found on her social media accounts either. So basically, she was just reusing whatever she had. Then that teaches me that she was Ethan was not the father, because if Ethan was the dad, you would be kind of present around that time, and you probably already had those pictures that Megan was sending to him. But anyway, then on December the 7th was the last credible supposed in-person sighting of Evelyn. I think was the babysitter, and then the day after, on the 8th of December, the stories begin. Megan messaged Haley Spiro and states her dad, meaning Ethan, had her. So she starts with Ethan having her, not her mom being crazy. But then she goes back to that. But to that. So on the 9th of December, Megan begins dating Preston Hunterwood, only referred to Hunterwood during the case. And then between the 14th of December and the 16th of December, Megan claims to have called her biological mom, Angela Boswell, to take Evelyn after she picks her up from Sue, the babysitter. So this is where she has 2 lies ongoing. One that she's saying that it's with Ethan to her friends, and then another one that Angela had her. Okay, so on the 18th of December, Megan and Alexia are messaging with Alexia, being told that the child's father, meaning again Ethan Perry, took her from me. So she literally had 2 lies ongoing at the same time. Y'all, that's crazy. So then on January 2020, Bailey Hawkins, the one of the friends who testified at the trial, receives a message from Megan with an image showing herself and Hunterwood visiting a place blowing rock And she captioned imagine such. So this image, right? It was used during the trial, and it was shown that Megan, the mom, and Hunter, right? They went to this place, blowing rock. Yeah, blowing rock, having a good day trip. So if the mom indeed had Evelyn, it would have make a lot of sense of Angela taking the baby to this trip, but yet the baby wasn't there. We all know the baby wasn't there and why it wasn't there, because sadly she was unalive at that time. But her lie was so inconsistent. Oh no, why are you apologizing, Willow? It's absolutely fine. You did amazing. This is amazing, girl. Absolutely not. You don't have anything to apologize for. You did amazing. I'm loving this. I'm just like trying to give a bit of more context because you cannot write everything in here, otherwise it would be an essay. So it's absolutely amazing. This is amazing, Willow. So like it just did not make sense, that lie that she said to Bailey, because how can her mom have the kid right at this time, and yet they're going on a trip and your kid is missing, right? Your kid is missing, you are worried and everything, and yet you go on a trip. I'm sorry, no. I would cancel all my plans to try to find my kid. um so I like, this is absolutely crazy, that like the fact that uh, she went on the trip while her kid was missing. I'm like, that's just crazy. Anyway, moving on. Um, the same day, on the 20th of January, Megan is asked by Chris Hall how little Evelyn is doing, which she answers by stating, "Good, mean as everything, and she hates me." But then Megan on the 16th of February, so 16th of February was already when the police and the TBI and everyone was already sniffing around that Megan was lying, that this was all a ruse. And then was around the same time that Tommy Boswell um said that Evelyn was missing and he hasn't seen her for ages. So around that time, she posted on Instagram that says on here, an image of Hunter Wood posing in front of a house with the caption, "So excited for our new home." Second of all, there is no way, I don't think she and Hunter could afford a house like this. Sorry, excuse me. I mean, and again, it goes to the oh, that's your birthday. Oh, 16th of February. That's pretty soon, case one. Um, so what I was gonna say is, so your baby is missing, right? You're very concerned about it. You're doing TV interviews and everything about that, but yet you are house shopping and furniture shopping. Excuse me. How does like um how does like this absolutely have any sense? It doesn't, because then again on the 17th, the day after they go out to see the house, they go pick up furniture. um how can you like literally be worried, like even if like your mom at this point, right? Either your mom had the baby or Ethan had the baby and you were fighting for custody. How do you really have that patience and mental ability to go furniture shop and house shopping and going on trips and going this? I would be fighting for my kid. I would literally be looking around the earth for it, not going on trips and having fun and taking picture. Then on the 18th of February, Shirley Lowry is arguing with Megan. Megan states that she's unable to bring Evelyn over as Ethan had her, wouldn't let her pick her up, and that they have court in the morning for custody and visitation arrangements. She sent Shirley, that's a tongue twister, a picture of herself and Evelyn, which she has captioned last weekend. That was the um that image from before. Let me see if I can find her again. Oh, I went too far. as always. I don't know what to do this. So basically, it was not a new image. DC has contacted the law enforcement that they had any contact with Evelyn in around 2 months. And then Megan again posts on Instagram featuring Hunter posing in front of a truck caption New 2020 High Country. So yet again, Megan is posting a photo of Hunter in front of a car. And like, how can, like, again, he goes to the states that if your kid is missing, why are you doing? Absolutely. Oh no, like you, Willow, you were amazing. So then on the 19th of February of 2020, the Amber Alert is activated for Evelyn Boswell, which there's the Facebook post about it from the TBI, the Tennessee Bureau of Investigation, with the little cute pictures. Then on the 20th of February, and this was the date, right, 20th, that we know that Megan voluntarily went into the police station to talk to investigators, and that had the interview where basically the investigators called her a liar at the end of it. I think it was this one, wasn't it? Was one of them too, but I know. So a red Chevy on that day was tested for evidence like Red Sea thing in Middlesbrough, Kentucky. Oh, so we are in Kentucky now. Then, in the next day, a third interview with David Grant and Matthew Price. 40 some people are searching for Evelyn. Hunter enters her life. Evelyn goes missing. She is also interviewed on that same day by WCIB TV news station and Keith Weiss. And then it has that interview exactly on the 22nd of February. Christian Arnett is urging Megan to be honest, which she answers by stating that she's 100% honest and scared of the person who took her. So she basically is scared of herself. Okay. Then Hunter Wood is asked to bring Megan a change of clothes and tells him that the TBI is in North Carolina with her biological mother, Angela Boswell, who does not have Evelyn with her. She also says that she hopes they can get the truth out of my mom and bring my baby back to me. Right. So now, this is where Angela and William McLeod were arrested because they got found spitting on 35 zone, and I think they were going at 50 something, and they were driving the car that supposedly Megan got repoed back in December, because when she started working at the chicken shack, she had a car that get given her. I think it was a BMW, a silver gray BMW. And then at some point in December, the car got repoed, and I'm doing air quotes, um, because that's how she met Hunter. Because the dad, because she was pregnant, she had doctor's appointments or whatever, and Hunter's dad felt bad, so he asked Hunter to drive Megan to the doctor's, right? And that's how Megan and Hunter started dating and started talking. So that's how that came about. And then on the 23rd of the 2nd of February and to the early of 24th, Megan is interviewed again by the TBI Assistant Special Agent Christopher Wilhoy. That name reminds me of the cookies, Chips Ahoy. Sorry, just my remarkable. And then again, I think outside when she leaves the interview, or even before, because she was outside of the police station. She was interviewed by WJHL news station, one of the feeds that we've been having. Yeah. So this is really awesome. I'm loving it. Then on the 28th of February, the mobile home on 962 Sugar Hollow Road. This was the uh was this Megan's trailer, Willow? The one on the 28th of February. I'm just interesting. So probably gonna wait for that. Oh, it's been almost a half an hour of deliberations. So yeah, jury has like 10 minutes to come. No, I'm joking. I need to start hunting down the feeds because I'm just waiting to see if Willow replies to me to my question. I'm asking if the mobile. If you don't know, it's fine. I don't want to put you on the spot. It's absolutely fine. Now I'm in the wrong feed. I want the other one. Though. Where is it? There we go. So just hunting the fade just to make sure, because sometimes they do say some stuff on the chat if like questions or anything, so I like to keep an eye out. So continuing on the 6th of March of 2020, Evelyn Boswell is found. So she was found in a playhouse in the granddad's property of Tommy. Like, so this was Tommy Boswell's property. So on the back of the house, there was a playhouse that he had built for Megan, I think, when she was little. So, and obviously it hasn't been used in a very long time because the decay and everything. And sadly, that's where Evelyn body was found, inside of the white trash bag. So hang on, correct, that was the one she moved out. Oh yeah, okay, thank you. That was so the mobile home that was investigated on at the end of February was the one that we heard and saw pictures of, that had very terrible like mess. And good thing that smell-o-vision has not been invented. And yeah, so Evelyn Boswell was declared deceased on the 6th of the 3rd, 2020. So in March, the when they were body was found. She was born on the 28th of November of 2018. So then we'll jump until May of 2021. On the 10th of May 2021, the print from Megan's left middle finger was found in one of the pieces of foil used on Evelyn's head, as well as stuffed. I did not know about that detail. Oh, so are is she really telling us that the piece of foil that was stuffed inside of her mouth was there by accident? Megan, just go away and be locked up forever. Then on the 22nd of the 10th, 2021, a tissue testing report was filed showing it was drenched in Megan's Boswell DNA. It was found in the same trash can as little Evelyn's body. Then on the same day, on the 22nd of the 10th, Megan's prints from right middle finger as well as ring finger are found on the black trash bag which contained Evelyn's Boswell's body. And now on the 5th, and then there was another couple things. I think there was on the September 2022 there was a hearing from the medical examiner that we listened yesterday at the end of the trial, the one that did the mic drop at the end. And then Megan was officially charged with first degree unaliving in the case of her daughter. So obviously all the credit goes to Willow Moss. She was literally, make sure you guys follow her blog. It is amazing, absolutely great. Check it out. There's the link, the name of it. I'm gonna see if I can copy to the chat. So thank you very much, Willow. I really appreciate that. It is absolutely amazing, girl. You, I'm very well impressed. You did amazing. You couldn't do any better because that is great. So yeah, so that's the kind of like the timeline out of the case in a simplified half an hour version of the case. It's just crazy. This girl thinks that actually she can get away with it. um why am I on YouTube Music? I don't want to be on YouTube Music. I want videos. Thank you. Thank you, YouTube, for granting me this. So now what we're gonna do? Judge Boyd is still on the trial, so sadly we can't go on there. But I want to go somewhere that we're gonna, guess what? We're gonna do some parole hearings. We might finish the one that we were doing earlier. Just carry on that one. And what I'm gonna do is, I am beyond exhausted and I had a very emotional day. I am gonna leave the parole hearings and swap places with Nightbot, and I am gonna go to bed. So again, I thank you very much, Willow. I appreciate it so much. But yeah, so it came the time that I'm gonna go to the bed. And what I'm gonna do is I'm gonna leave you with Nightbot. Yes, I'm gonna go to bed with Taylor Swift, and Nightbot is gonna be very jealous. That is very, very, very true. Ooh, are you posting the link, or are you? You can post the link if you want to. I don't think do I have it. Let me have a look, because I did get an email. Did I get an email, or was I dreaming? My days, my brain is so out of it that I think I'm already dreaming. Hang on, let me. Yes, I do. So I will. Yeah, it's okay. I've got the link. I will post the link in chat for the direct for the blog. So I'm gonna copy the link, then going into the chat. 1 second. Doing this on the fly. So there we go. I've got it. Thank you very much. Make sure you check it out. That for our lovely friend Willow, and I will definitely be reading that. It is a very, very detailed of the trial, which is amazing. Oh my days, this is awesome. That is very, very good. So there's the link. I just need to set up things for Nightbot, so making sure that it is set up for success. Otherwise he can just grab me anyway. Because I did told them that if the verdict comes at a reasonable time before they decide to break for the day or something, I am gonna come back, because I want to watch this thing. Is this correctly? No, I don't think it is. Yeah, hang on, I did something wrong. Of course I did something wrong. There we go, that's much better. Oh yeah, no worries. I have your blog now bookmarked on my phone. That is for sure. So I'm gonna put the rest of the the verification hearings that we were watching earlier, and then I'm gonna leave. Nightbot knows what to do. You can just play whatever another one that is that is a bit longer. Right there, but I'm gonna turn off the mic for 2 seconds, and then it will come on. I don't know, it might turn on the camera. I don't know. I don't know what is he gonna do or not, but you might be able to see the cutie pie. But give me just a minute to give him some instructions, and I'll be right back. Oh, I know. I've been on the Discord that's been updating that, and I'm probably gonna be watching that on catch up like everything else, because I want to go to bed and I want to try to sleep, because I am a little bit tired. But for sure, I absolutely want to watch that too, Lois. We'll try to see if there's a verdict, people not here, try to send a notification or something. I need to work on that. But anyway, I'm gonna stop talking. Swap places with so with Nightbot, and if I don't come back tomorrow if I don't come back today, I'll see y'all tomorrow. Normal time, because I think if we don't, we're gonna be just on verdict watch. And then we're gonna do some stuff. I don't know what we're gonna do. I'm still haven't thinking about that. I don't think my brain is working that well to think that far ahead. But I'm gonna love you and leave you, y'all, and I'll see you tomorrow if I don't come back for a verdict.
So you're pleading not guilty, but really you're guilty of not reporting because you didn't have one. So
It's all based on one thing that I didn't report, and I didn't know I had to, sir.
okay.
I just spent 37 years in prison. I lost my mother, my father, my stepfather, my uncles, and my cousins, and everything while I was in prison. When I got out, I was homeless. They literally put me out on the streets. They took me to a halfway house and dropped me off.
Okay. All right. I understand that. Were you arrested in April of 23?
Yes, sir.
You got out 22. You were arrested in April of 23. Tell me about that charge.
It was a simple fight. I got into a fight with a guy. He attacked me, and he chose not to pursue that because he knew he was in the wrong. He attacked me, and I defended myself. That's all it was. And they dismissed the charges. That's why I said, about a parole hold. I was in jail for Friday, Saturday, and Sunday and Monday. I went to court Monday morning. They gave me OR bond. I walked out. In other words, no parole hold on me. I didn't have no idea there was a parole anywhere on me. I didn't know I was on parole.
Okay.
I went to the parole board in 2045. I was I went to parole board at 2045 sentence, right? 25 years, 20 years in, 45 years of age, and I was denied parole. 2 years later, they discharged me. And they let me go to a detainer. They extradited me back to Ohio, and I spent 15 more years in prison. I discharged that number. They released me. They released me homeless, broke, with nothing, with a bag with about pounds worth of stuff that I had in my possession. It was my own life right there. I said my mother passed away, my father passed away, my stepfather passed away while I was in prison. And I lost uncles and cousins. I didn't know nothing about being on parole. Surely would have reported if I knew. Because
Okay, if we don't revoke your parole, what are you gonna do here in Louisiana?
I'm not from Louisiana, sir. I'm from Ohio. My life is in Ohio. I have a fiance in Ohio. I have an apartment in Ohio. I have furniture that I've accumulated. You know, I have a life in Ohio. That's where I live. So I grew up. Lived all my life there.
I thought when you got out, you didn't have anything. You just had.
I've been out since 22, and I accumulated some certain items. And I went through LMH, which is Lucas County Metropolitan Housing, and was awarded an apartment. And I was taking care of that. I was getting this and that together, and I was amassing a life. You gotta remember, I've been in prison all these years. I never had nothing, so I had to start all over again. And I was just in the process of doing that.
Okay, that's where I was confused. I thought you were homeless and out of
I
everything.
was.
And I understand you would when you first got out, but you've accumulated some things. And your home now, your home is in Ohio, correct?
Yes, sir.
You going back to Ohio if you don't get revoked, is that correct?
Yes, sir. I would love to as well. My fiance is waiting on me. She has a bus ticket ready for me.
About your wife?
And my fiance, she's not my wife yet. She will be.
Okay. All right, and let's see, you gonna get out if we revoke you gonna get out in a year and a half anyway, right?
Yes, sir. Yes, sir. Listen, I didn't know I was supposed to be on parole. I didn't know nothing about it. Never signed no paper saying I was on parole. That nothing. I had no idea that I was on parole because I would be reported to a month right now on probation, on unsupervised probation.
Okay.
So, next year.
All right. Do y'all have any questions?
I do.
Yes.
Yeah, you got us in a bond here, okay? So if we don't revoke you, you got to do interstate compact to go back to Ohio.
Yes, sir.
And I don't know what the rules are in Ohio, but if she's your fiance, odds are they may not accept it because you're not kin to them and it's not immediate family. If we turn you loose and can't go back to Ohio, what you gonna do? I mean, you gonna be back on the streets?
Contact with Mr. Rogers here, Terry Rogers, who runs a Silver Living House, and trying to get established there if need be, where I could stay somewhere until I could get a job and get an apartment, or do something until I get my paper, my parole transfer to Ohio. I'm a
And
resident.
how old are you?
Excuse me?
How old are you?
I'll be, in 2 days, I'll be 65.
Okay. I have further questions.
I was in the process of getting my Social Security disability. I have COPD, I have diabetes, I have AMD, which is age-related macular degeneration. Basically, I'm a bad health.
Can you draw regular Social Security? Do you draw Social?
And
do you draw any Social Security now?
I was in the process of doing that when I got ended up on this.
Okay.
I mean, it's a done deal. Basically, I have to give my disability because I'm a veteran and I'm disabled. I can't really do much. I just had surgery on my leg. I'm going blind. I'm blind in my left eye.
Gotcha. Okay.
I have diabetes and I have high blood pressure.
I have nothing.
Okay.
I was looking at your diminution of sentence certificate in Louisiana where we let you go.
Yes, sir.
There was an address, but basically what it says there, it says, if released for any reason prior to June 1st, 2027, you are to report to Sandra Ortego, 300 South Street, Leesville, Louisiana, 337-238-6427, and that sheet is signed by you.
Okay.
The same signature.
Oh, years ago though. And
You, so you just forgot about it.
my memory is not that good. I can't remember that. And, you know, like I said, I had a lot of traumatic events that happened over
right.
the next.
One more question. I don't have all the details right in front of me, but I'd like to know a little bit about your manslaughter charge in Louisiana and your charge over there in Ohio. What did you have to do 37 years for? You said you did 37 years. That's a lot of.
22 down there. I did 22 in Louisiana. And then I got out, I was on parole when I left and caught this charge, this manslaughter charge. And I had to go back and finish my parole time.
What were you on parole for over there?
In Ohio?
Yeah.
A robbery and an ag assault.
And then you had a manslaughter down here that caused that to get revoked?
Yes, sir.
And well, tell me a little bit about the manslaughter. What happened there?
It was a fight, and guy grabbed the hammer, tried to hit me with it. I took it from him, hit him with it.
Some questions.
I was working on his house for him, fixing a redwood ceiling. It was falling in, and we had some tools later on. He grabbed one, tried to hit me with it.
Y'all fighting about money, women, or drugs?
So he was drunk and being very belligerent at a place where we were at, and he was disrespectful to this woman. And I told him, "Man, you ought to be cool." And he kept on stewing on that, kept on being mad about it, you know. And he finally got, or just he was irate about it. He was very, very inebriated.
Gotcha. Thank you.
Hey, you're welcome.
No questions I have.
I move for an executive session.
Got a, do I have a second? Got a motion and a second to have an executive session. I'd ask staff to call roll, please.
Freeman.
Yes.
Freeman.
Yes.
Fowler.
Yes.
Okay, we're going to be in executive session just for a few seconds and a few minutes maybe, but we'll be right back. So you're standing by.
Okay.
Well, this should be interesting to see what results that they come up with. He's got that much wrong with him. And he just wants to get out. Oh, it's funny. Fancy having all those things and being in prison. Well, hello to everybody who is left while we wait for this guy to finish. It's interesting how he's looking about the room, like. I wonder whether he's trying to nick stuff from the room while people are not looking. Although he said he's going blind in one eye, so. What do you think? Do you think the judges will let him off? I think he's got a fair chance. I really want to paint these models. I find it difficult to listen to the voices in these small court cases. I find it really hard to listen. I don't know whether it's the accent. Kinda wish I had some more opinions. Still looking around the room. I wonder what he's doing in that room. Ah, right. You're still here lurking. Well, I'll make loads of noise when there's when the trial comes back on. I was a bit sad about missing the closing comments. But there is stuff I need to do. Was that Paula? Oh, thank you for the card and the presents, Paula. You made Katya's day. I read the card as well. Yeah, he's still looking around the room. Oh, we have him on full screen.
Okay, time's 9:37 in the morning, and we're
I'll make a motion that we go back to, regular business.
got a motion and a second, so we're back into regular session now. And so we're still with Mr. Scott Leonard. And I think we're ready to vote. Since I had your case, I have to vote first. My vote is that you not be revoked, but that you have to stay in jail until you complete the interstate compact with Ohio. And if they'll accept you, then you can get out of jail and go back to Ohio,
Okay, sir.
not come back to Louisiana.
Well, I hadn't never planned on this. I was homeless. I was living on the streets.
Okay.
I finally got an apartment. My life started to come together a little bit. You know, and it's hard when you're my age. I'm 65 in 2 days.
Okay.
My birthday's the 13th. I'll be 65 years old. And basically, I've been in prison all my life. And I'm starting to get it together now. And I got a fiance. I got an apartment. I mean, you know, things are starting to progress in a positive way for me. And
we understand that, but the general public looks at your criminal history. You done some bad things in the past.
Yes, I did.
And I want you to know we understand that. We understand you may be misleading us. You're gonna get out in a year and a half anyway.
Yeah.
But we can let you out a few months early if you get your interstate compact and go to Ohio. If you don't do that, if that's not completed, if Ohio won't take you, you got to stay in jail.
Well,
Ohio bad.
I don't even know how to do any of this stuff you're talking about.
The probation officer will come, have to do the interstate compact.
Okay.
You'll be contacted.
Okay.
And when you sign that paperwork, you be sure and read it carefully and remember it this time.
Okay. Well, I mean, it was a long time, sir. I mean, it was a long time.
Yes, I know. 2006 is a long time to remember signing something. So granting all that, and that we took that into consideration too.
Okay.
Anyway, to make it real short, we find you guilty of all of these violations that you did.
Yeah.
But we're going to grant your request, or at least my vote is to grant your request, providing you fill out and complete the interstate compact with Ohio, and that they accept you. Otherwise, you got to stay in jail till the year and a half.
Yeah.
Got it?
Yes, sir.
Okay.
All right, I'm gonna concur with Mr. Prater, but just to throw a few more details at you. The way the interstate compact works is the probation officer is gonna come and ask you to get your address for your fiance over there in Ohio.
Yes, sir.
Gonna send paperwork to the Ohio Probation and Parole Office, which you obviously know about them already. They're gonna go and check out the address that your fiance has, make sure it's acceptable and make sure she's willing to take you back. And if all that checks out, then they're gonna respond back to Louisiana and say, Ohio is gonna accept your case by way of interstate compact. When that letter is received by us, that Ohio is gonna accept your case, then that's when your release will become effective and you'll be able to go back. And you'll have like a certain amount of time to get over there and get in contact with them. Don't, wait and go 6 months later.
I have a birth ticket waiting on me.
Hold on, you need to listen to me because obviously you listened the last time. I don't want you to get in trouble again. There's gonna be it's gonna be time dated, or from the time they accept you to the time you get over there and you go see them and you get everything straight on that end. Don't dilly-dally around over there or forget about it, because if you go over there and you don't meet the timelines, they're gonna immediately sign back saying he never showed up and we reject him. And then you're back in jail. There's gonna be another warrant. You're coming back over here again.
Oh, I understand that, sir. I'll be on top of that, everything. I said, I got a
Also,
birth ticket
as a
waiting.
condition of probation, we're gonna add that, or condition of supervision, add that you pay the cost of extradition, what it costs us to get you back down here over a period of time, worked out with your probation officer, depending on financial status.
Listen, sir, I'm disabled. I am literally a disabled veteran. And I've been in the process of,
Run our money. Don't win the lottery or else we'll claim our money.
You're that good.
All right.
All right.
The bottom line said, if you're able to.
All right. Mr. Pete?
I concur, do not revoke complete interstate compact and upon release, pay costs of extradition.
Okay.
Okay, so that concludes this.
Can I pay that in small increments?
Yeah, they gonna set it up. They gonna set up a payment.
A payment you can afford.
Okay.
All right. Okay, that concludes our business at Beauregard. I think we're signing off from Beauregard. Thank you. And you are not involved.
Good.
How nice are these judges? The sweetheart fiance waiting for him in jail. Must be lucky. She must be still waiting for him. He said he was getting his life together, so almost feels a bit heartwarming. I think we have another person. Not sure. Let's see. Oh, we do. We have another person. Hey, everybody in chat. Just in case you don't know, I tend to take over at a certain time. So it's roughly about 8 p.m. here. Not sure what time it is Eastern. I will ask DCA eventually what time it is over there. But yeah, I take over on the night time. And don't worry, if I start painting, I'll still be paying attention. I just like painting my little figures. Yes, we are having trouble for some reason. It's 4 p.m. So roughly about 4 p.m. I'm going to try and take over for Katya or TCA. Just to make it easier for she wakes up at about 4 a.m. in the morning, goes to work, has a little bit of a rest, and then she goes on stream. So she does tend to be doing this all day. She would like to make this her main job, but at the moment, it's just not feasible. That's not good. Let me see. What can I do to make that easier? That's on 4G. I might try and turn off a phone. See whether that works. Right. Is that any better? I tend to not. I jump with my speech sometimes. It's a stupid verbal tick that I don't like, but I'm working on it. It's so nice to have you both in chat, Paula and Jenny. Having you chat with us. Oh, that's excellent. As I'd like to say in this stream, if you have any questions you'd like to ask me, now is a great time to ask while I put the next trial bit on. Here we are. In a minute, it should come on. That's it. So now we're just waiting for them to speak to us. So yes, if you got any questions, please ask them. It makes for entertaining commentary.
Okay, good morning. Sorry, we had some things we had to do. Sorry if you've been waiting for us. The time is 10 o'clock in the morning, and
the time, the longer the stream, it might downgrade the quality sometimes. If it's really long, it is worth refreshing the feed because then it comes back better. That is a good point, Katya. Now go to sleep.
the staff there, would you please identify yourself?
Good morning, Mr. Chairman. Joe Buttress, Assistant Warden, Elaine Hunt Correctional Center.
Christy LeBlanc, classification. Terry Gray, Director of Medical and Mental Health Services at Elaine Hunt.
Okay. Thank you for hosting us this morning. Your name is Peter Post, is that correct?
Yes, sir.
Okay. And my name is Steve Prater, and these are my board members, and you can see Pete Freeman and Danny Barra. And we're going to be deciding whether you get revoked this morning or not. And do you have a guest in the back? Is that somebody that's with you?
Yes, sir. That's my father.
Okay. Would you introduce yourself, please, sir?
Yes, sir. Gerald Post Sr.
Okay. All right. Mr. Post, do you have a piece of paper in front of you that talks about your rights as far as this revocation, as far as this goes here? Okay.
Yes,
and did you sign that?
Yes, sir.
And it talks about whether that you are not entitled to an appointed lawyer, but you can hire a lawyer, and that you choose not to do that. Is that correct?
Yes, sir.
Okay. All right. Well, we'll go ahead and proceed. And the way we'll do that, did you have a question?
No, sir.
Okay. And the way that we'll do that is that each case is assigned to a different one of us. And this is Mr. Pete Freeman's case to my right. And he's the one to ask you questions about what rules you're accused of violating and how you stand on those rules. And you can talk to him about that. So we'll go ahead and get started.
Okay, Mr. Post, I'm gonna read a violation. You can plead guilty, not guilty, guilty with a statement, or not guilty with a statement. Okay? The first violation is that condition number 3 in April 2024, you moved from your address of 1619 Stanford Road, Gulf Breeze, Florida, without the permission of supervising agent. Your whereabouts were unknown. A parole warrant was issued on April 17, 2024. On May 29, 2024, you waived your preliminary hearing and pled guilty to absconding supervision. How do you plead to that charge?
Not guilty, with a statement.
Okay, what's your statement?
April 17th, I was currently at West Florida, hospital. I went and checked myself into it was a mental health section of the hospital, called the Pavilion. I had a nervous breakdown and I was having panic attacks. I went and checked into the hospital. I forgot the exact date. I think it was somewhere around the 14th. I did submit some paperwork that had the dates outlined. And I think I got out of the hospital somewhere around the 24th. And I ended up going back to my original residence, which was 1619 Stanford Road. I never did change my place of residence. I know I wasn't there when he came for the home visit, Another thing that, I feel is important, I did turn myself in to probation and parole. I went to check in May 8th, and that's where I was arrested at the probation and parole office. I did go there to check in, but the warrant had already been issued for my arrest.
Okay, well, let me ask you this. Your ex-wife says you did not live there. That you were just using that and that you would drive the truck over there when the probation officer was supposed to come see you, so you would be there. That's true or false?
That's false. I was living there. 9 times out of 10, when he came there, I was inside or in the garage working, or out in the driveway working. A couple of times, I was around the corner working on somebody's vehicle. I did have to come home. I met him in the driveway, but most of the times when he came for a home visit, I was either inside or in the garage working or around the house working.
Why would your ex-wife make that statement? I mean, it's point blank. She said that.
Yes, sir.
So, using this address, but I want to make it clear he does not live here.
We was having some serious problems, and that also led to my hospitalization. You know, I was in Florida with absolutely no friends or support. The only thing I had was her, and you know, right before all of this, it was to the point of almost me, you know, not having nothing, and I panicked. I even she went to send me a bunch of texts and everything. I threw my phone away, and I went and checked into the hospital. I sought help, you know.
Okay. Let's move on to the next one. You were supposed to do 6 hours of community service work per month, and you also were supposed to attend NA and AA meetings, which you did not do. A progress report from Florida dated 1/10/2024 received indicating you refused to comply with the Louisiana special condition. How you plead to that charge?
Guilty with a statement.
What's the statement?
The community service, I absolutely have no excuse for. Anything that I had to offer would be nothing but an excuse. I dropped the ball and I apologize for that. If given the opportunity, I will abide by the rules and, you know, see to it that I do my community service and any other rules or stipulations set by the parole board. I was working a lot. I did, and then when I wasn't working, I was doing a lot of house repairs at my house as well as my mother-in-law's house. But I still, at the end of the day, I should have made it a point to make time to go do the community service as I was told.
What about the AA meetings?
The AA meetings, the primary parole officer that I had when I first went to Florida, after a couple of months, he sent me to a counselor and for an evaluation. The counselor signed off, said he didn't see the need for any further counseling or AA meetings. I turned that paperwork in, and I wasn't required to do the AA meetings. Then Mr. Gamble took over my case, and he wanted to reimpose that. I did go to meetings here and there, and it's when you attend meetings, it's important to be able to open up and talk, you know, and for it to be effective. And it was hard for me to find a group that I was comfortable with. Approximately a month before I got arrested, I had finally found actually 2 groups that I was actually comfortable with. You know, I was, and another thing, I was going to, Lakeview, Behavioral Hospital, which was, you know, they also specialized in, substance abuse. I had a psychiatrist that I was seeing there.
Are you on any mental health meds?
I'm on Depakote now. It's supposed to be for my anxiety.
Yeah.
And it helps me greatly.
Okay. Yeah, I'm glad to hear all of this, but you know, working parole 35 years, and if I was back in the time that you are backing, there's no way I'd have missed those AA meetings. You know you were ordered to go to. I don't care what my counselor would have told me. I'd have said, I'm going regardless, because I don't want to go back and do 20 more years, 22 more years.
Yes, sir.
But you didn't. I mean, where are you going to live if we don't revoke you today? Where are you going now?
I'm going to live with my father. A lot of things have arose since my incarceration here. I mean, he's elderly, he's disabled. I mean, it's literally to the point now in his life that my freedom and me living there with him is potentially life or death for him. I mean, he can't even cut the grass half the time. You know, he can't make it to the grocery store.
Where does he live?
Kenner, Louisiana.
Okay. I have no further questions.
Okay. Dan?
No.
Okay, let me just make sure I understand this. The current charge you're on parole for now is a conviction from 1999, correct?
96.
Okay, and when were you paroled out?
21.
Okay, and from 21 to 24, you were living in Florida, correct?
With the exception of maybe 3 months when I first got out, I stayed with the Louisiana Parole Project for roughly a month, and then we stayed in an apartment in Kenner for about another month or two, and then went to Florida.
And so from 2021 until 2024, you didn't have any problem fulfilling your obligations of parole, correct?
Yes, sir.
You did everything you were supposed to do.
No, sir. With the exception, you know, I didn't do the community service and the AA meetings as.
Okay. All right. And then you were rearrested because of that.
Yes,
and
sir.
Failing to report your address and what we talked about there. Okay, I just wanted, right? All right.
Okay, y'all ready to vote?
Yeah.
My father also wanted to speak.
Okay.
Yes, sir. I just wanted to say that if Peter is released and lives with me, he will abide by everything that you tell him to. I'll make sure of that. And I really do need his help around the house. So it would be beneficial to me if you did release him, reinstated his parole. I guess that's it. All I can do is guarantee that he would abide by everything that you have stipulated.
All right. Then I'm suppose this is a hard decision because you went to Florida and you know you're backing so much time and you didn't do what you were supposed to do. You know, obviously you must have been having some problems with your ex-wife, or which I don't know. Y'all still married?
No, sir. We still talk, but we're not married, and to be honest with you, I'm not even trying to, go back that route.
Because if you go back that route, you could be in all kind of problems.
Correct. I got my focus on taking care of my dad and,
All right, well, I'm ready to vote then. Okay, my vote today is going to be to do not revoke and that you go live with your dad and do the things you're supposed to, report to the probation officer immediately. And I want a mental health evaluation completed.
Yes, sir.
And the same conditions apply that applied before. You got a 6-hour community service and you got to go to AA.
Yes, sir.
That's one.
All right, thank you, sir. Bara?
I'm gonna go ahead and concur with Mr. Freeman, but also order a condition that you pay the cost of extradition to get you back down here from Florida. And that you be returned for a revocation hearing should you violate any of those conditions. The excuses are over with.
Yes, sir. How do I go about finding out the cost of the,
They'll set it up for you on a monthly payment.
okay,
Okay, and I concur. So it looks like we're not going to revoke, but we're putting some conditions on you. And
Yes,
so therefore, listen to what we had to say, because they're dead serious. Okay. All right,
thank y'all very much.
Oh, wait, let him finish telling.
All right, that'll conclude our business here at Hunt Correctional. Excuse me, we have one more at Hunt. And then we'll conclude our business there, but that concludes this particular hearing on Mr. Peter Post, and the time is 10:19. Thank you.
So that concludes our tiny little bit. We haven't had any more on the verdict watch. We're still going. So we have another thing we can go on to, but 2 interesting parole hearings, I think. The second one I'm not so sure about. I think he's going to do what he wants when he gets out, but that's just my opinion. Or maybe he's just sick of life in prison and think taking care of his dad will probably be easier. What do you guys think? You'll have to let me know in the comments. But I don't personally think the second guy is going to be obeying many of those rules. It should be interesting to see him go back to jail. See whether we got another one on here. Oh, we do have we have another one. Let's have a look at this one when it comes on. Loving your comments, by the way, Pickles. Keep them coming because I do like to have a good laugh while I paint my miniatures. I will have to try some of the hooch from Costco. I might buy some when I get paid in the summer.
Mr. Thomas, is that you sitting there?
Yes, sir.
Okay, well, this is the board sitting here, and my name's Steve Prater, and you see on my right is Pete Freeman, on my left is Danny Barra. And can we have the folks that are sitting in the room with you there introduce themselves?
Yes, sir, Mr. Chairman, Joe Buttress, Assistant Warden, Elaine Hunt Correctional Center.
Christina Wong, classification.
Okay, thank you for hosting us today, and we'll see how quickly we can get out of here. But we want to hear what Mr. Thomas has to say about some things. Mr. Thomas, do you have a piece of paper in front of you with your name and your DLC number on it?
Yes, sir.
Okay, and does it have a deal where it talks about lawyers on there?
Yes, sir.
Okay, and you're not entitled to an appointed lawyer, but you can hire a lawyer if you want one. Do you know that?
Yes, sir.
Did you hire a lawyer? Do you want a private lawyer?
No, sir.
Okay, you ready to go forward with the hearing?
Yes, sir.
Okay, good deal, good deal. The way we're gonna do this is that each one of us has a particular cases that we study, and they're gonna go over certain rule violations with you and hear what you got to say about it. And you can plead guilty with a statement, you can plead not guilty, or anyway, but as we go over each rule, as Mr. Freeman goes over each rule with you, he's gonna ask what you plead, and then he's gonna talk about it and see what happens, okay?
Yes, sir.
Thomas, I do not think we can proceed with your hearing today because you had appointed counsel at your preliminary hearing because you stated you couldn't read and write.
Yes, sir.
So we need to check on that to see, can we proceed without appointed counsel if he had appointed counsel at the preliminary hearing?
I move for executive session.
Yes, second.
Okay, got a motion? Mr. Freeman?
Yes.
Bob Ross,
Yes.
Freeman.
Yes. Okay, we're gonna be going into executive session to discuss your status with your reading and writing and the attorney, what effect that has on us. The time is 10:33 in the morning. We'll be right back.
And time to skip, if we've got any skipping left to do. Oh, we're back. Yeah.
All right, can I have a motion to come back in from executive session?
A motion.
Second.
Got a motion and a second to return from executive session. Time is 10:41. We're back in regular session. Mr. Thomas, we cannot continue your hearing today because of the fact that we've been told that you were represented by an attorney, an appointed attorney, because you qualify for that at your original hearing, and that that same attorney will need to represent you at this revocation hearing. He has been contacted and he wishes to do that. So we'll have to reschedule this particular hearing for another date, and you'll be notified. Until then, you'll remain locked up, and then we'll have you here and see what we say about that. So that'll conclude our business at Hunt, and that'll conclude our business for the Committee on Parole. And the time is 10:42 in the morning. End of cases for today. So you pleading not guilty, but
That's not good. Let me just get the other one on. Okay, that's not going to take very long. Okay, can you hear me? Great, that's good. Let's see whether this comes through. Either that or Pickles is winding me up. Waiting for that to load. Shouldn't take very long. There we go. I wonder why you just cut out. I don't want to skip ahead because it's awfully close anyway. So, it makes me curious of what the previous guy was about to do. Or what he did. And what his argument for like getting off his charges. Oh boy. Great stuff. Now, why isn't it coming on? Oh, wow. There must be some skip then. And let's try and skip it a bit. This mouse isn't very good. It's just, oh, we got an interesting pause here. He's looking right at the camera, very serious.
Good morning. Pardon board is called to order. Today is Monday, February 10th, 2025. Time is 9:12 a.m. Would you call the roll, please?
Ms. Renata?
Present.
Prater?
Here.
Simmons?
Here.
Reed?
Here.
Madam Chair, we have a quorum.
Yes. For the record, we have 4 members present today, so any action will require a unanimous vote. We will allow public comment on requests before any action item. Before we begin, I'd like to acknowledge the folks who are here and support our staff. We are seated in Baton Rouge at DOC headquarters. Would our staff introduce themselves for the record, please?
Evan Thompson? Sure, I'll be right. Carla Williams? Shakita McCarter? Heather Pennington, probation control.
And thank you for providing security today. We appreciate it. Our first item on the agenda this morning under regular business is review and approval of the minutes from Monday, January 27, 2025. Those are included in your packet. Are there any corrections? I'll entertain a motion for approval.
I make a motion that we approve the minutes.
We have a motion by Mr.
Second.
Tillis, second by Mr. Freeman to approve the minutes from Monday, January 27th. Is there any objection? Hearing none, those minutes are approved. So we will begin our next agenda item, which is consideration of applications for clemency and pardon. And I believe our first case is in Tenshaw Parish.
Yes, this is Tenshaw Parish.
Good morning, ma'am. Would you introduce yourself for the record, please?
Happy Monday. This is Emlet.
Happy Monday to you. We appreciate you helping us out this morning.
Thank you.
And you have Mr. Riley. Is that you, sir?
Yes, ma'am.
Mr. Riley, would you introduce yourself? Tell us your name and DOC number.
Willie Riley, 330823.
Yes, sir, Mr. Riley. And before we begin our process, I want to recognize the folks who have joined us this morning, who have an interest in your case. We have by Zoom your sister Deborah Riley and Frederick Matthews, your brother-in-law. Here with us, also on Zoom, representing the DA's office in Jefferson Parish will be Mr. Randall Meyer. Here with us in Baton Rouge, in our hearing room, we have Robert Janest and Consuelo Janest. Mr. Janest, and I apologize if I mispronounced your name, will be speaking at the appropriate time and will ask for his remarks. First, Mr. Riley, let me just read some identifying information into the record. Willie Riley, you were sentenced. You're currently serving a 25-year sentence. You were sentenced in Jefferson Parish, March 17, 2011, for attempted second-degree murder. You do have a good time release date, which is December 26, 2030. Mr. Riley, is that information correct?
Yes, ma'am.
Well, Mr. Riley, would you take a moment before we start our interview process and before we hear from those who want to speak? We want you to tell us why you submitted an application for clemency, why are you in jail, and why do you think we ought to recommend an application for clemency?
Yes, ma'am. I had reevaluated myself since I've been down, and I looked at all possible things that I was able to do with myself and for myself. And I had went through some classes and I had studied a lot of things that helped me change my ways, change my attitude, change toward everything that I'm going toward goal to reach this point where I can say I can represent myself and allow myself to speak and put in the application toward hearing something after being down alone to identify myself that I am a changed man. And I changed that way so when I get if I get allowed to be out or something, anything like that, I can remind myself that, I'm going forward instead of backwards.
Okay, so tell us why you're in jail.
And I attacked my supervisor in the altercation where I had just snapped and my mind just was just gone at that time, though, but I had refocused everything I had did in the power of myself, and to recognize that I did that, and I couldn't take that back right now, though, but at this time, present time, though, I'm selling myself to let everyone know that, everything that I had did back is back. Everything I'm doing forward now is forward.
All right, well, thank you, sir. And Ms. Litt, is there anything you can tell us about Mr. Riley?
This lit. That's call for you. Ms. Lit.
Ma'am,
Is there anything you can tell us about Mr. Riley?
I had a warden here. I have both wardens here. They're going to speak on his behalf.
Right, we'd like to hear from the wardens then. Thank you.
Yes, good morning. How y'all doing? This Deputy Warden Johnson.
Good. How are you, sir?
All right.
What can you tell us about Mr. Riley?
Okay, he a good worker, has no disciplinary issues. He worked basically 24/7. You have to make him a stop worker. He just work. And he gives us zero problems. And he's a good guy and seems like he ready to do what he's supposed to do when he get out.
Yes, sir. Thank you so much. Now, does anybody else have anything to say?
Yeah, just the head warden here.
All right.
How y'all doing? I'm Warden Bass.
Good morning, Warden Bass. Is there anything you want to say about Mr. Riley?
Yeah, like I say, just basically what my deputy warden said. Like I said, Mr. Willard been here with us for some years now, and like I said, never had a problem with him. He's a good worker. He get along well with the staff. He just anything he asks that we ask him to do, he does with no problem. Like I say, he's a real good guy. Like I said, I've been doing this for almost 30 years, and like I say, I don't have too many around like Mr. Willie. So he's a good person.
Yes, sir. Thank you, Warden Bass. We appreciate your remarks. At this time, we'll hear from the folks who want to speak in favor of Mr. Riley. And first, we'd like to hear from his sister, Ms. Deborah Riley.
Yes, ma'am. Good morning. Can you hear me?
Yes, ma'am.
Okay. On speaking of Willie's behalf, I know he's been in there for a while. He did what he has supposed to have done all of these years. He's a good person, lovable. But the situation he has got into, I know it's hurtful, but I think that everybody deserves a second chance. And he's been in there long enough, like he said, he did his classes. He's been doing what he's supposed to have done all of these years. And I think that, so far he deserves a second chance to be, released as of this point.
Well, yes, ma'am. Thank you, Ms. Deborah. We appreciate your remarks. Mr. Matthews?
Yes, ma'am. Frederick Matthews.
Yes, sir. Go ahead, sir.
Okay, my name is Reverend Frederick Matthews. I pastor a church in Kenner, Louisiana. Willie Riley is my brother-in-law. I met him many years ago when he was a kid. His wife and I have been married 55 years this year, and I know him personally. And I believe he's rehabilitated and he's ready to come back and into the life. Prior to that incident, there wasn't anything that Willie was into. I considered him and still consider him a good and caring person. And our family stands waiting to help him to re-enter in any way that he can. We willing to help find work and whatever need to support from family, he has it 100%. Not just those locally, but those that are in California, North Carolina, and other places. We would like to see him come home. I think he's ready to re-enter, and I pray that you all give him that opportunity. Thank you.
Thank you, sir. We appreciate your remarks. At this time, we'd like to hear from Mr. Janas. I'm sorry if I'm mispronouncing that, sir. Yes, sir. Go ahead. You want to step up to the podium and introduce yourself and tell us what you want us to know?
My name is Robert Janas. First, I'd like to appreciate the opportunity to address the board and speak on behalf of myself and my family. Growing up, I didn't know either of my grandfathers. They had both passed before I was born. And my dad was my role model. I watched my dad. I learned what it took to be a man, a husband, a dad, a grandfather. And like my dad and my daughter before us, my grandson and I are inseparable. On that fateful day, after fighting for my life, trying to somehow stop the bleeding, I had to call my wife and tell her that I had been stabbed 6 times. And I didn't think I was going to make it. Imagine making that phone call. But worse, imagine having to receive that phone call. Started crying. My grandson was in the call, and he started crying. So to protect him, my wife hung up. Not knowing if that was the last time I would talk to my wife. I was terrified. But knowing I would never see my grandson again made me more determined than ever to fight for my life. I had 6 stab wounds, 1 to my upper back, 3 more to my lower back. And at that point, I asked Mr. Riley to stop, and I had a new grandson. And instead, he stabbed me twice more in the head. I was losing a lot of blood, and I thought somehow, if I could just stop the bleeding and stay conscious until I reached the hospital, I would have a chance. 2 different surgeries, a week in the hospital for each one, 3 months of rehabilitation. I was able to return to work and my family. It's been 14 years since the attack. I'd like to give you a glimpse of those 14 years, the good and the not so good. The not so good is I suffer from terrible nightmares. I have PTSD. I have mood swings. I'm always looking over my shoulder. I always sit with my back to the wall. I don't trust people anymore. I'm quick to get angry. People say I should go to therapy. Therapy won't change the fact that the attack happened. But when these emotions occur, my response therapy and my therapy is always the same. I think of my grandson, my best friend, the most important person in my life. This is my grandson at 3. And I'm teaching him how to play golf. It was just before the attack. This is my grandson at 17. It was just a few months ago, and we were visiting college campuses. I can't imagine not experiencing these last 14 years with my grandson. So for my therapy, I keep these 2 pictures of me and my grandson in my wallet, in my car, on my nightstand next to my bed. When those dark days come, which is still too often, I look at these 2 pictures, and that's my therapy. That's what keeps me going. That's what makes life special. As for Mr. Riley, he had no remorse during the attack, after the attack, at the trial, or any time since. He tried to take my life that would not only have affected me, but would have changed the lives of my wife and daughter. But to try to steal my future with my grandson is the worst thing. I said at the trial, in my victim statement, that I will never forgive him for that. And if God sends me to hell for that, then I guess I'll see Mr. Riley in heaven. So today I ask that you, Mr. Riley, sentence be continued in its entirety. Thank you for your time.
Thank you, sir. Really appreciate hearing from you. Can we hear from the DA's office, please? Mr. Meyer.
Good morning, Randall Meyer, Assistant DA, Jefferson Parish, and we're opposed as well to Mr. Riley's request. In looking at his application, he stated that he had worked with Mr. Jeunesse for 20 years, and Mr. Jeunesse had given him a hard time for the last few months, which is, the reason why he ended up attacking him. And well, the hard time that he gave him is that he was found to be intoxicated at work a few months before and got suspended and had to take AA treatments or AA, the program. He came back and was is suspected to be intoxicated again when Mr. Jeunesse took him to be tested, and that's when this happened. And he was the aggressor. Mr. Riley was the aggressor in this case. Mr. Jeunesse retreated, trying to get away from the attack, and was stabbed as he recounted 6 times. Fortunately, he's alive today. Because of the nature of that attack and the offense and the victim opposition, we're opposed to his request for a commutation of sentence, and noting that he's only served 14 of the 25 years. Thanks.
Yes, sir. Thank you, Mr. Meyer. Mr. Riley, your case was assigned to Mr. Prater. Would you answer any questions he may have, please?
Yes, sir, Mr. Riley. How are you today?
Okay, how you doing?
Okay, I've read your file extensively, and I tell you, since you've been incarcerated, you have done you've done good. Your wards have bragged about you and everything else, and so that's the way you're supposed to act. But let me ask you something. In your statement, I don't remember you saying anything about the victim. I don't remember you saying anything about being remorseful. All I heard was how good you done, talking about yourself. And that kind of bothers me. Did you stab this man 6 times?
Yeah, I had stabbed him 6 times, but it was just out of big anger, emotions, the way things went down. But like I said, from the first beginning, I did that in the past, but I can't take that back forward now because it already happened. If I can change things around, though, I would, but it had already happened already. And I'm sorry about it. It happened, but at that time, though, it was really raised up in anger towards things that had happened. But since I've been down, I realized that everything that went on, it brought me to this here point where I know I can find a million reasons to stay out of jail, but I can't find one reason to try to come back.
Okay, you've served 14 out of 25 years.
Okay.
That's 56% of your crime of the time.
Okay.
And the state, because of previous laws, you're going to get out in 2030 anyway. In 5 years, you're going to get out anyway, aren't you?
I guess it can be 2030.
Yes.
But I'm sitting here on the behalf of speaking to myself and everything. It's a possibility that with my behavior and my retribution and everything I'm going through, I was leaning on just paper or something, or maybe I could act for leniency time or something like that, so I can just go back to normal life or something like that. If it's possible. If we can all change, everything change, I change too. In a way where everything is not there.
I hope you have changed.
Yes, sir.
Certainly needed to. Yeah. That's all I got.
Any other questions?
No, ma'am.
Questions? All right, Mr. Riley, I don't see any other questions, so I think we're prepared to vote. Mr. Prater will be voting first.
Yes, ma'am. Mr. Riley, I hate to tell you this, but my vote is to deny. And it takes all of us voting the same thing. To deny, you have served, but like I say, 56% of a terrible crime. I cannot imagine what this man's gone through. And I also cannot imagine what would have been in somebody's mind, because I've been mad before. I've been pissed at people, but I never stabbed them. And so that's a different kind of mindset. And we got to make sure that you realize the seriousness of this by serving your entire sentence. My vote is to deny.
Mr. Freeman?
My vote is to deny, not enough time served in victim and law enforcement opposition.
Mr. Tiller?
I concur with Mr. Freeman.
And I vote the same, Mr. Riley. I'm glad that you're doing well where you're at, and they speak highly of you, but I too, based on the opposition that's been expressed today, I'm going to vote to deny your parole. You have an a firm out date in 2030. So good luck to you, sir.
Thank you, Alder.
We'll sign off at 9:33.
Okay. Okay.
Let's see whether he does anything off camera. Nope. There he goes. Let's skip ahead.
All right, good morning. The Pardon Board is reconvening at Louisiana Transitional Center for Women. It is 10:39 on Monday, February 10th, 2025. Would the staff there at LTCW please introduce yourself for the record?
April Cootie, programs.
Nice to see you again.
You too.
All right. And we have before us, is that Ms. Butler?
Yes, ma'am.
Go ahead, Ms. Butler. Introduce yourself. Tell us your name and DOC.
My name is Amber Butler, DOC 556550.
All right, Ms. Butler. Let me recognize the folks who have joined us. We have some folks here in Baton Rouge with us. We're at DOC headquarters. We have your daughter, Kevin Butler, Derek Butler, your dad, sister-in-law, Ashlyn Buros. And speaking on your behalf will be your brother, Jordan, your mother, Arlene Butler, and daughter, Haley Watts. And at the appropriate time, we'll call on those folks to do that. First, I will read some identifying information into the record, and then we'll have a conversation before we and hear from those who want to speak before we start our interview process with you. So you're here this morning because you've submitted an application for sentence asking for a commutation of your sentence. You were sentenced in August of 2009 for simple burglary in Washington Parish. You received a 2-year sentence. And then in 2012, also in Washington Parish, armed robbery and armed robbery with use of a firearm. And for that, you received a 20-year sentence for the armed robbery, 5 years for the use of a firearm. Those are running concurrently. So it's a total of 20 years. You are not eligible for parole, and you have a good time date, which is March 27, 2027. Does that sound right to you?
Yes, ma'am.
So this morning, Ms. Butler, would you take a moment before we hear from others and tell us what landed you in jail? Why are you in prison? Why have you submitted an application for a commutation of your sentence? And why do you think we ought to vote favorable for you today?
Okay, first I want to apologize for what I've done. Oh, I'm nervous. I'm sorry. I don't even know how to start. I'm scared. I'm sorry for what I've done, and I can't say that I didn't mean to do it because I know I've done it, but the person that I used to be, I'm not her anymore. I was just really young and was going through a lot. Oh man, I'm sorry. Freaking out. It's okay. Just talk, say.
Take your time.
I don't even know how to begin because I'm scared. Um,
Tell us what you did. What was your crime? Tell us what you did.
my crime was armed robbery. I robbed somebody that I just should never done. This is something I just should never done. I should never been there, but I was, and I regret doing what I've done. And I didn't mean. I wish I would have never done that. It's like the biggest mistake of my life. And I'm so sorry to that family because I know I've done them wrong, and I know it's probably scarred them for life. You know, I just wish I would have never done. Uh, oh, I feel like the girl that I used to be. I'm just not her anymore. I'm not immature anymore. I've grown a lot. I done got my GED. I got my associate's degree. I got my bachelor's degree. I've been working my whole time here. I have a job on maintenance. I've been on maintenance for 5 years. I've learned how to fix things, and I really enjoy that. Like when I was at home, I had jobs here and there to where I wasn't into the jobs, I would say, but now I know how to work and earn what is for me. And my biggest goal right now is I just want to be a mom. I just want to go and be a mom of my kids. Then I do thank y'all for trying to hearing me out. And I'm sorry I'm breaking. I'm sorry. I'm nervous.
That's okay. We're going to hear from the other folks, and we still going to talk to you again. So
yes, ma'am.
Have a moment to collect yourself. Let's ask Miss Cootie, what can you tell us about Amber?
Amber's been here with us about 10 years. So she has definitely grown. She's taken advantage of everything we have. Like she said, she got her GED. She has her associate's and her bachelor's degree through Ashland. I mean, she has worked hard. And I have Miss Fountain in here with me also, that is who she works for with maintenance, if you'd like to speak with her.
We'd like to hear from her. Miss Fountain, what can you tell us about?
First of all, I'd like to say good morning. Screwdriver. I'm here and I have a maintenance crew, and Miss Butler work on that crew with me. She's grown from the time that I started. I've been there like 4 years. I used to do transportation, and I changed position, and she's been under my supervision since then. From the first day when I first started, when I first started working with her, and up until now, there has been a big change. There has.
Good. Well, that's good to hear. We appreciate hearing from you. Thank you so much.
You're welcome.
All right. We'll hear from your family members who are here who want to speak on your behalf. First, we'd like to hear from your daughter, Haley. When you speak, I want you to speak loudly so she can hear what you're saying.
Hi, my name's Haley. I'm your mother. I just want to say that I'm very sorry for everything that she did. I mean, she's very sorry too. But I just want my mama home. Like, I really just want to know her. So I'm adopted. I haven't adopted at 3 years old. And I don't even know who she is. I've never met her. That's all I wish is to be able to know her. And I know that she's working on a better life. And I have faith that she's doing better. And I really hope that y'all can see that. And then y'all choose to let her out just so I can go my mom back.
Thanks for being here. We appreciate it. Right. That was a good job. Jordan, can we hear from you? This is Butler's brother.
How you doing? I'm gonna start off introducing myself. I'm Jordan. I'm her younger brother. 33 years old. I'm a tugboat captain. I have a beautiful fiance. We have 2 kids. Keep it constant. Keep in constant touch with my sister. Through how we get to talk to her on the app and get the text back and forth and FaceTime. Genuinely, I do think she has grown. She has committed a crime and she's done the time. And I mean, there's no doubt in my mind that she is where she is for what she's done. And I wouldn't deny it. Like you said, like she said, that she has grown as a person. She's doing school and things that she probably wouldn't have done if she wouldn't have gotten incarcerated. She may not have grown to be a better person by this. This is probably what helped her. You know, we grew up in New Orleans in the city, so I'm not going to say you are who you are and you make the decisions that you make. People you hang around with can cause you or make you to do the wrong things. I've grown a lot. I've never been convicted of any crimes, anything, but I know moving away from the city and growing to be a person and a father and a soon to be a husband is all the choices that you make. I talk to people that we hung around, my sister that we grew up around. They're very surprised at the man I've become to this day. And I hope that I can do the same for my sister. I think she's doing what it takes to grow as a person and show that she wants to get out and be a woman and a mom. You know, she got 2 beautiful kids. If she gets out soon, hopefully she's still got a few years to at least raise her younger daughter on, you know, things that she can show not to do and to do and, you know, things like that. We already have 2 possible jobs lined up for her if that accommodates for if she gets out and they approve that. We already have 2 jobs possibly lined up for her. Places to stay. She was more than welcome to stay at my house. She's gonna be more than welcome to stay at my mom's house. And I've already told her that she already knows too. If you come home and you live with me, there will be rules. There will be things to follow. You will be on the right path. You won't be coming here and running the streets and doing none of that. It will be all getting your job, focus on whatever you got to do to better yourself and enjoy all the years that you lost. I lost 14 years with my sister. But I'm hoping that that comes to an end and get our relationship back and be brother and sister and be a happier family. Thank you. That's all.
Well, thank you for being here and thank you for supporting your sister. Awesome. All right, and Miss Arlene, let's hear from you, please.
Hi, my name is Arlene. I'm nervous. It was wrong. And the first thing I like to do is start off by acknowledging what she did wrong. She's aware, we are aware. And we are remorseful as a family for the actions she took that day. And the person she thought she was that means to me. Like my son said, it's taken a lot of hard work for her. She's had a lot of struggles where she's at now. But she's been overcoming a lot of things. And her family, and this is only just a couple of people of her supporters that are ready to take her and make come home to her daughters. This is having a young baby that was actually born in April. So she never really got to know her that much. We do have jobs, like my son said, we have jobs lined up for her. And I just know she's not the same person. Like she said, either she did a horrible thing back then, and I know, like she said, she never ever wants to go back where she is. Now she wants to maintain her job. She wants to raise her kids. She wants. My husband and I were getting to that age. We have health problems, and we may not be here if she has to stay a lot longer. So we'd like to have our daughter back in our life. It's been 14 years of a 20-year sentence, and I'm hoping y'all will see. At least give her a chance, please.
Yes, ma'am. Thank you. Thanks for being here. All right. Ms. Butler, Amber, your case has been assigned to Mr. Tillis. Would you answer any questions you may have?
Well,
Good morning, Ms. Butler. How are you?
good morning. How are you?
I see that you've made some improvements. You've taken a lot of classes.
Yes, sir.
That's good. Tell me what happened. Why were you robbing people?
Okay, honestly, at that time, I was going through a situation with my oldest daughter to where my half sister had my oldest daughter. She was raising her because I couldn't get my life together. I couldn't find a place to live. I couldn't find a job. And then something happened with my sister and my youngest baby to where the state came in and took my oldest daughter. And then I was going through trying to get her back. I couldn't find a job. I ended up getting a house with her father, but I just couldn't hold a job. And then they made me sign my rights over from her. And then from there, I lost my baby, and then she was my world. And I don't know. I have no excuse for it. I don't, because this is just something I should never have done. And I regret it every day of my life for that. I don't know. I was just trying to live, I guess. Oh,
Were you on drugs at the time?
I smoked weed, yes, sir.
Alcohol?
I don't drink.
So you were doing these robberies by yourself?
I was hurting out my kids' father. It was just wrong. I was around the wrong people.
I see. Well, the choices we make are the choices we have to live with.
Yes, sir.
That's kind of bad. So if you're released, or when you're released, what do you plan to do?
I want to find like a good job. I just really just want to be a mom to my kids. I want to be able to work an 8 to 5 job, and I don't even care what the job is, as long as I can provide for my family and work hard for what. How do I say that? Work for what I deserve, and provide for my family and stuff. I just want to be reliable, and I don't want to be somebody, but I want to be a mom that they can look up to and say, "Great job, mom. I'm proud of you, and I love you," and stuff like that.
I see. I have no questions.
You have a question?
Let me ask, so you burglarized a store, correct?
Yes, sir.
And you got caught, and you got a deferred sentence and probation for that, correct?
Yes, sir.
Burglary. And while you were on probation, you got convicted of drug paraphernalia, right?
Yes, sir.
Okay. And then a couple of years later, how many years later was it when you did the armed robbery?
Almost 2, I think. If I'm
Okay.
not mistaken.
Okay. And why did you, it says in here, you picked the victims. Why did you think they had money, or was it a dope deal you were trying to think they might have dope?
No, it was just random people. That family was just rambling. That's the only person that ever had that family was the only person that it ever happened with.
Okay. All right. That's all. I'm just trying to get all the incidents straight.
So Amber,
Yes, ma'am.
what are you seeking today? What are you looking for?
For a second chance at life, to prove myself that I'm not the same person I used to be, and that I'm different.
I understand, but you submitted an application for clemency.
Yes, ma'am.
You have an out date, which is 2 years away.
Yes,
right?
ma'am. Yes,
So
ma'am.
what are you looking for today? Are you seeking parole eligibility? What are you looking for?
That parole, yes, ma'am. To going home earlier than the 2 years, to get home to my family and rebuilding my life.
Well, let's What's your conduct record look like?
Like my behavior?
You got any write-ups?
No, ma'am, I haven't had a write-up in like 10 years, I think.
All right, I'm asking the questions about what you're seeking today because the clemency process is very lengthy. If you even were to receive a unanimous vote that was in your favor today, it could take more than 2 years probably to get it processed all the way through, even if the governor was inclined to sign it. So I was just trying to determine specifically what it is you're trying to seek to. So you said you want parole eligibility, or which would be through a parole.
Yes, ma'am.
All right. I don't have any other questions. The panel prepared to vote? Mr. Tillis will be voting.
Today, Ms. Butler, my vote's going to be to deny because of strong law enforcement and the crime that you committed. I'm really pleased that you're doing what you're doing, and I hope you keep up the good work.
Thank you.
Mr. Prater.
I concur with that. You're going to be out in 2 years anyway, and nothing that we granted today would have helped you in any way.
Still possible.
It is.
It is possible.
Okay. Well, my vote's to deny because of the fact that I was trying to make it easy on you and tell you, but I didn't want to put any more burden on you, talk about your past. But my vote is to deny because of your criminal history in the past, the burglary and then the violation while you're on probation. So deny.
Mr. Freed.
My vote is to commute to 15 years with immediate parole eligibility. I think she's done a great job in prison. She was young when all of this happened, and I think the interview was great.
Thank you.
That's my vote today.
All right. Ms. Butler, you've received 2 votes to deny, 1 vote to support your commutation request. So you know what the outcome is today because it requires a unanimous vote. My vote would have been to commute your sentence, but not commute it to 15 years, just commute it to make you immediately parole eligible. But the outcome of today's proceeding is that your application's been denied because you didn't get a unanimous vote. But I echo what Mr. Freeman has said. I think you should be proud of yourself. I agree with what your brother said, that you probably have had some opportunities there that you wouldn't have had you not gone to jail. So you've got a lot to live for. We see 2 beautiful young ladies here that are anxiously awaiting you coming home, and you will be there. March of 27. Good luck to you. Be proud of yourself. You've done a good job.
Yeah, thank you. Have a good day.
Thank you. All right, that concludes our business at LTCW. We're going to sign off at 10 a.m.
Well, that was interesting. Robbery and other stuff. Oof. So apparently, according to the report, she picked her targets, but according to the victim, it was random. Oh, that was a bit interesting. But there again, I do think she makes a good case. I do think there's a lot of truth in what she says. A lot of the emotions seemed rather real. I think that was quite good, actually. I'm a bit disappointed. I think more of the judges should have been like, yeah. We can actually... Oh. Oh dear. That's not good. Let's force quit on that. You know when you get a warning message come up on your computer and you're like, oh dear. I'm trying to think which ones... Nope, resume. I don't want to force quit applications. I'm sorry if no, that's relaunch. I am trying to make sure that this doesn't quit. There we go. Right. Crisis averted. Oh, why? There we go. Let's skip ahead to the next trial. I don't know why it keeps. There's a window that keeps making me want forced quit stuff. It's annoying me. Here we are.
All of you award? All the new ones here?
All right, good morning. Committee on the Park Board is reconvening. We're at Dixon Correctional Institute, Monday, February 10th, 2025. It is 10:05 a.m. I'd like to ask, Warden, please introduce yourself for the record.
Good morning, Deputy Warden Turner. Walter Aswell, 603043.
Jay Babineau, classification.
Xavier Source, reentry. Curtis Thurman, mental health.
Got everybody?
Ma'am.
All right, and Mr. Aswell, thank you. You have introduced yourself. Let me acknowledge the folks who have joined us by Zoom. In support, we have your sister Sarah Seal and your mother Robin Aswell, both who will be speaking on your behalf. And you have Tara Winters as well. Here, also on Zoom in opposition, we have Chad Cassard, Candy Cassard. Here with us in Baton Rouge, also in opposition, we have Scott Seals and Stephanie Seals. And Mr. Seals will be speaking at the appropriate time. And we'll hear from both Chad and Candy Cassard at the appropriate time. First, let me just read some identifying information into the record, Mr. Aswell. Mr. Aswell, you are classified as a first felony offender. You are currently serving a total of 25 years. You were sentenced in Washington Parish, August 21st, 2012, for armed robbery. One count, you received 20-year sentence. Armed robbery, use of a firearm, you received 5 years. Attempted first-degree murder, 3 counts, you received 5 years. And aggravated obstruction of the highway, you received a 10-year sentence. And as I said, all those sentences are running together. So it's a total 25-year sentence. You are not eligible for parole, and you have a good time date, which has been adjusted to October 3rd, 2031. Does all that sound correct?
Yes, ma'am.
So, Mr. Aswell, before we hear from the folks who want to speak today, we want to hear from you. We'd like for you to tell us why are you in jail? What led you here? And why have you submitted an application for clemency? What are you specifically asking for? And why do you think we ought to vote for you today?
Yes, ma'am. Well, first of all, I would like to thank the board for granting me this opportunity to speak and to address you all this morning. I can say that when I committed my crime, I know I was still a young man. I had no clear direction in life. I had lost my father when I was young, when I was about 13. He had died of a massive heart attack, and it was just something that I had never properly dealt with. It was an issue that had caused me to spiral into depression and seeking out all the wrong ways to deal with major issues or problems in a person's life like that. I hung out with the wrong type of people. I was led into participating in just bad behaviors. I got into smoking weed, drinking alcohol, taking drugs, and just trying to ignore my problems rather than really deal with them. All of this led until eventually the person that I was around the most, who was the person that I committed this crime with, he and I went out and we went and robbed this bank. During the commission of that crime, when the police officers tried to arrest us, instead of just surrendering and giving up, we ran. We tried to flee the scene, and that resulted in a gunfight took place. The person I was with started shooting at them, and they started shooting back, and the whole thing spiraled out of control way too quickly. The whole thing escalated, and it was just something I know I should have never been involved in. And there's not a day that hasn't gone by since my incarceration that I have not reflected on these things, that I have not felt completely awful about, because I know that my actions resulted in a lot of pain. It resulted in a lot of fear. And I know that my actions put other people's lives in danger, all because I was too selfish, too immature to deal with my own problems. And so I made that someone else's problems as a result. And this is something that I have endlessly thought about, that I wish more than anything that I could be able to take back and undo that kind of damage. And at this point, I'm here speaking to y'all through this application process because it was an opportunity for me to try to present myself and try to show that I have gone to great lengths to correct those behaviors, to show that there is no possibility that I would ever engage in any type of activity that would be similar in any sort of way again. All I ever want to do from now on is to try to somehow undo whatever type of damage I may have done, to try to make up for the past, to try to show that I am capable of being a responsible person, of being a reliable person, of being dependable, of being someone who is not a threat to anybody, to be a productive citizen. And
Well said. Warden Turner, what can you tell us about Mr. Astor?
Yes, ma'am. How you guys doing? Walter has been a great inmate since he's been with us. You know, we only speak on the individual that he's become now. He's been with us a little over 12 years. He's a trustee, and one of the things I commended him on earlier, he hasn't received any disciplinary write-ups during his entire incarceration. He's a pride member. He's taken advantage of the numerous opportunities and programming that DCI has had to offer. He's also received his associate's degree from Ashland. He's the assistant editor on both our magazines, Strike Low magazine. I think you guys are familiar with that. And there's also our Dixon Digest, our employee magazine. Both great magazines. So he's done everything that we've asked him here, and he's been very valuable to us as the administration at DCI.
All right, thank you, sir. So at this time, we'll hear from the folks who want to speak in support. So could we hear from your mother, Ms. Robin, as well?
I can't, I'm trying to hear you. I can't hear. Can you hear me?
Yes, ma'am, we can.
Okay. Well, everything my son said is all true. He's a very, very humbled young man, and he is speaking from his heart like I am. My son is a hard-working, dedicated young man. He will be valuable to the society. He will be upleading and encouraging for any position that he would get in as a job. As he said, he did his associates. He's working on his bachelor's degree. Would like this opportunity for y'all to consider to release my son, let him come out, and he's going to have a home to live. My house where I live, and Big Branch, which is Lacombe, Louisiana, and he has somewhere to live. And I know there would not be a problem getting him employment. But he is an upright, standing young man that made a very, very bad choice when he was very young. And he knows it. And as y'all can see, This is his first offense. My son has never, ever been in trouble with the law. He's never gotten any kind of tickets whatsoever. And he's always wherever he's worked, the companies he's worked for, the restaurants and so forth, everyone wanted to make him a manager, has made him a manager, has always wanted to upgrade him with whatever he was doing in any applicable place that he worked in. Also, even when he was 14 years old, he was in Taekwondo, and the owners and the elders that were teaching at Taekwondo, they wanted at 14 years old to make my son a leader with the young children and teach them the lessons that my son has made. But again, he was 14, so of course he was not driving. And then that's what we had to say. We can't, because as Walter said, I lost my husband, he lost his father. And then that meant I had to be mama and daddy. And we've really tried to do the best we could. And, if I failed my son in any type of way, I'm very remorseful. But I was always here. And I did always tell my children, which they were at a very, very young age when this happened. But if there's anyone who wants to speak to, I will give them counseling. They can speak to a family member, because Walter has such a huge family support to back him up. If you would speak to any family member individually, with no one hearing each other, they're all going to speak highly, upright, all good about my son, because he is a good person, and he will be a very productive young man in the society as of today. I love my son. He is a good person. If I thought my son needs to stay in there, I would honestly say that. My son, Walter Roy Aswell III.
All right. Thank you, Ms. Aswell. We appreciate your remarks. We have to move on. We'd like to hear from Sarah now. Sarah, go ahead. No, you're still muted.
Yep. Can you hear me, ma'am?
Yes.
Okay. Ma'am, I thank the board for having this hearing today for my brother, and I agree with what my brother's statement was, the warden's statement, my mother's statement, and I'm just here in support. And I do believe it is time for Walter to be released. He's completed all programs, never had a disciplinary report. He is very intelligent, and he will be of good service to the community that he will be in, to society as a whole. And he is a very, very regretful. He is going to do wonders in the community. He has goals that he would like to accomplish in our society. He'd like to be some type of motivational speaker, as well as open a small business. And I believe in all of his dreams, and he will accomplish them. As well as he got his associate's degree, he's continuing to work on his bachelor's degree. And thank y'all again for having this hearing for him and the opportunity to be released. And that's all I have to say at the moment, and I can give further statements if needed.
Okay, thank you very much. We appreciate you taking the time to speak with us today.
Yes, ma'am. Thank you.
Okay, we'd like to hear, we'll take testimony from victims, and we'd start with Zoom. If we could hear from Chad Cassard, please. You're still on Zoom, you're still muted. There you go.
I'm Chad Cassard. I appreciate y'all having me. I'm sorry I couldn't be there. I'm up at the hospital with my father. There's not a day that goes by that I don't remember April 11th. April 20th, 2011. That morning was a very stressful morning that I'll never forget. I fought in litigations For 5 years, my family's been through hell. I've been through hell. Every time I drive down Highway 26, I don't forget what happened that day. And the way I feel, he had an opportunity to go to trial. He decided to take a 25-year plea with the understanding he had no eligibility for parole or probation. And my thoughts is, I feel he should have to do that 25 years. He had an opportunity then. He had an opportunity to stop when we initially tried to stop them. Instead, they fired upon us and fled for 12 miles into another state. Then, when we disabled the vehicle, they continued to flee on foot. That's my thoughts. I think he needs to stay, but it's totally up to y'all.
Yes, sir. Thank you, Mr. Cassar. Does your wife also want to speak?
Let me see if I can get her out the room.
Okay.
Candy, they want to speak to you.
Okay. Hello.
Good morning.
Good morning.
Is there any input you want to give us on your husband's behalf in the matter of Walter Aswell?
Well, I can also just give you my perspective as his wife. And he is a father of 4 children. People make bad choices all the time, and sure, there is redemption for some. However, the actions that they took that day and decided upon, and he was there for it, could have taken him away from his 4 children, could have taken him away from us. We don't get clemency. We don't get a pardon for the events that happened that day. I literally am laying next to him when he wakes up at night, sweating down, and none of that. There is no pardon for it. Their cars look like Swiss cheese from that day. And of course they shot back because that's what they have to do. In today's age, you should not be able to go rob a bank, shoot at numerous officers who literally put the uniform on knowing what they're doing, and they're going to protect and serve. And he protected and served that day. I think the fact that he even asked for a pardon is ludicrous. He should have to serve his time. He has been
12, 13 years. 12 years.
Yeah, 12 years. It's been 12 years. Is it 13?
13 years.
13 years. It seems like yesterday, though, for us. And there is no pardon for any of us whatsoever.
Yes, ma'am. Thank you for taking the time. I know you explained where y'all are. Thank you for taking the time to speak to us. We do appreciate it.
Yes, ma'am. We appreciate y'all. Thank you.
All right. And here with us, we have Mr. Seals.
Seals, as Jazz reiterated, that day is just a nightmare back then. It had affected my life in numerous ways. Especially since that day I had to go home and tell my little kids that their daddy almost lost their life. Coming within 6 inches, I had a bullet hit me in the head. One stopped behind my head, one hit my door. Piece landed on my leg, the other piece landed in the driver's seat. They chose to do this. They could have stopped. He can't say that he was in control of the vehicle also. At any time he could have pulled over. They chose to continue to get away and continue to try to kill us. There were numerous people walking down the side street while they were shooting out the vehicle. Other cars passing, they were shooting still. No regard for anybody's life. Nobody's. He chose to take that 25 years. He knew what he was getting into as far as
far as no parole or no benefits. He agreed to that. So I don't see how, he's asking for that. He's changed everybody's life. I mean, like I said, I still do this, put my uniform on every day to go to work, protect citizens and everything. And I know what it entails, my job. However, coming that close to lose my life just for disregard, disregarding everybody's life that they try to take. Yes, I don't see how it's, possible he's asking for something. That's my thought on it. Thank y'all.
Thank you, sir. Thank you for being here today. Thank you for your service. All right, Mr. Aswell, your case has been assigned to Mr. Freeman. Would you answer his question?
Okay, Mr. Aswell, on that day, were you, high or drunk?
The morning of the incident, I had been smoking synthetic marijuana. So I was under the influence of some mind-altering substances. Yes, sir.
What kind of, treatment have you received since you've been in prison?
I have taken part in the 12-step program. I've done Alcoholics Anonymous. I've taken part in Narcotics Anonymous meetings. I've even done a Drug Dealers Anonymous meeting. I've taken substance abuse classes. Any and all mental health programs that have been offered here, sir, that I have signed up for, I've sat in on, I've taken part of, so that I could address those issues of feeling a need to take some type of substance and alter my mind state to escape reality rather than deal with it.
Did you have a firearm that day?
Yes, sir.
Okay. And you had purchased the ammunition, correct?
Yes, sir.
Okay. Did you fire your firearm?
No, sir. I didn't shoot at anybody.
But what went through your mind? You didn't think about stopping that Jeep once he went to shoot? Or you just were just.
Once the police officers got behind us and everything started getting out of control the way that it did, I was in fear that I honestly believed if I had tried to pull over or to stop in any sort of way, I was afraid that the person I was with might have shot me. I honestly did not know what to do as the incident was unfolding. I was terrified, and it doesn't justify my actions whatsoever. I do realize that. I know there's no excuse for what took place that day, and I sincerely, from the bottom of my heart, I wish more than anything I could take it back. But I was scared, and I ran.
Okay. So, you took a plea bargain, you took the 25 years and quite frankly, you got a very, very, very good deal. I mean, this could have been 25, 25, 25 consecutive instead of just 25 together. You do have opposition from the DA and the sheriff. As you noted, your mother and your sister talked on your behalf. We've heard from some of the victims. And I may repeat their names, but I just want to say that Miranda Myers was opposed, Scott Seals was opposed, Chief Shannon Lyons was opposed, Chad Cassard was opposed with his statement he gave us, and Captain Miller was opposed. So you had a lot of opposition, and I know you can't do much about that, but you did have a lot of opposition. How about write-up, Warden? Has he had any write-ups?
No, sir, Mr. Freeman, he's remained right up free on his entire incarceration.
Okay, I have no further questions.
Okay, any other questions?
I have.
All right, I don't see, Mr. Aswell, I don't see any other questions, so I think the board's prepared to vote. Mr. Freeman will be voting first.
Okay, Mr. Aswell, as I stated, you've taken a ton of classes, you've done very well, your disciplinary record is great. But to me, the bottom line is, you took a plea bargain, and to me, a very lenient plea bargain. So my vote is to deny.
Mr. Tillis?
I concur with Mr. Freeman with law enforcement opposition and victims.
Mr. Prater?
I concur, and it's just ridiculous. I think that you would even apply for this, after the shooting at the police, robbing a bank and all of that. The lady we just heard before us, she had been sentenced to 20 years for one-armed robbery when nobody was hurt, no chase, no shooting at the police or anything like that. You got a good deal. I think a good deal would be for you to serve the rest of your time.
And I do concur with my colleagues. I do appreciate that you've done well in prison. You've been an asset to the institution, and the remarks that the warden said about you, but based on the plea agreement that you agreed to and the opposition that's been expressed here today, my vote today is also to deny. Good luck to you, Mr. Aswell. That concludes our business at DCI. We're going to sign off at 10:30.
Thank you, Mr. Rod.
Man, that was wild. Can you imagine Swiss cheese cars? To have every authority figure just say, no, don't let that guy out. And the woman's case was just how she talked about that witness. Oh man. Even the judges were like, why did you even bring this before us? You just knew it was going to get flat out denied. I suppose he was smart enough to pass all his cases, but not smart enough to figure out everybody would deny him trying to get out early. And he got very lenient, so I suppose it was to be expected. He didn't look that bothered, to be fair. So, on to our next case.
It's 10:35 a.m. on Monday, February 10th, 2025. We are at DOC headquarters in Baton Rouge. Would the staff there at Angola please introduce yourself for the record?
Reginald Lamoureux, classification.
Carmen Shipley, offender records, and Warden Benoit is here. He stepped out for a moment. He'll be right back.
Okay, thank you. We got some feedback coming from somewhere.
Yeah, we got it. We cut it off.
Okay, good. Thank you. So our first case is Mr. Gladney. Good morning, sir.
Hey, good morning.
Would you introduce yourself? Tell us your name and DOC number.
James Gladney, 96496.
All right, Mr. Gladney, before we start our process, I'd like to acknowledge the folks who have joined us by Zoom in support. We have your sister, Miss Johnson, Kendrick McCurdy, your niece, John Morgan, your nephew, and another niece, Adobe Johnson. Is it Margaret Johnson, your sister? Is that your sister's name?
Ma'am.
And let's see, Margaret, Kendrick, and John will be speaking on your behalf. We'll call on them at the appropriate time. Also by Zoom in opposition, we have Joyce Walker, and Annette Sanchez, and here with us in Baton Rouge, we have Jonathan Pruitt. Jonathan and Joyce will be speaking at the appropriate time. We'll ask them to do so. Let me just read some identifying information into the record, Mr. Gladney. You're classified as a second felony offender. You're seeking a commutation of your sentence. See, you were sentenced in Bossier Parish, January of 1982 for first-degree rape and armed robbery. You received a life sentence on the rape, 40 years on the armed robbery. You have another sentencing date also in Bossier, March 2nd, 1982. First-degree rape, you received a 75-year sentence. Also armed robbery, you received first-degree rape was life, armed robbery 75 years. Those are running consecutively. So you're serving a life sentence. Mr. Gladney, is that information correct?
Yes, ma'am.
So, Mr. Gladney, before we hear from the folks that want to speak today, we want to hear from you. Why are you in prison? What led you to prison? Why have you submitted an application for commutation of your life sentence? And why do you think we ought to vote to grant your request?
Well, first of all, I'm in prison because of my crime, what I did. You know, I made some bad choices, some bad decisions that caused me to be here. I come here in 1982, and I actually thought I was, you know, I thought I was mentally I had it together. I thought I was a man mentally, you know, but mentally I found out after coming here, learning the different programs, working, learning commitment, learning what responsibility is, learning different things here that I was really a kid. You know, my understanding level was very low. I matured here in Angola, and I entered into a lot of programs that was helpful for me, you know, that helped me out. You know, I facilitate programs now as well for giving back to the community and all that, you know. But I thought I had it together before I came here. You know, before I, you know, in '82, I thought sure that I had it together, but I found out that I really was an immature kid. I grew up here in Angola. I learned a lot here. You know, I can really say that coming to Angola actually helped me because I was on a path probably to get myself killed or something like that. So I think Angola was the best thing that could happen for me. Well, I grew up here. I just, you know, that would be my statement. I like to also say that I'm truly sorry. I'm truly regretful what I did, the crimes I did, that I committed. And, you know, if it was any way that I could rewrite this book, I would rewrite it myself, you know, and I would write it where, you know, I would harm myself before I would harm anybody else. I became a Christian here as well when my mother died in 2013. And my whole insight changed. I ain't the same person that I was when I came in this gate, you know, in 1982, you know. So.
Okay. Well, thank you, sir. Mr. Warden, is the warden make it in?
Yes, ma'am.
All right. Good morning, Warden. Is there anything you can tell us about Mr. Gladney?
Well, he's a class. I'm trying to see what class trustee is. He's a class C based on his sentence. He's been here a long time, as he told you. He's no problem for us. He's taken advantage of a lot of our programs. He's got a low Tiger score. You know, he come here, I think, when he was about 22. Been here a long time. 65 now, so, you know, he's aged out. He's no problem.
Thank you, sir. We appreciate your input.
Yes,
Well, you'll hear from folks who want to speak on your behalf. And first, could we hear from your sister, Miss Margaret Johnson?
Good morning.
Morning.
My name is Margaret Johnson, and I am his sister. And what I like to say is that my brother has changed since he got there, and he has become a Christian, and I'm very proud of him. He left when I was 21, and he was 23. Excuse me. And so much has happened since he left. There's no family members left but one. He's the only brother I have. I'm the only sister. So it's just us two, and now I'm sick. And I've been diagnosed with a few things, and I'm just praying and hoping that he can come home. That was my mother's prayer, that she lived long enough for him to come home, and she didn't make it. But I'm still here, and I'm still standing strong, and I'm still trusting and believing God that those doors will and can be opened. And like I said, he left when I was young. I was 21, he was 23. I'm 63 and he's 65, and we only got each other, and I'm very sickly now. and I would love to have my brother at my side. There's so many things that we could try to catch up on, but I know we'll never live long enough to catch up on it. But I just need him home. I need him home. I need him home, and I'm just asking for mercy of the board that they would consider the time he been gone. All the family members are gone. The only thing I have is my 2 girls, and that's wearing and tearing them out. You know, so it would be nice. It would be a blessing to have him home at my side. Thank you.
Yes, ma'am. Thank you. Thank you. Miss Jakendrick McCurdy. You're still on mute.
I'm sorry. I'm Kendrick McCurdy, and I'm James Gladney's niece. I would really love for him to come home so we can get to know him. I grew up on the phone getting to know my uncle, but I want to know him in person. And I feel like he missed out on a lot of us growing up. He was locked up when I was born, so I never seen him. I only grew up with him on the phone and seen pictures of him. And I have 3 kids of my own, and I want him to be involved in their lives as well, because we need our uncle. He's the only uncle I have left. And that's all I have to say at the moment.
Yeah. Well, thank you for taking the time to speak with us. And
Thank
we
you.
also have John Morgan.
Hello, how you doing?
How are you?
I'm doing just fine.
Great. What would you like us to know?
I'd like to speak on behalf of Unc. We can really use him out. The family really needs him right now. With his wisdom, he's changed a lot, and I know he's truly sorry for what he's done. And I can feel it every time we talk. And we need another strong male out. It's mostly ladies in his family. His sister's really sick. He has his nieces, and everybody just wants him out. It's a lot of catching up and things we have to do. And I feel like that he's a better man. Like he said, he was a kid, and we all make mistakes. Things happen, and I feel like he's paid. He's done his time, and he's beat himself up enough. And me and him talk about it a lot. And he's worried about his sister. He lost most of his family since he's been down there. And he has family here that loves him, and we're going to do everything we can for him while he's out. He has places he could be, he could stay, so it would be just a positive for us if we can just get him out and just complete this family for whatever time that we have left, to get to know each other. Everybody wants to get to know him. You got kids, babies, nieces that he wants to see and get to know. And I want to do a lot with him. It's just a lot on this family, right now, and it's been torment. It's been that torture's been there for so long, and everybody is feeling it. And I just think that hey, it's time, and we love him, and we would love to have him out. And that's about it. That's all I have.
Thank you, Mr. Moore. Appreciate you taking the time to speak with us.
Thank you.
Yes, sir. Now we'll hear from those in opposition. First, could we hear from Jonathan Pruitt?
Morning, board. My name is Jonathan Pruitt. I'm Susan Annette Sanchez, youngest son. First, I would like to acknowledge that I've heard what his family has to say. However, it is my mom and I believe that true repentance, true being sorry, means accepting punishment for your actions. So that is one of the reasons why I stand with my mom against putting Gladney back home. Other thing, it's one thing to say that you have changed, but true change in the inmate could not be quantified unless he was out. So just saying he has changed while he is still incarcerated doesn't prove anything. I would also, if would forgive me for using the language term, my mom is the badass. My mom came forward after the events that happened to her on her own, and she is here again today. She's been a very strong woman, and though I was born after the events that took place, I've always known my mom to be strong, facing the trial she has gone through. However, her reaction, her demeanor, everything changed whenever she heard his name again. That is a pain that, though she has not shown it, she has carried these many, many years. And though Ms. Gladney would suggest that there's anything he could do to ease that pain, to show his atonement, that my mom and I believe that he only show his atonement by fulfilling his initial sentence.
Yes, sir. Thank you. By Zoom, we have Joyce Walker.
Good morning. My sister is a strong woman, but still she has had to live with this for so many years. She and with this coming up with Mr. Gladney, she's living it all over again. And to see her traumatized again is it breaks my heart. And she you know, when he said, you know, stuff happens, you know, what Gladney did was not like simple as stuff happens. He made that decision to rape my sister, and you know, he might be sorry now, but she's still suffering from what happened. So it's not like some, you know, it happens. Not like when you have a flat tire on the side of the road. You know, it's easy for him to do all these things behind bars. But whenever he gets into the real world, a lot has changed since he's been in prison. And he can make it behind bars, but it doesn't necessarily mean he can make it out in the real world. So I'm totally against him being out. And that's all I have to say. Thank you.
Yes, ma'am. We appreciate you taking the time to speak with us today.
Thank you.
Mr. Gladney, your case was assigned to Mr. Tillis. Would you answer any questions he may have?
Good morning, Mr. Latin. How are you?
Fine.
Good. How old were you when this crime happened?
21.
21. Were you doing drugs then, or were you on drugs?
I drank. I never did drugs.
You never did drugs? How long have you been incarcerated?
Almost 44 years.
44 years. So, did you get your GED?
I graduated from high school.
Oh, you did? Did you get any more education after then?
No,
How long did you serve in the military?
Almost 2 years.
Almost 2 years. Okay. I have no more questions.
Any questions?
Yes.
I want to, you were dishonorably discharged from the military, is that right?
Yes, ma'am.
You did some time in Leavenworth.
Yes, ma'am.
So you were on federal supervision for that offense that occurred while you were in the Marine Corps in Japan. You were released from Leavenworth in 1980 and were on supervision. And so as a result, there's still a federal detainer that's active. Is that right?
Yes, ma'am.
And then while you were in the parish jail in Bossier, there was 3 different attempted escapes.
I believe so, yeah.
All right, I don't have any other questions, Mr. Gladney, and I don't see any by my colleagues, so I think we're prepared to vote. Mr. Tillis will vote first.
Mr. Glenn, at this time, you have strong opposition from several judges, law enforcement, sheriff, DA. My vote's going to be to deny.
Mr. Prater?
My vote is to deny because of the terrible nature of the crime. There were multiple victims, and I can't do anything but deny.
Mr. Freeman?
I concur with Mr. Prater and Mr. Tiller.
And Mr. Gladney, I'm glad to hear from the ward you're doing well where you're at. Based on the very strong opposition that's in the record, what we've heard today, my vote today is going to be also to deny. So today your application's been denied.
You know you would like to hear about those escape attempts. 3 attempts in Paris prisons. Wow, that's spicy. Oh, but what got me the most was that it was multiple crimes. It wasn't just one. It was multiple. Yeah. What I would like to know about is the crime lords, mafia members. That would be interesting. But the annoying thing is you don't get to hear it all. You don't get to see the life story. But hearing about what he did. But, well, I guess he'll just have to sit in prison a long time longer. Yeah. But he was like 22. Think about that. I suppose he was old enough to know what he was doing. So, yeah, that's true. Send him pictures and postcards. At least they kept in touch with them. I think we'll move on to the next trial after that. Just trying to find the beginning. Oh, sorry. Verdict watch. Emergency. Sorry guys. I've just seen it. I'll have to go wake up TCA. And I'll have to find out where this, oh, come on. Oh, this laptop is not working for me today.
I'm going to go through these admonitions again. You're not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case till
Verdict
it's submitted
watch.
to you. You're to report promptly to the court any incident
We have the
involving
verdict.
an attempt by any person to improperly influence any member
I need
of the
to go
jury
get
or a
TCA.
juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. Now, when you get back to the hotel, you're not to deliberate. You only deliberate in that room.
Okay.
That's 11. I don't think we have Ms. Rucroft. They all left you. Okay. We'll go through this one more time. Now we're all back together. You're not to communicate with other jurors or anyone else regarding any subject connected with the trial. You're not to form or express an opinion about the case until you finally decide it. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any jury member or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. All right. Yeah, you can go with the officer. Have a good evening. We'll be in recess till 8 o'clock in the morning.
Oh no. Oh, that's the worst. No verdict. My days, after all that. Oh. Yikes. Sorry. TC is just giving me one of those looks. She was like, you got me up for this. Oh, that is so sad. Well, I guess you're all coming back to tomorrow early in the morning. Oh, sorry. I need to get rid of this. Oh, so what a day we've had. Oh, boy. Well, I guess I'm going to see you all tomorrow. Unless you have any objections. Thank you for tuning in. And make sure you like and subscribe the stream. Thank you all for coming in, especially Pickles. Keeping me company tonight. Oh, thank you, Toxic. We all need those hugs. Right. See you later, Case One. Oh boy, I'm tired. Oh, well. Isn't there an outro? I hope you don't mind if I just leave it there. Good night, everyone.